CPC. Give all the memos. Give all the memos. Day after tomorrow ಗೆ ಹಿಂದೆ 3,000 ಮೆಮೊ ಇದೆ ಕೊಡಿ. All for Monday. Any submission? Wait. Yes. ಯಾವಾಗ? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನ್ ಮೇಡಮ್? ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲಿ ಇದೆ, ಬರುತ್ತೆ ಬಿಡಿ, ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಿ. ಎಸ್. $230 ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇಲ್ವಾ? ಒಂದ್ ನಿಮಿಷ. ಕರೆಕ್ಟ್. ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಅದನ್ನ? When did you file it? At the end, is it? ಸರಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು? ಯಾವತ್ತು ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು? ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ? ಎಸ್ 230 ತಗೊಳ್ಳಿದ್ದು. ಎಲ್ಲಿದೆ ಮೆಮೊ? ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಆನ್ಸರ್ ಪೇಪರ್ ಕೊಟ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. ಎಸ್. ವೈ? Give it. 230 ತಗೊಳ್ಳಿ. ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಎಸ್. ಮೇಡಮ್ ತಗೊಳ್ಳಿ. 230. Give it Thursday or next Tuesday. Give it. No, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಸರಿ, we'll see. Thursday. ಅಲ್ಲಿ ಅವಾಗಲೇ ಹೇಳಿದೆ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ ಅಂತ. If you are again interfering, then I will not take that memo. Yes. ಓ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಎಸ್. ಗಿವ್ ದಟ್ ಎಲ್ಲೇ ಬಿಡಿ. ಏನು 230 ಎಲ್ಲ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬರುತ್ತೆ. ನಾಟ್ ಗ್ರಾಂಟೆಡ್. ಗಿವ್ ಇಟ್ ಫ್ರೈಡೆ. ಟುಮಾರೋ. ಅದೇ ನಂಬರ್ ನಂಗೆ ಗೊತ್ತಾ? ಮತ್ತೆ ಬುಧವಾರ ಅಲ್ಲ, ಗುರುವಾರ ಮಾತ್ರ ಲಿಸ್ಟ್ ಆಗೋದು. ಕೊಡಿ. ಎಸ್. Vacating ಎಲ್ಲ 9th. Give it.
My lord, is a KIDB acquisition, my lord.
Vacating ಯಾವ್ದಿದೆ ಎಲ್ಲ ಕೊಡಿ. All memos for vacating interim orders. Give it. Give it. Vacating interim order ಕೊಡಿ, ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಇಸ್ಕೊಳ್ಳಿ. Vacating interim order. ಹೌದು, vacating interim order ಹಾಕಿ. ಬ್ಯಾಕ್ ಮೆಮೊ ಯಾಕೆ? ಗಿವ್ ಇಟ್. ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕೊಡಿ. Thursday. ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಮೆಮೊ. ಇವಾಗ ಕೊಡಿ ಮೇಡಮ್. ಎಸ್. ಲ್ಯಾಂಡ್ ವಾಸ್ ಅಕ್ವೈರ್ಡ್ ಇನ್ 1952 ಕೊಡಿ. ಎಸ್. ಕರೆಕ್ಟ್ ಆಗಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಕೊಡಿ 230. ಎಷ್ಟು ಮೆಮೊ? ಏನದು? ಫ್ರೈಡೆ 4th ಸರ್. ಕೊಡಿ. ಎಸ್ ಕೊಡಿ.
My lord, KIDB, my lord. My lord, what has happened is that this converted lands, final notification has been issued in violation of the circulars, my lord. And my lord, I already have a development plan. I have third party rights with my purchasers. My lord, the delay is causing some
pending ಇದೆಯಾ?
Please, my lord.
ಕೊಡಿ. ಎಸ್.
Lord, may I request
my lord, give it. It will come Tuesdays and Thursdays according to seniority.
My lord, writ petition by judgment debtor, arrest warrant is issued.
ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
Miscellaneous petition is pending before the same court. It's an ex parte judgment. 230.
230. Date given. Give it.
My lord,
Land acquisition matter, 2013 matter. This remanded matter. Next week.
My lord, an application, my lord, for impleading has been rejected.
Old in the.
My lord,
Bharat
now, my lord,
seniority
on 10/7, my lord, it is posted for judgment, my lord, at least, my lord, Friday, my lord.
7th, Monday.
7th.
I am a tenant, my lords. There is a threat of disposition, my lords.
ಹೊಸದುರ್ಗ
ಇಲ್ಲ
ಮ್ಯಾಟ್ರ್.
ಸ್ಟೇ ಮಾಡೋದು
ಏನ್ ಹೊಸದುರ್ಗ ಮ್ಯಾಟ್ರ್ ಅಂದ್ರೆ
ಇಲ್ಲ ಸ್ಟೇ ಆನ್ ಇಸ್ ಅ ಪಾರ್ಟಿಷನ್ ಸೂಟ್
ಏನ್ ಬೇಕೀಗ?
I have to get a stay order on that IA lordship. 3 or 4 memos have been moved.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಕೊಡಿ.
Lordship, CRP matters, Lordship, 230.
Submission, madam. I am in position as last 20 years, my lord. Respondents are necessary in detail. Friday is going to be judgment, my lord. Kindly to come here tomorrow, my lord.
Tomorrow, yes.
Please,
CRP on admission here.
tomorrow.
Thursday again, sir.
ಗೊತ್ತಿಲ್ಲ, ನೋಡೋಣ. Thursday or next Thursday.
My lords, I am a tenant, my lords.
Lordship, the petitioner is a Residents Welfare Association of Defence Officers. They are seeking for refund of past 15 years, my lords. The pending matter, my lords. We take it on Tuesday, my lord.
Give it, yes. Give the memo, sir. Pending matters will come only according to seniority.
482 petition law, the successive petitions against the in-laws.
ಜೋರಾಗಿ ಹೇಳಿ sir.
The 482 petition law, successive. And
Friday.
lots, the date is there on
This is
next
Friday,
month.
sir.
Please.
Thursday. 2:30.
My lords,
2:30 ಬೇಡವಾ?
fresh matter, my lords.
Give it.
My lords, I am a tenant, my lords, and delivery warrant has been issued against me, my lords. Tomorrow, my lords,
How long are you squatting over the property
my lords,
without paying rent?
my lords, there was a compromise, my lords, and this execution petition is, I have been paying rent, my lords. This execution petition is premature to the date contemplated in compromise.
Yes,
Tomorrow, my lords.
tomorrow. Monday.
Fresh matter, GMCPC.
Monday ಕೊಡಿ ಎಲ್ಲ.
There is a delivery.
All GMCPC matters, give it
There is a delivery warrant, my lord, tomorrow, my lord.
tomorrow. Delivery warrant ಇರೋದು ಮಾತ್ರ tomorrow.
Tomorrow.
My lordship is order is stay, respondent number 3, order is stay,
Order stay.
stay the order,
ಏನ್ ಬೇಕು ಸರ್?
order stay ಮಾಡ್ಬೇಕಾಯ್ತು ಅದಕ್ಕೆ.
ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡ್ಬೇಕಾಯ್ತಾ? ಈಗ ಆಗಲ್ಲ. ಸೋಮವಾರ.
My lords.
ಮ್ಯಾಟ್ರ್ ಅದು?
Monday, ಇಲ್ಲ, fresh matter ಅಲ್ಲ, pending,
ಹ?
pending.
ಪೆಂಡಿಂಗ್ ಅದು ಸೀನಿಯಾರಿಟಿ
My
ಪ್ರಕಾರ.
lords.
CPC fresh matter, my lord.
Give it.
This is the fresh matter, my lords.
Fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lords, further hearing matter.
That will come. Further hearing we are posting it, right sir?
But the urgency is that, my lords, there is a threat of disposition. The respondents have obtained a collusive decree.
Hmm.
And they have not made me a party before the civil court. I am the original owner of the two scheduled property. So with respect to, my lords, they are trying to dispose of it.
Friday.
Your lordship.
This matter is to be listed along with another matter, that's all.
ಯಾವ್ದು ಅದರ್ ಮ್ಯಾಟರ್?
GMCPC along with CMP, my lord.
Along with
Along with CMP, both the matters are arising. out of-
CMP
Yes,
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸರ್. ಎಸ್, ಮೂವ್ ದಿ CMP ಕೋರ್ಟ್. ಈಗ ಮೂವ್ ಮಾಡಿದ್ ನೀವು CMP ಮ್ಯಾಟರ್ ಸರ್.
ಅಲ್ಲ, GMCPC, my
Your
lord.
lordship.
This is to be
CMCPC
listed.
ಆದ್ರೆ ಕೊಡಿ. CMP is not before
GMCPC,
this
my
court.
lord.
All the matters will go to the CMP court.
Yes.
ಅದೇ ಬೇಕಾ ನಿಮ್ಗೆ? ಕೊಡಿ.
GMCPC, let it go to the CMP or that may
It
come
won't
to
go
this.
like that sir. CMP is senior judge, it will go there only.
Yes, my lord. Yes.
ಹಾ ತಗೊಳ್ಳಿ. ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ. Move the CMP first
My lords. He's
and draw the
But
CPC
in
to
fact,
that.
I am told the same thing in that court, my lord. That is the reason, my lord.
All right, ಕೊಡಿ.
Grateful, my lord.
ಮೇಡಮ್ ಅದು CMP ಜೊತೆ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ, ಇಲ್ಲಿ ಪೋಸ್ಟೇ ಮಾಡಿಸ್ಬೇಡಿ ಇಲ್ಲ ಮುಂದೆ.
My lords, he's in custody for the past 2 years.
ಯಾರು?
Breach of promise of marriage.
Custody, breach of promise of marriage ಅಲ್ಲ?
Yes, my lords.
Take that day after tomorrow, madam.
Your lordship, fresh matter, my lord.
See, successive rate. Huh?
Further hearing.
Further hearing, on Friday.
My lords, custody is his mother.
Custody ಇದ್ದಾರ? ಇರ್ಲಿ ಬಿಡಿ.
My lords.
ತೊಂದ್ರೆ
Mother
next
is-
Friday.
is the sole breadwinner.
Before doing all that, he should have known.
Another case is registered. For his wrongdoings, another case is registered. This case is, there is genuine
ಆಯ್ತು.
legal ground.
ಆಯ್ತು.
Your lordship,
List on 11th.
fresh matter, my lordship. Kindly have.
Give it, sir.
2:30.
2:30? Why?
Yes, my lordship. Matter is posted for judgment tomorrow, my lordship. before the
Judgment.
trial court.
Yeah, what is the order you're challenging?
In the OS number,
ಅರೆ ಯಾವ್ದು ಡೇಟ್, ಆರ್ಡರ್ ಡೇಟ್ ಏನು?
6/8/2000, sorry, 8/6/2025, my lordship.
ಕೊಡಿ, 2:30. Yes.
Third, after completion of evidence, the application was filed for appointment of court commissioner. That on 26th, the application was rejected. Today it is posted for argument, my lord.
ಕರೆಕ್ಟ್ ಆಗಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
My lord, after,
ಏನು ತೊಂದ್ರೆ?
ಇಲ್ಲ.
ಐ ವಿಲ್ ಆಲ್ಸೋ ರಿಜೆಕ್ಟ್ ಇಟ್. 2:30 ಬೇಕಾ?
ಹೌದು,
ಕೊಡಿ, ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
rejected.
Lordships, kindly on the CPC matter.
Give it.
No, because it's a
Monday, sir.
2/5 Monday.
Monday or Wednesday, it will come on
Monday.
senior. Let's call the cases. Being spoken to account.
Being spoken to still number 1.
Why being spoken to? Who has moved?
There's a clerical error. The order uploaded on the High Court website, it says about a different case, the order which has been uploaded on online.
Ah.
It talks about partition. My case is regarding to declaration. We have not sought for any, my case is regarding to the rejection of my clubbing application.
ನಿಮ್ ಮೆಮೊ ಏನ್ ಹಾಕಿದ್ರಿ ಮೇಡಮ್?
Memo being spoken for correction
ಅಲ್ಲ
of
ಇದಲ್ಲ.
that.
At length would seek liberty to file an application for transfer of suits
No,
to
no,
be
I have
held
not
together.
filed any such memo, my lord.
No, while making the submission.
No, I have not made such submission. The thing is, the opposite counsel was also very much present. I told there was 18 cases
Correct.
which was pending for adjudication, where the plaintiff is a common plaintiff.
Correct.
And the evidence, the averments in the plaint is a common, the defendants are different. And the plaintiff who claims the title is the one consolidated property.
Now,
not
what is,
the-
you made the submission, would submit that seek liberty to file an application.
It is in the same court, my lord. So all the 18 cases are before the same court.
Get the JY diary, stenographer's diary corrected. Let me see what I've dictated.
Very,
If that is what I've dictated in your presence, then I will not change.
very well.
Orders, still number 2.
The name of JC Kumar may be deleted.
Who is on record now?
Now I give the NOC, permitted to retire.
Anup Harnalli is on record.
Please.
Registry to delete the name of JC Kumar as appearing for the petitioner in the light of Anup Harnalli entering appearance for the petitioner.
Date may be fixed.
2016 matter will fix a date. List the matter next Tuesday
Much of.
in
Obliged.
preliminary hearing. Yes, next.
3.
I then ನಿನ್ನೆಯಿಂದ 3 ದಿವಸ ಮೂವ್ ಮಾಡ್ತಿದಾರಲ್ಲ, what is the urgency?
Now the university is not carrying out the local inspection. For the academic year, we will be losing the admissions. This annexure A is passed by the government of India on the basis of the report of some other college. This court granted an interim order staying that order, and then admissions are going on. Annual inspections are conducted by the Rajiv Gandhi University.
Correct.
We have paid the fees. And all the dental college inspections are done. Our college inspection is not done. Therefore, I have filed this application long back. Otherwise, we will lose admission this year also.
Yes, Ramesh. sir.
Rajiv Gandhi University is.
RGHS ಯಾರು? Inspection committee ಅವ್ರದೇ ಅಲ್ವಾ? LSC.
Permission.
Who are you?
I appear for the Dental Council of India.
Madam
Can
is
I
for Union
draw
of
your
India.
lordship's attention to
Union
the-
of India.
No, I'm Union of India.
Ministry of Health.
My lords, may I just draw your lordship's attention to the order dated 12/3/2025 minutes. Now, my lords, the difficulty with this college, my lords, since 2019 is there are, my lords, grave infrastructural deficiencies, my lords. An ex parte order of stay, my lords, is passed in 2023, my lords, pursuant to which.
No,
my lords,
there's a direction to conduct joint inspection. What happened?
that is by the DCI. We have conducted it, my lords, and we've also placed it on the file of the court, my lords. Your lordships
Alright.
will see my memo dated 25th of June, my lords.
Yes.
Now, during the pendency of this particular inspection from the month of March till now, my lords, they make an application for local inspection as early as December 2024. They don't agitate that issue till today, my lords. They now come up with an application saying that local inspection has to be carried out. That's one aspect of the matter. But the difficulty is, my lords, I as an apex body, my lords, on 3 occasions have basically recommended that the college should shut down, my lords. The mechanism for it, my lords, is that I send the report to the central government takes a decision. My lords. Central government takes a decision to 2023. They come before this court.
Oh, takes a decision to shut down.
Yes.
All right.
On 2 occasions, my lords.
All right.
An order of ex parte interim stay is, my lords, passed. And if I show your lordships that order, my lords, the true facts have not been placed before your lordships.
Which ex parte what?
My lords, your lordships will see the order dated 13 December. my lords.
If my learned friend is arguing on merits, I will argue on the merits.
ಇಲ್ಲ,
of
on the
case.
direction ಅಂತ ಹೇಳಿದ್ರ.
Now I have sought direction against the Rajiv Gandhi University. They have conducted the inspection on the direction of this honorable court.
Correct, the report is
all
here.
the earlier reports are found to be false in the present report.
Found to be false?
Yes.
Where is that report?
That come, your lordship, they have submitted the report, my lord.
Now, who represents Rajiv Gandhi University?
My lords, Rajiv
My learned
Gandhi
friend is
University-
arguing as if, my lord, he
My lords, may
contradicts
I,
his own report
my lords, I have
earlier.
been very fair, my lords.
You are
If I may
for the
just
fourth
please-
respondent, is it?
I am for the second respondent, my lords. I am the apex body, my lords. The larger issue is, my lords, that we have recommended.
Now, who is appearing for Rajiv Gandhi?
My lords, that would be Farah, I think, my lords, on the last date she was here.
Who?
Farah Fatima, my lords.
Where is she? Where is the report now? Tell me.
Milord, the report is produced, Milord, along with this, Milord.
By way
Now,
of
I'll just take your
amendments.
lordships, Milord, kindly come to the writ petition, Milord, for a minute. Milord, for the academic year 2022, the inspection was conducted by the DCI, annexure F, page 46, Milord. Annexure F, page 46, writ petition. Milord.
Writ petition.
Yes. Milord, they found.
Where is Farah? RGHS. I would have granted the order now.
My apologies, Mr.
Yes. Page.
Milord, page 46, Milord.
That's copy, they've not served me for this
Of what copy?
application.
No, copy served on them and filed.
I'm not on me, Milas, I'm sorry. In fact, I was requesting my learned friend to give a copy.
Why have not served the copy?
Milord, served and filed, Milord.
Served and
Lordships
filed.
will kindly see.
Not to me, Milas, maybe other respondents.
The one who
I
has
have
to,
served on everybody
the
has.
one who has to conduct inspection, you have not served the copy at all.
Milord, all the persons you have said, including the DCI, everybody.
No,
has
Kodi.
served. I'll give the copy.
Give
today,
another
right now.
copy. I'll take it on Thursday.
Please.
Yes, list on Thursday in preliminary hearing.
My lords, may I request for a date, my lords, on the 10th of
Thursday is
July?
the date.
I will also seek for some more
But on the-
instructions from the
one- just only
DCI,
one
so we
minute.
can give it a closure, my lords. I mean,
We-
from December till now, my lords, they've not expressed urgency. They've only now preferred an
Admission time
application.
urgency.
My lords, 10th of July, my lords.
In a
that's my
college
only
that has
request.
been directed to be shut down, not once but
This
twice.
college is established in 1992, Milord.
Ah,
Now the inspection is conducted in 2022. They have found two deficiencies, Milord. One,
No, my
there
lords.
is a deficiency of mobile dental van. And then Milord, circular saw is not there in the orthodontics department.
those are the only two
Those
deficiencies?
two deficiencies.
No, my lords.
Sudden,
My
one
lords,
second.
So for
sir.
those two deficiencies, anybody would
No, in
direct
fact,
shutting down of the
then
college?
They issue a notice, we submitted a compliance report. They issue a notice stating that there are deficiencies of the college. They attach the deficiency of a college of called the name of the college is Milord, Baba Jaswant Singh Dental College, Hospital and Research.
ಯಾವ್ದು ಫರೂಕಿ ಅಂತಿದೆ?
No, in fact, the basis of passing this
Print out
order
minutes.
is the report of the other college, Ludhiana College, Milord.
ಅದು ನಿಮ್ದೇನಾ?
Yeah, no, it's not ours.
That is
So
not
that is the
case, my
reason
lords.
why this court passed an order considering that, Milord, on the basis of report of some other dental college, this order is passed. And Milord,
May I
subsequently,
respond, my lords? I'll respond once, my
What
lord.
you have done root
Kindly
canal to
see,
some
Milord,
other
your
patient?
annex-
My lords,
H, my lord,
prima
their own
facie,
document.
from their own documents, my lords, I will demonstrate how this communication, my lords, is manufactured at the time of filing the petition, in my understanding. There is not one document which evidences, be it a postal receipt, that they have sent any communication saying we have
Milord,
not.
annexure, yes, may
supplied.
kindly be seen
And my
for a
lords, your
minute.
lordships will come to page 116. They have replied to the notice, they've
No,
replied
that
to the
is
inspection
subsequently,
report.
Milord.
How is it?
Subsequently,
We'll hear it the whole hog.
please, Milord.
Yes.
My lords, may I request for a date on the 10th of July? I will get
All
some
right,
more
no
instructions.
problem. List the matter on
Till then, let them
admission.
carry out the
When
inspection.
is the admission?
Milord, admissions, Milord, September.
When is the admission?
Milord, now we have
September.
to carry out local inspection.
September
Place
they have
it before
admission, sir.
syndicate, Milord, and then they have to send it to the KEA. Milord, it should come in the seat matrix, Milord. Then the entire purpose.
I'm asking
Milord,
you, when is the
Milord, when there is an
When
interim.
is the next academic year? Sir?
Milord, say academic year will get closed September 2025. Milord.
Yes, we'll hear it, yes.
Let-
Then you should
let
have
them
moved the
inspect,
matter
Milord.
early in January or
Milord, I'm
February. and
only
got-
saying, Milord, let them inspect, Milord. Let them not take any decision on the local inspection committee.
Yes.
I have paid the process,
Yes, Farah.
the inspection fee.
Let it come up next week.
Inspection.
I've not been served with a copy, I have no instructions on inspection.
Copy serve ಮಾಡಿದ್ರೆ
I don't know. Milord.
without instruction, she will not accept inspection.
Milord, I'll serve it today at 2:30. You like to last.
10th
I'll
of
serve
July,
it
my
right
lords.
now,
Serve
Milord.
it, sir, serve it,
10th
yes.
of July.
Milord, this is the only college where, Milord, they have not inspected because the matter is pending before this court. Milord, 23, 24 they inspected, 24, 25 they inspected.
On the application, I will hear it on Friday.
My lords,
On the application.
No, the difficulty is this, my lords. Now local inspection will happen. My lords.
On the application, I will hear it on Friday. Are you inspecting?
My lords, we
Are
have,
you inspecting?
no, my lords, it would be RTO.
wait.
And I do not know why Dental Council of India is so keen to shut down.
Lords, I am the
Dental
apex
college
body.
was established
They
in
don't,
92,
my lords,
my lord.
conduct the college in terms of the regulations. They
already
expect
closed
me to
for
keep
1 year
quiet,
in
my lords.
2019.
They impugn my inspection report and they expect me not to respond. my lords.
My lord,
How-
I will point
I mean,
out
how-
from their own record, my
Lords,
lord,
we
on the
will point
basis
out
of
as well,
report
my
of
lords.
Vidyana College, they recommend to the central government for withdrawal of the recognition given under section 60 of Dental Council
Lords,
of
that
India.
is not the case, my lords.
They
I
are
will also
thoroughly
point out
exposed.
from their own
Central
documents.
government is asked to file affidavit. my lord.
They were given
I have
two
not filed any
opportunities of
affidavit.
hearing, my
ಅವ್ರಿಗೆ
lords, and
ಹೇಳಕ್
they
ಬಿಟ್ರೆ
refused.
ಏನಾದ್ರು ಕೇಳ್ಬೋದು.
Please.
There must be some courtesy, my lord. The allegation against the Union of India is that they were not given opportunity of hearing. They were given 2 opportunities which they did not avail.
We'll hear it
both are-
only on the application.
Please,
Yes, on Friday, list on Friday in preliminary hearing.
please. Interim order is to extend, your lordship.
Interim order ಇದೆಯಾ?
Literally, your lordship granted after
But
hearing.
it's a stay on
my
our order for
The
withdrawal of
court has
recognition.
granted in interim order.
What interim
staying
order?
Annexure A, my lord, prohibiting us
September,
to
my lords.
make admissions.
Interim order subsisting shall continue till the next date of hearing.
Please.
Please, my lords, very good.
Number 4. The petitioner on this matter. My lords, your lordships have taken this matter up several times. The respondent's counsel is not appearing. My lords, on the last date, your lordships have passed an order voting his absence that the matter would be heard today.
Yes, madam, ಹೇಳಿ.
My lords, your lordships will see this is a writ petition challenging.
NTI housing,
Pardon?
NTI housing,
Yes.
yes.
This is a writ petition challenging the order of the Assistant Commissioner and the Deputy Commissioner mutating the RTC in the name of the landowner after the land has been acquired. You know, the land is survey number 165/2, measuring 29 guntas in Kurgehalli village. It was acquired in favor of the NTI Society, 4-1 notification in 1985, Annexure D, page 30. 6-1.
What is the date of the impugned order?
Manoj, the date of the impugned order is by the Assistant Commissioner in
Yes.
2016 and by the Deputy Commissioner in 2023.
How did they do it?
On
Yes,
the
government. Acquisition final ಆಗಿರೋದ್ರಲ್ಲಿ mutation ಅವ್ರಿಗೆ ಹೆಂಗ್ land owner ಹೋಗುತ್ತೆ?
Manoj, they rely on a writ petition order
Which is that?
which has since been recalled, Manoj.
Page,
Manoj, they have relied on the writ petition order at annexure.
first take me to the writ petition order, madam.
Please, Manoj,
Which is that? That is 2009,
please. 2009
annexure T, page
annexure-
78.
Please, Manoj.
Ah,
On the basis of this writ petition order, where the landowners were directed to be heard,
ah.
the AC and the DC rely on this, whereas in fact at annexure U, it has been recalled since.
Which is that, where is that recalling order?
Your lordships will find it at page 108.
108.
Please, my lords.
Recall ಮಾಡಿದ್ದ ಇದು.
Please, my lords, para 25. At page 108.
Now, first, which is the writ petition order?
My
Oh,
lords, the
this, it's a
annexure
short
T,
order. Yes, yes.
3-2.
This is recalled in 2019.
Please, my lords.
Yes.
On that basis, the AC passes the impugned order, which is confirmed by the DC. Your lordships will find it at page
No,
25.
is it that after the initial order by Justice B.S. Patil,
Please, my lords.
the AC and DC have passed orders?
Please, my lords.
Those are impugned in this petition on the ground that those orders have been recalled.
No, no. On the ground that the landowner's possession has
Correct.
been
That is
fortified.
on the ground that the earlier order on which the mutation entries were changed has since been recalled. Justice
No.
Narendra's order.
Manoj, there initially the land was ordered to be dropped. We challenged it. Then the landowner, that was annulled. Then the landowners challenged it saying we were not heard. That was the order at annexure T, where they said you hear the landowners.
All right.
Thereafter, my lords, it's been recalled in 2019.
That
Then-
order, that is what, that order is recalled.
Yes, the order on which the DC places reliance has been recalled. That is at page 25 of the impugned order.
Hmm.
Your lordships will see the reliance is placed on order dated 6/7/2009 and 32641 of 2002.
Page, madam.
Page 25, running page 25.
Writ petition is allowed, so and so. ಆದೇಶ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಪುನರ್ ಪರಿಶೀಲನೆ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಿ ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಿದೆ ಅಂತಿದೆ. Page 26.
Please, my lords. He relies on this order.
No, true. ಉತ್ತರ ಹೋಬಳಿ ಗ್ರಾಮದ so and so ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವ ಪುನರ್ ಪರಿಶೀಲನೆ ರಿವ್ಯೂ ಹಾಕಿದ್ರ?
RP, before that is.
This is before the DC.
Yes.
Yes. You had filed review.
I had filed it. The petitioner here
Yes,
is the
yes,
review
yes.
petitioner.
Where is the original order, AC's order?
Your lordship will find the
28.
AC's order at annexure B, page 27.
This is based upon,
This is a short order, my lords. This does not make any reference to
this
the
does not make any reference to any order.
Yes.
But the DC's order while rejecting the
Review
review
places reliance
refers
on
to
an
Justice
order
B.S. Patil's order.
that is recalled. And that writ is pending now along with the other writ. My lords, the allottees.
True, but then matter should go back to the DC.
My lord, the land is already acquired. The RTC was standing in the name of the society. It has been now commutated in the name of the landowner.
Correct, I got what you said.
My lord, the
But
landowner.
if you are on that ground that the order on which the DC rejects the order has been recalled,
My lords, I'm on two
we'll have to
grounds.
set aside that order, but
I'm-
what happens to the AC's order then?
I've challenged both.
You've challenged
I've
both.
challenged both. My lords, I'm on two grounds. One is, first of all, acquisition has attained finality. Their challenge, the landowner's challenge to the acquisition has been dismissed and confirmed right up to the Supreme Court. So therefore, they do not get any independent right. Secondly, my lords, even the order that he places reliance on does not restore possession to them so as to mutate the RTCs in their name.
Which order does the AC place reliance upon?
Annexure T, my lords, 32641 of 2002, which said here the landowners, before taking any action, annulling the dropping of the
Where
land.
does he make reference to that?
My lords, your lordships will find it at page 25,
25 is DC's order.
DC's order.
DC makes reference,
Yes,
no doubt.
DC's
I'm talking
order-
of the AC.
My lords, the
DC order will go, no doubt.
The infirmity in the AC's order is, first of all, my lords, kindly see, it's not even a reasoned order. Secondly, the aspects of the acquisition are not even taken note of.
Change of kata on the basis of inheritance, but the respondent authority hence appeal. What order do you pass? Government?
My lord, I accept that, my lord, but the interesting person is the owner, my lord. Despite that, my lord, what we have acquired is at page number 20, page number 54 may be turned, my lord, wherein the acquired portion was in the said survey number 165/1 and to 165/5. It is 4 acres 16 guntas, my lord. Page number 54, in page 3, my lord. That was subsequent, the total extent acquired in 165/1 to 165/5. Serial number 36, my lord. That is 4 acres 16 guntas, my lord. It was also, portion was also given, like that it is. Subsequently, it was amended at page number 51, my lord. 2 acres 3 guntas was amended, my lord, at serial number 2, my lord. 2-3, it was amended, my lord. So to substantiate that, the exact amount of what was acquired and what was given portion, I have to verify, my lord, with respect to only that part. Here, only
No,
160.
the possession was handed over in 1991.
The government has admitted that.
And
before this
matter
order.
goes up to the Supreme Court, everything is over. Now, how can you mutate the names in the, mutate the names of the landowners
There will be
whose
remaining land
lands have been acquired? Remaining land anta ellide?
ಇಲ್ಲ
AC order ellide?
ಇಲ್ಲ ರೀ ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅದಕ್ಕೆ 165/2 ನಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಅಂತ ಹೇಳಿ that has to be verified.
My lords,
Maybe
Both-
remanded back to
Both the orders
DC.
should go.
Yes.
my lords, my humble submission is there is no question of a remand. If your lordships were to accept the argument of acquisition has attained finality. There is
No,
no
no.
doubt about that. The
What
RTC.
he is saying is, what the government is saying is, there is a modification or amendment to the acquisition. 4 acres 16 guntas is now reduced to 2 acres 16 guntas.
3 guntas.
2 acres 3 guntas. What happens to the remaining?
Lords,
remaining
that is not a correct
The
submission.
remaining submission, the remaining extent is what they are claiming. If they are claiming that, then
My lords,
And
when.
I am not saying that is only bar 2 is claiming, it's bar 1, bar 3, bar
we'll
4.
set aside
Lords,
both the orders.
That contention.
Now DC's order will go because of
That
his
contention
reliance.
the government cannot take because kindly see annexure R page 73
Hmm.
concerning the same land. The learned at page 75.
Yes.
Kindly see the landowners, my lords. Same parcel of land Ramanjunappa is at serial number 874. Page 74.
All
Kindly
right.
see the order at 75.
Dismissed as not
Learned
correct.
government advocate appearing for the first respondent has filed a memo stating that the government has handed over possession of the lands to the petitioner. Petitioner submits that in view of the memo, he does not press the writ petition.
Yes, ma'am. That is not disputed, ma'am.
So, my lords, then where is the question of saying they don't know which land, etc., when they
It's-
have
it's only
admitted
amendment.
categorically?
Amendment of.
Now, where is the,
annexure-
Order dated
where is the order handing over possession?
My lord,
At annexure
the
J, madam.
memorandum of
J page
OM,
54
my lords,
itself.
at 51192 at page 52.
What are the lands handed over?
My lords, your lordship will find that at page
52, right?
54.
55.
54, serial
54.
number 36.
36.
This is, no, right.
165 bar 1 to 165 bar 5, 4 acres,
11,
16
19.
guntas.
That you just now
That I have
showed.
just- That
and
was
my lord,
amended in
16 to
1907, my lord.
16.
Now,
to
madam,
was
5,
also-
this is 5/11/1992.
Yes. Then the RTCs were standing in the name of the society at page 58 and 59. There was no dispute at that time. The government did not take up any such contention. Even today, they have not filed statement of objections, just an oral submission.
My lord, that was amended at page number 51, my lord, what I have showed. Page number
No,
51.
you'll have to file something if that is there.
My lord,
you
that was
can't be-
amendment notification in 97, my lord.
You
97.
can't be submitting this orally. You'll have to submit
My lords,
something on record.
kindly also see, my lords, in 1999, at the request of the landowner, the lands were sought to be dropped. The society questioned that. That was the order in which this
No, everything
memo
is
was
fine.
filed.
I want to know the extent of land that was handed over to the society.
The entire, my lords, here your lordships are concerned with 29 guntas and 165 bar 2.
Yes,
And the landowner, my lords, has at several times come up before this court vis-a-vis this extent, and he has lost. So therefore, his extent is the same extent here. He is not claiming for a
now,
balance extent.
4 acre 16 guntas is what is handed over to you?
165 bar 1 to 5. This is 165 bar 2, 29 guntas.
The whole 165 consists of 4 acres,
My lord,
35 guntas.
165 cannot be treated as one entity when it's folded as 165 bar 1 to 5. Each sub-survey number has a distinct entity with an extent of its own. These landowners are concerned with 165 bar 2 measuring 29 guntas. There's no dispute in our mind on the landowner's
Yes.
mind. They've come to court categorically with that case even at annexure P. And then the acquisition
65
also, my
bar
lord,
2,
at
29
Page number
guntas.
58 may be turned, my lord.
65 bar 1 to bar 5.
Once,
4 acre 16 guntas.
my lord, page number 58 may be turned, my lord.
Why do you create this confusion?
Yeah, that I have to take the
That,
exact
my lord,
extent.
in
what has
any
been-
event,
what has-
the AC has not said there is balance
total
land. We need to find out.
No, that is what order of the AC is bad. We can,
Yes.
we can
And
set it
DC
aside,
is
send
worst.
it back. But if no remand is necessary, his objections would be necessary. You file your objections.
My lord, now
The
there's
extent
also-
I will mention, my lord.
Yes.
My lord, the
Extent
other-
ಅಷ್ಟೇ, see, to remaining 29 guntas land ಇತ್ತ ಅಂತ ಎಲ್ಲಿದೆ, where is it?
ಅದು ಗೊತ್ತಿಲ್ಲ. I will just take the instruction.
You
I will
get-
file, my lord.
My
One
lord,
statement.
also secondly, the layout plan has sites. The allottees have been allotted the sites. They have filed
If
injunction
there is an
suits.
intermodal operating in your
Yes,
favor.
there are injunction suits filed by the allottees for sites formed in
Only
this
disturbance-
extent.
No, the
where
only
injunction
problem is
granted.
he is not
extent.
present and he does not have complete
The
information.
lordships have seen over the last 4 days.
They
he's
did not
been
come,
present.
correct, yes. The learned,
Extent of land, my lord.
heard the learned counsel, Nayantara appearing for the petitioner. The learned counsel for the respondent, second respondent Karthik has been absent on the 5th occasion today. Therefore, this court had already observed that the matter would be heard and appropriate orders would be passed. The learned counsel for the petitioner takes this court through the documents appended to the petition, seeking to demonstrate that the order of both the assistant commissioner and the deputy commissioner suffer from illegality, illegality and need not be remitted back to the hands, their respective hands, to pass necessary orders in accordance with law. The learned counsel for the learned HCGP would submit the only issue is with regard to 160 survey number 165 bar 2, which is 29 guntas of land. What is handed over to the petitioner according to the learned HCGP is 4 acre 16 guntas from 165/1 to 165/5. If it is 4 acre 16 guntas, the entire extent that is acquired is 4 acre 35 guntas, is what he says. And remaining 29 guntas, instructions has to be sought whether it was left over or otherwise. The learned counsel for the petitioner submits that was not the order of the AC nor the petitioners at any point in time had contended that land in 29 guntas had been left over pursuant to the acquisition. Therefore, change of mutation entries after acquisition is a procedure that is not tenable in law.
Especially when it was standing in the name of the society.
More so in the light of the fact that the land stands in the name of the society. The learned HCGP is given a week's time to steer clear the controversy, seeking instruction or filing his objections as the case would be, failing which the petition would be disposed. Is list on next Tuesday.
My lords, the entire extent is also available in the RTC, my lords, for the
Correct,
government to
RTC
take
4
a
acre,
stance
35
of
guntas.
land that
4
they
acre
have
35
acquired.
guntas, 29 gunte ಎಲ್ಲಿ ಬಂತು ಮತ್ತೆ ಆಮೇಲೆ?
4 acre 35 guntas and the given is 4 acres 15 guntas that was subsequently 4 acre 16 guntas that was subsequently amended in 1999 to 2 acres 3 guntas.
Does not stand to reason at all. Anyway, list on Tuesday next. Yes.
Very well. I'm
Still
waiting.
16 guntas andrunu alli
Does not stand to reason. We'll see.
29
Yes.
guntas.
My lords, that the acquisition has been upheld. They did not
That
stand
is not-
outside of the
that is not
acquisition
disputed.
saying our,
Yes, yes, anyway.
my lords, very unfair for the government to take the stance anyway. I'll controvert it.
Next Tuesday.
Very well.
Tuesday,
I'm
Tuesday,
waiting.
yes.
5,
Steps to be taken in deceased R2.
For weeks time.
A week's time to do the needful.
Interim order.
Interim order subsisting shall continue to the next date of hearing. In the event needful is not done, the interim order would stand automatically vacated.
2 weeks. 2 weeks.
2 weeks. Rectification of office objections.
The matter is settled between the parties, my lords.
Settled, huh?
Settled, my lords.
Some 81 suit, one item is settled.
Oh, anyway. Learned counsel for the petitioner submits that the subject petition is rendered infructuous in the light of
My lords, it wouldn't be infructuous, my lords. We want it to be, because I
Compromise
filed an
petition
impleading
we have
application.
filed, my lord.
It's
only
my
one
lords,
item, huh?
One item, my lords, in FDP proceedings. I have filed an impleading application which was rejected, my lords, in the trial court. In
All right.
FDP proceedings.
All right.
Challenging that, my lords, I've come before this court. I have to report the settlement before the FDP court, my lords. So my WP has to be allowed. and
Then
I'll
we'll
propose
allow
it.
it and send it back.
Yes, my lords.
The petitioner is before this court calling in question an order dated 29/7/2024 rejecting an application filed under Order 1 Rule 10 or 2197.
My lords.
Order 1 Rule 10, is it?
Yes, my lords.
Order 1 Rule 10 of the CPC seeking to implead himself as a party respondent in FDP 2 of 1989. The learned counsel for the parties would now submit that the settlement is arrived at between the petitioner and the respondents, and the same has to be reported before the concerned court.
File the compromise petition before your lordships, my lord.
Settlement has been arrived at between the parties by drawing up terms of compromise on 21/5/2024. In that light, the petitioner becomes a necessary party to place the settlement and get the terms of settlement recorded by the concerned court. In the light of the settlement being arrived at between the parties, I deem it appropriate to allow the petition, set aside the order dated so and so, rejecting the application under Order Rule 10 for the purpose of the petitioners, for the purpose of petitioner placing the settlement before the concerned court and the concerned court taking note of the same and passing necessary orders in accordance with law. ಇನ್ನೇನ್ ಬೇಕಾ?
Such ಇಲ್ಲ ಅದರಲ್ಲಿ ಒಂದು ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ for R1 and
IA1 of 25 be allowed, my lord. First respondent died. Two
ಅದಕ್ಕೆ
children
LRs
are
ನಿಮಿಷ
to
ನಿಮಿಷ.
come on record.
IA1 of 25 ಏನು impleading?
Impleading by the LRs of first respondent who has died.
For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the application seeking to bring legal representatives of
First respondent.
the first respondent is allowed the petitioner to amend the cost title accordingly. ಆಮೇಲೆ
12 to 28 my lord are unnecessary parties.
Necessary parties.
So far as
memo for deletion. The petitioner files,
respondent has filed it.
the respondent has filed a memo seeking deletion of R12 to 28 as they are not necessary parties to the present list, the petitioner has no objection to the same. In that light, at the risk of the respondent, the memo is accepted. R 12 to 28 stand deleted from the array of respondents in the subject petition. Compromise petition, other ಬಗ್ಗೆ ಹೇಳಾಯ್ತಾಗ್ಲೇ.
Compromise petition is already recorded, my lords.
ಅಷ್ಟೇ, allowed, go back there.
Much obliged.
ಹೋಯ್ತು ಚೇತನ್, ಹೋಯ್ತಾ? ಕನ್ಫ್ಯೂಷನ್ ಆಯ್ತು.
ಇಲ್ಲೇ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೋದು ಅಂತ ಕ್ಲೈಂಟ್ಸ್ ಅನ್ನು ಇರಿಸಿದ್ಯಾ ನಾನು?
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಅಲ್ಲೇ ಮಾಡ್ಬೇಕು ಅಂತಾರ ಅವರು.
ಹಂಗೆ ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು.
ಅದೇ ಅಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಅಲ್ಲೇ ಮಾಡ್ಲಿ ಫಸ್ಟ್.
ಯಾವುದು?
Compromise petition will be a part of the record.
ರಿಟ್ನಲ್ಲಿ ಹಾಕಿದೀವಿ, ಅಲ್ಲೂ ಹಾಕೋಣ ಅಷ್ಟೇ.
ಎಸ್.
7.
Post immediately after service of notice upon respondents 1 to 7. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Next. Continue, yes.
Acknowledgement has been filed this morning, my lords.
Huh?
The acknowledgement has been filed this
Learned
morning.
counsel for the petitioner submits, needful has been done, office to verify.
And
Entry
regarding the
matter
office
subsisting will
objections,
continue.
it stands complied in the previous date itself, my lords. There was a clarification.
Learned counsel submits, the office objections also have been complied with, office to verify.
Entry order may
Continue, yes. Next.
9.
My lord, I appear for the petitioner. The
4
office
weeks,
objection
my
may
lord.
kindly be overruled, my lord.
In 4 weeks, representation.
Application pending before the DC in respect of the arbitrator in under National Highway announcement.
Oh, same order pass ಮಾಡಿದೆ. ಎಲ್ಲಿ ನಂಬರ್ ಕೊಡಿ ಅದು.
Your lordship 14812.
14812
of 2025. My lord,
Copy
on
ಇದೆಯಾ?
passing this order also, I
Put
made
it.
a mention that
Put it.
direction may kindly be given to the respondent number 1 to pass a detailed order considering the
ಅದೇನಾ? Same thing?
documents. But that thing has not come in this order also, my lord. Because they'll pass, there are instances that the
Perfunctory orders will be passed.
yes,
ಇದು ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ದಿ ಫಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ರೂಲ್ಡ್ ಅಂತ ಮಾಡಿ ದಿ learned counsel for the petitioner submits that the issue in the list is identical to the one decided by this court in so and so. The learned counsel further submit that an observation with regard to observation that the competent the deputy commissioner
please.
that the deputy commissioner should pass a detailed order concerning the issue has not been has been inadvertently omitted in the said order. Therefore, the deputy commissioner shall pass necessary orders in accordance with law after considering all the contentions raised by the petitioner in the application, ordered accordingly. Same.
The lordship.
2 and 3 may be dispensed with, my lord.
Respondents 2 and 3. Notice to respondents 2 and 3 stands dispensed in the light of the issue being only consideration of the application. Yes, next. Mooru adena?
Ade.
9, 10 and 11. Yes.
Great. My lord, time limit.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
3 weeks.
4 weeks ಅಂತಾನೆ ಇರ್ಬೇಕು ಅದ್ರಲ್ಲಿ. ಏನ್ ಟೈಮ್ ಲಿಮಿಟ್ ಇದೆ ಅದು ಮಾಡಿ. ಟೈಮ್ ಲಿಮಿಟ್ ಇಲ್ಲ ಅಂದ್ರೆ within 3 weeks from the date of receipt of the copy of the order. ಸುಮ್ಮನೆ ಇರಿ, ಕೆಲಸ ಮಾಡಿ.
Great.
Yes.
Where?
Contempt ಹಾಕಿ ಗೊತ್ತಾಗುತ್ತೆ. Furnishing FPF, PF.
Lord, the office objections have been complied with.
And
And
counsel submits
notice
office
to-
objection has been complied with.
Lord, notice to the remaining uncontesting respondents may be dispensed with.
Counsel for the petitioner, it's same matter. Huh?
Same matter, same matter.
Counsel for the petitioner submits that notice to R2 to R12 be dispensed with as no relief is claimed against them. In the light of the said submission, issuance of notice to R2 to R12 stands dispensed.
Lord, not on the ground that no relief is being claimed. They're not contesting defendants.
I have not
They're
contested.
contesting
at the-
respondents.
Non-contesting respondents. Yes.
Lord, this matter was supposed to be tagged.
Yeah, the
with-
tag,
Your Lordship
no, which
on the
is that
previous date
number?
asked us to move a memo. We moved a memo yesterday. I think not
Number,
the
number.
number is going to be given in some time. The DR is not yet there.
12 days. Interim order passed. It's still in FR stage.
Tomorrow.
And they have taken 3 dates to
Tomorrow.
get it tagged.
Tomorrow.
Please.
Yes. List tomorrow. Number ಕೊಡಿ.
Number,
in the course.
something.
List tomorrow. Once he gives that number, tag it ಮಾಡಿ.
FR number is 13.
Petitioner, my lord. Sir, the copy to counsel representing the lower court, my lord. As per the.
Learned counsel files a memo depicting service of notice upon the counsel for the respondent. There is no representation yet, lest the matter 16th interim order subsisting will, wait, interim order subsisting will continue to the next date of hearing. Yes. Next.
Preliminary hearing, 14.
My lord, the amount of rupees 3,99,458 rupees, it's already been deposited, my lord.
When?
On 12/3/2011 only, my lord.
Aye, ಇನ್ನೇನು ಉಳಿತು?
Tashildar.
Yes, Shivrakash.
On the memo they filed and also document. And the last occasion they filed. May I kindly take one
ಏನು?
document or annexure they filed, that's in 1231.
Oh, covered by judgments, huh?
More than a dozen of cases covered. My lord, their own document, what they have produced was saying that they have deposited amount. May I kindly take my lord to the document they have filed. In that notice is issued by the Tahsildar Bangalore. Tahsildar Bangalore, wherein the check and check number they have referred, my lord. The Tahsildar reply to the land acquisition officer is, ಯಾವುದೇ ಪತ್ರವ್ಯವಹಾರಗಳು ಇರುವುದಿಲ್ಲ. ಪ್ರಯುಕ್ತ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 7 ದಿನಗಳ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿ ಸಂಬಂಧಪಟ್ಟ ಕಡತಗಳಲ್ಲಿ LND ಉತ್ತರ ಶಾಖೆ ಹಸ್ತಾಂತರಿಸುವ ಸೂಚಿಸಿದೆ. ತಪ್ಪಿದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಅದಕ್ಕೆ ಮೇಲೆ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನ ಕಾರ್ಯಗಳು ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದವರ ಕಚೇರಿಯಿಂದ ಸ್ವೀಕೃತವಾಗಿರುವ ಚೆಕ್ ಅನ್ನು ನೀವು ಸ್ವೀಕರಿಸುವ ಬಗ್ಗೆ ಸ್ವೀಕೃತಿ ವಹಿಯಲ್ಲಿ ನಮೂದಿರುತ್ತದೆ. ಸದರಿ ಚೆಕ್ ಅನ್ನು ಯಾವ ಬ್ಯಾಂಕಿನ ಖಾತೆಗೆ ಮಂಜೂರಾಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಕಡತದಲ್ಲಿ ಯಾವುದೂ ಪತ್ರ ವ್ಯವಹಾರಗಳು ಇರುವುದಿಲ್ಲ. On my writ petition filed.
You are still in possession?
I am in possession right from 1960, my lord. Only one point I would like to make my submission. 1960, this Doddakalla Sandra, the survey number is 19. It's an extent of 4 acres, 10 guntas. It's a government kharab land. I am in cultivation, I am in possession. The TT tax is also paid in the year 1966 onwards. My lord, in the year 1969, when we made application, a portion about 2 acres, 10 guntas in possession of this Ramaya, and other 2 acres is in possession of Kempamma. My lord, the grant committee, they have granted this land to Kempamma 2 acres and to me 2 acres, 10 guntas. Then this acquisition started in the year 1988. In the year 1988, they have not shown my name, though mutation entries and though the revenue records are in my name. Then the proceedings started. Then I approached the Sambal court way back in the year 2006. Then the Sambal court again to consider all these things remanded. Meanwhile, the other portion, 2 acres in the name of Kempamma, the land acquisition officer as well as the government, after considering the Kempamma approached the Sambal court, the entire proceedings of acquisition has been quashed. That's also one of the annexure I have placed.
Yes.
Now remaining 2 acres, I built my house, electricity is supplied, and the garden I'm maintaining for my family. And also the active cultivation is made. Now the entire extent of Doddakalla Sandra, where 4.4% is the percentage wise they have acquired. Remaining entire extent is left out or denotified or deleted. In this connection, this Sambal court on 11/12/2023 passed an order directing the BDA to file an affidavit to that extent. What is the extent of land they have acquired and what is the lands, which are the lands which have been denotified. They are not.
Murugesh, affidavit ಹಾಕಿದ್ದೀರಾ?
Affidavit is filed.
Update is filed. So far as sketch is
9th
concerned.
9th September 2024, I filed an affidavit.
All right.
The order in detail, may I kindly take my lord to the.
I produced the
Order sheet.
entire lands notified for 9th stage lot. The details of the acquisition is at document number 1. Still, survey number wise I have produced. Lordship, may kindly see.
The order is on 12/3/2024, wherein the Bangalore Development Authority to state on affidavit the extent of land out of 241 acres, 20 guntas, which is declared to be handed over for execution of the scheme in Doddakalla Sandra village, and to what extent award had been passed, as well as to what extent the layout had been formed. The Bangalore Development Authority shall also state the lands, if any, given up from the acquisition, either by denotification or by passing any award in respect of the land in Doddakalla Sandra village. It shall also furnish a sketch indicating the extent of land that it has taken possession pursuant to passing of the award in respect
Yes,
of the.
sir.
This is the specific direction given and specific order made by the sample court. Till date, the affidavit to show all the particulars and the sketch they have not produced till date. And my adjoining land 2 acres Kempam was quashed by the sample court. All those judgments are placed on record. My amal and responsible submission is now the entire Doddakalla Sandra, only 4% is acquired, and that too for the societies, not for the use of this BDA. With this, there is a total scheme has not been implemented. It is a case where the sample court has
Yes.
followed my petition.
Heard reserved, yes.
Obliged now.
Intermod ಇದೆಯಲ್ಲ?
It is there, it is there.
Subsisting shall continue to the disposal of the petition.
My lord, connected matters about 6 decisions are placed on record, my lord, on the last date. Obliged.
Make one request. Not the,
You filed your objections.
if I have offshore holding say, the decision in the offshore holding, even if the scheme lapses, the acquisition.
We'll look into everything and pass.
Please.
Yes.
And Lord, insofar as the other is concerned, the house building cooperative societies, but this honorable court has held that, Lord, the formation of.
Where are the judgments?
I shall place those.
ಯಾವಾಗ?
I'll today accept.
Place it.
Please.
Yes.
Obliged.
Place all the judgments and synopsis also.
Please.
Murgesh.
Accept.
Next.
15,
every 2 weeks time ಅದ್ರಲ್ಲಿ ಸರ್ವೆ ಮಾಡಕ್ ಹೇಳಿದೆ
2014 ಇಂದ ಮಾಡಿಲ್ವಾ? Rule issued ಅಂತ ಇದೆ.
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡಿ ಒಂದು ರಿಪೋರ್ಟ್ ಹಾಕಿ ಅಂತ ಹೇಳಿ.
Just the matter.
ಅದ್ರಲ್ಲಿ
Final
electronic
hearing as
survey
rule
ಆಗ್ಬೇಕು.
is already issued on 17/3/2017. The learned counsel for the respondent BDA submits that report of the survey will be placed before the court on the next date, list on 24th. Yes, next. Intermod ಇದೆಯಾ? Yes. Yes, Sriraj.
16,
ಏನ್ disposal?
Filing a
Covered.
memo- Covered ಅಲ್ಲ. I'm filing a memo to dispense with bringing the LRs on record. R4 ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Counsel for the petitioner files a memo that the legal representatives of the fourth respondent are not necessary parties to the issue in the list or the dispute at hand. In the light of the memo filed, no steps need be taken to bring in the legal representatives of the fourth respondent at the risk of the petitioner. ಏನ್ covered ಏನಿದೆ?
ಅಲ್ಲ covered ಅಲ್ಲ. Your Lordship may dispose this off. Because I have a very tough case to argue, my lords, but your Lordship may hear me for 2 minutes. Because these lands were acquired, my lords, for Nagarbavi layout second stage. Because Nagarbavi layout second stage, my lords, the lands were acquired. 1982, my lords, the preliminary notification was issued. 88, my lords, the final notification was also issued. Award was passed. Possession was taken in 91. Lords, thereafter, various landowners challenged the acquisition. The writ petitions were dismissed, writ appeals were confirmed. Thereafter, lords, another set of landowners, they challenged the acquisition. Writ petitions were dismissed, confirmed in appeal. 30 years later, my lords, the original landowner, he sells the property in 2012.
To you?
No, to my vendor.
To your
Now I am
vendor.
the second purchaser. In 2014, my lords, knowingly.
After the acquisition?
After the acquisition. Knowingly or unknowingly, my lords, I purchased the property in 2014. After the lands were acquired, it is attained finality, my lords, I have purchased the property. My lords, I have no qualms regarding the acquisition. I have been in possession, my lords, for the past 12 years, having built a house, 3 floors, I produced photographs. Now, my lords, for the mistake that they have done, after having been in possession for 30 years, the original landlord, he sells the property. I, not knowing about the acquisition, my lords, I purchase it. I
Due
have built a
diligence.
house. My lords, I have, there is nothing else to argue, my lords, apart from the fact that I am in possession for the past 12
What
years.
should be done for that?
Your Lordship may give me some respite, my lords, with regard to the fact that I have been in possession for the past.
You should fight against your
Lordship, if
vendor.
he has constructed, then 38D provision is there in the BD Act.
Lords, we've also explored 38D, Lords, but the extent of this land is about 5,000 square feet.
It's only
Then
up to 4,000 is allowed here.
Land, Lords, was acquired. It was acquired for 5 acres, 11 guntas. Now, Lords, the only portion that I am claiming possession of is 5,000 square feet. Was any protection that your Lordship can, Lords?
Protection, what protection?
I will, Lords, under 20, I will file an application for betterment tax, Lords. And it says any person aggrieved, even under section 20.
Betterment taxes will not be applicable here. The only option is 38D. He has to give up some, he has to claim only up to 4,000.
That
You
is
have 5,000, you are holding
4,960 is the square feet.
Claim up to 4,000. That's all.
Up to 4,000, he can claim under 38D.
Under 38D. All right, we'll pass that order. That's all, otherwise nothing. Yeah, they will consider that under 38D.
Great.
Yes. Yes. Correct. Huh? Dispose.
Seventeen.
Appear for the petitioner, my lord.
Produce file of SLAO.
But sir, I prepared some synopsis.
Ah.
But this is a question with regard to utilization of land without acquisition. Only dispute with.
Utilization, admitted utilization.
Admitted utilization. I am raising two grounds. One, the extent of the land utilized is under dispute. That is one thing. Second is with regard to the title. It's a grammaton land. I would say that the petitioner has no title.
Why is it come in orders? What's the matter in preliminary hearing Thursday?
My lord, on submission.
Thursday.
Very well.
Serial number 18, my lord, this is the land which is acquired in the 1960 and 1964 for Hazrat Colony. Hazrat Colony. My lord, it's a Inam land, my lord. This honorable court directed me to records pertinent to the same, my lord. But there is no proof of payment by them. On last occasion, my lord, I just pointed out this honorable court, my lord, at page number 25, my lord. Page number 25, typed copy of the application filed by them in the year 1966. 1966, my lord. The original application is at page number 18, my lord, and the
page
18, my lord.
Yes, sir.
Page 18. They have clearly stated.
Wait. Yes, sir.
Religious and charitable norms land. The land will be resumed subject to regrant. Therefore, my lords, make NDC page number 28. While passing the order of confirmation in my favor, the authority came to know, they came to the conclusion 1.3 and half guntas of land is already been acquired by the state. They said whatever the amount that is going to be paid, required to be paid in my favor.
Page.
Second paragraph, page number 28.
Further, the compensation,
for the loss of 1 acre 3.5 guntas of land out of the survey number 12 of Arlur village, which has been acquired, has been acquired for the purpose of the Harijana colony and to be paid to the applicant. I further order and directed the exercise of the powers vested under the section 9 of the Village Officers Abolition Act that the compensation for the loss of the right of Shanbog to be paid to the applicant, and he is also he is losing the Shanbog office service. Therefore, both the remuneration as well as the land, as the compensation is directed to be paid to me. And no word has been passed.
1971.
It is 1971. And from 1964 to till date, no compensation, no award has been passed with respect to 1 acre 3.5 guntas of land, and no compensation has been paid.
Yes, sir.
My lord, page number 25 may be done. Page number 80 of the application filed in the year 1966, my lord.
That is for the grant.
64 is the land which has been utilized for Harijana colony, and 60 when it has been rested with the government, the Inam land. And thereafter 66, he made a
occupancy price may be adjusted out of compensation.
Yes, ma'am.
Oh, this is what they
This
have
is-
said last time. you
We have filed it, my lords. We have filed an application.
After grant also, they have to pay towards the government some amount as occupancy price as per the act, my lord. They have not produced that. And after the lapse of about more than 50 years, they have come up before this honorable court, my lord. Almost 60 years itself, my lord.
Yes, sir.
As far as limitation is concerned, my lord, it's the obligation of the state to pass the award. And I may permitted to pass on certain judgments in the aspect of the matter. Lords, the first judgment is, my lords, I would request this honorable court to turn to pink page number 5.
Paragraphs.
Paragraph number 14. The first thing that the High Court should have inquired with the state is as to why in the year 1977 itself, that is the year in which the land came to be acquired, the award of compensation was not passed. The High Court should have actually inquired why it took 42 years for the state to determine the figure of 4,68,099. The High Court should have also asked the state to, on what the basis of determination of the amount of towards compensation. It's a well-settled position of law that after the award towards the compensation is passed, the owner of the land is not satisfied with the quantum. He can even file an appeal for the enhancement to the same. The High Court proceeded on the footing that the amount of rupees 4,68,099 has been assessed, and it is now for the applicant to file the appropriate application to get the amount disbursed in his favor. This is what exactly the question is. When the question of award comes, it is the obligation on the part of the state to pass the same. It is not, my lords, the second judgment that I would request the honorable court to kindly look into is not that is the page number 13.
Paragraphs put kodi.
Paragraph.
Paragraphs. In your index, indicate the paragraphs.
May I indicate it?
My ground is only that. limited
Lords,
to judgment.
another important aspect of the matter in this matter, my lords, out of total extent, 2 or 3.5 guntas, 2 acres have been granted in my favor. 1 acre, 3.5 guntas were been, it's a Shanbog in Amti land. Resumption takes place subject to the regrant. And I was being regranted. What the time of regrant, it was been noticed that the extent of 1 acre, 3.5 guntas has been acquired.
Yes.
Therefore, compensation has been directed to the audit. And what's as to quantum of compensation, one submission that I have, the last judgment, my lords, there are judgments to the effect, my lords, even the relevant provision is clear that it required to be dated to the date back of the notification. But recently, the Supreme Court has said it required to be dated to the date of the award. That's one judgment which I want to bring it to the notice of this one. Paragraph. May kindness.
My arguments are limited, madam. In the application itself, it has said that it has to be deducted or adjusted towards the payment of a grant itself.
ಅದು application ಅದಾದ್ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿರೋದು. ಆರ್ಡರ್ ಆಗಿರೋದು
Heard reserved, yes.
After the order, he has to pay, my lord. That proof they have not produced, my lord. The rest of things is delay in filing this. There was no representation, there was no request.
That I
There
will
was nothing
consider.
made
Yes.
from 71 till this filing of writ petition.
Okay.
Yes, next.
19,
I'm appearing for petitioner in this matter, my lord.
Respondent, furnishing FPF.
Respondent number 3 has passed away, my lord. I have filed application to bring the LRs of respondent number 3.
I have already disbursed the compensation in 2023.
Now, what is the petition for?
My lord,
Petition is that the amount should be deposited before the court.
Is already in order?
I am entitled for a portion of the compensation amount.
Interim order is granted already.
Yes, my lord. There was an interim order granted. It is also subsisting. Now that, my lord, respondent number
And
1.
interim order shall not be released till the next date of
My
hearing.
lord's payment was on the 4th of February 2023. Interim order was thereafter passed on the 2nd of March 2023.
Now, payment was made by then?
Yes, my lord's payment was already made. The writ petition was itself filed after the payment was made.
My lord, that
Writ
was
petition
also,
was filed on 22nd of February 23. My lords, we had already paid it on 4th of February. Interim order came to be granted on 2nd of March.
please, my lord, I have produced annexure B, my lord. This is my
Okay, we'll
representation.
record that. Now, what is the petition remaining for?
My lord, annexure B is my
Direct
representation.
respond deposit compensation. Civil
Please.
court ಆಗ್ಲೇ pay ಮಾಡಾಗಿದೆಯಲ್ಲ deposit ಏನ್ ಬಂತು?
Alla, annexure B, my lords may kindly take annexure B. It is dated 9th August 2021. I filed my objections. They don't consider. And my lord, now they say that
Today
they
we
have
will
released
direct
the
them to
amount.
consider what happens.
Even otherwise, my lord, this fact of, my lord, release of the compensation amount was brought to the notice, was also filed, my lord, along with the petition. Please see annexure E, my lord.
It's all, there is an interim order operating.
Having considered that, my lord, the interim order was granted.
No, of what avail would be the interim order now?
My lord, they have to redeposit, my lord, otherwise,
Who
my
has to
lord,
redeposit?
my lord, there should be a direction, my lord, despite
Who has
the,
to redeposit?
my lord, my only grievance is.
Oh,
R3.
R3 and R4, is it?
And
Yes,
R3,
please,
my
madam.
lord.
Who
Only
appears?
R3.
Without considering my objections, my lord, they really proceed to release. My lord, they have
And partition
acknowledged my
suit pending idea.
suit ಯಾವ್ದು pending ಇಲ್ಲ in
ಹಾಗೆ
respect
ಇಲ್ಲ.
of this.
ಹಾಗೆ ಇಲ್ಲ.
ಅಲ್ಲ, compensation release ಮಾಡ್ಬಿಡಿ.
Who are you?
I am one of the joint family member entitled for the compensation.
May I request page 13 may be kindly looked into.
Please see the family tree,
There's
my
a
lord.
translation of the family tree.
Ah,
Now, he is Nagapa's one son Muniraju.
Oniraju N.
My lords, the first name on the left hand side, my lords, Doddapayana's son Ramaya, he alone has received the money. He makes only R3 and R4. Lakshmana has not received any money. None of the other family members are made parties to the petition.
Now
Monies
that-
have been disbursed. It is 550 days since R3 is dead.
My lord, I have,
So it's not that he died yesterday.
my lord, since my lord, compensation amount is released in favor of this Ramaya, my lord. Ramaya and Lakshmana, since they were, my lord,
No, other claimants are not there?
pursuant to the death of my lord Bodappa,
No, no,
what happened is.
other claimants are not there. It's a joint family
Yes,
property.
all are entitled
All
to,
of-
my lord.
Then make everybody a
I'll make everybody, that, no difficulty about that, my lord. My only aspect is that, my lord, after the death of Bodappa, that is the Karta of the family, my lord, the revenue records were mutated in the name of Doddapayana. Taking advantage of that, my lord, these two, that is the children of Doddapayana, that is Ramaya and Lakshmana, who are respondent 3 and 4 before my lord.
Now I will record. If you want redeposit of the compensation, final relief, then we'll have to hear everybody.
Yes, please, my lord.
The petition is preferred, seeking a direction of deposit of compensation awarded by the National Highway, na?
Yes.
National Highway Authority of India in term for the purpose of acquisition of the subject land. The petitioner, this court grants an interim order on 2/3/2023, which reads as follows. Learned Counsel Giridhar SV, appearing for the NHAI, would submit that the compensation was determined and also paid to ಯಾರಿಗೆ ಒಬ್ರಿಗ
Respondent number
R3,
3
respondent number 3.
R3
filed it along with the memo.
paid to R3 in the month of February 2023 itself.
My contention, my lord,
4th February.
4th February 2023,
despite my objection, not
One nimsh.
considering, please.
2023. And the subject petition is preferred on 22nd February 2023, and the interim order is granted on 2/3/2023. The learned counsel for the petitioner submits that the disbursement of compensation is notwithstanding the objections filed by the petitioner not to disperse compensation in favor of any member of the family in the light of his claim also being a member of the joint family. Since the compensation is already dispersed, the final order that could be passed is redeposit of the compensation in the event the petitioner would succeed in the subject petition. If that is to be done, all the other family members who are entitled to such compensation should necessarily be a party to these proceedings. In that light, the petitioner shall take steps to that effect. Interim order subsisting will continue till the next date of hearing.
Interim order is not to disburse.
ಆಯ್ತು, ಇದೆಯಲ್ಲ ಅದು ಆಲ್ರೆಡಿ, ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ ಮೇಲ್ಗಡೆ ಎಲ್ಲ. ಎಸ್,
Obliged.
Notice on the IA to bring LRs of R3 also is to be ordered.
Yes, please.
notice on IA,
IA number.
IA 1 of 2025, notice on IA 1 of 25. Next,
20.
early hearing,
I appear for the petition.
application for early hearing
Things are
rejected.
complete, my lord.
My lords,
Application for early hearing rejected, list the matter in preliminary
lords,
hearing B group
my lords,
on 17th. Yes.
my lords, 1969 is the preliminary notification was.
17th is this month only.
50 years delay in
17th,
filing.
yes. You
Final,
have filed it in 23.
2019 is the final notification.
Correct.
After delay of
2020.
30 years, my lord, they have, anyway, we have paid compensation. They want,
Compensation?
compensation is paid.
1969
They want a
date,
new
my
act.
lords.
All right, yes.
My lords,
17th.
B group, my lords, may
B group
request for-
17th,
May I
yes.
request for preliminary.
Early hearing ಯಾಕೆ ಹಾಕಿದ್ರಿ? ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ
ಇಲ್ಲ ಆಗಿದೆ.
ಮತ್ತೆ? Yes.
My lords, he is 80, petitioner is aged about 80 years, my lords.
I request the matter be
I
listed.
have
on
not posted it on next month, madam.
for
17th only, yes.
My request for preliminary hearing.
You should understand. On Wednesday, big group comes first, yes.
In 21, I appear for the petitioner, my lords. In this matter, my lords, if your lordship could grant me 10 days time, my lords, I need to file my rejoinder to the statement of
Learned counsel
objections.
for the petitioner seeks 10 days time to file a rejoinder to the statement of objections so filed. Rejoinder, if any, by the next date of hearing, lest the matter on 24th interim order subsisting would continue to the next date of hearing.
Grateful, my lords.
22.
Challenges with respect to the final notification. I would request this honorable court to kindly note certain dates over there in the matter.
Production of documents in early hearing. Early hearing rejected.
Early hearing ಹಿಂದೆ ಹಾಕೊಂಡಿದ್ದೆ ಅದಾದ್ಮೇಲೆ ತಮ್ಮ ಮುಂದೆ ಬಂದು ಮ್ಯಾಟರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಗಳು ಕೂಡ ಆಗಿದೆ.
ಅದೇ adjacent land.
Adjacent land ಅಲ್ಲ ಇದು. This is land which has been the SHLC has approved a project and subsequent to which that has been notified by the KID.
Where is the board? Gopal V. Balman.
They have filed their objections. It was here.
Not pass over.
Okay, I might seek for next week.
Next week, next Tuesday.
Next week.
Early hearing reject, IA 2 of 2025 stands rejected. List next week. Preliminary hearing.
Next Tuesday.
ಅದಕ್ಕೆ early hearing application ಯಾಕೆ ಹಾಕ್ತೀರಾ?
ಅದು ಹಿಂದೆ ಬರ್ತಿರ್ಲಿಲ್ಲ ಹಾಕಿದ್ದು ಅದಾದ್ಮೇಲಿಂದ ಬಂತು.
23.
For petitioner, please. The petitioner challenge the annexure A, please, your honor. Filing a earlier writ petition. That writ petition was allowed and quashed the annexure
Yeah,
A.
which one? Sorry. Yes, sir. ಏನು ಹೇಳಿದ್ರಿ?
The petitioner challenge the annexure A, please, lordship. That annexure A filing a writ petition. In earlier writ petition 28,448.
Notice ಆಗಿಲ್ವಾ ಇನ್ನು?
ಆಗಿದೆ ಸ್ವಾಮಿ.
Yes, sir.
ಇದು ಕ್ವಾಶ್ ಆಗಿದೆ. ಕ್ವಾಶ್ ಆದ್ಮೇಲೆ I have given a represented, there is a mistake on part of us, please lordship. You have not mentioned proper survey number and measurement.
ಯಾವ್ದ್ರಲ್ಲಿ?
Writ petition annexure E, please.
ಅದರಲ್ಲಿ ಪ್ರಾಪರ್ ಸರ್ವೆ ನಂಬರ್ ಆಗಿರಲಿಲ್ವಾ?
ನಾನು ಹಾಕ್ಬೇಕಾದ್ರೆ ತಪ್ಪಾಗಿತ್ತು. They have refused to accept that, enough that I filed present writ petition, please lordship.
Which is the correct survey number?
334 measuring 2 acre 30 guntas. Instead of ಅದರಲ್ಲಿ 333/4 2 guntas ಅಂತ ಆಗೋಗಿತ್ತು.
ಅದು ಕರೆಕ್ಟ್ ಮಾಡಿಲ್ವಾ ಆಮೇಲೆ ಕೋರ್ಟ್?
ಇಲ್ಲ, ಅದು ನಂದೇ ತಪ್ಪಿತ್ತು.
ಮತ್ತೆ ಅದ್ರ ಕರೆಕ್ಷನ್ ತಗೋಬೇಕು ನೀವು ಫಸ್ಟ್. ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವರದು ಫಸ್ಟ್. You should file a correction there.
ಅಲ್ಲಿ ನಾನು ಇದನ್ನ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟೆ ಸ್ವಾಮಿ. ಅವರು they have refused to consider my.
You refuse to consider, you should seek correction of the order. Correction ಅಂದ್ರೆ it has to go before the same honorable
ಅಲ್ಲ,
judge.
correction ಅದಕ್ಕೆ ನಾನು separate writ petition
ಹಾಕಿದ್ದೀರಾ?
ಇದೆ present.
ಕರೆಕ್ಷನ್ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು. ಎಸ್ ಕರೆಕ್ಟ್ ಅದು.
ಇಲ್ಲ ನಾವು ಸಿಸ್ಟಮ್
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೇನೆ ಸರ್. ಇಲ್ಲ, my learned friend has appeared and he has received the copy.
ನಾವು ರಿಸೀವ್ ಮಾಡಿರ್ತೀವಿ ನಮ್ಮ ಆಫೀಸ್.
Bless the matter next Tuesday at the request of the learned HCGP. ಮತ್ತೆ ಟೈಮ್ ಇಲ್ಲ ಅವತ್ತು ಮುಗಿಸೋಣ.
Grateful.
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಬೇಡ, ಒಂದು ನಿಮಿಷ ಡೇಟ್ ಏನು ಮೇಡಮ್? ಅದರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕಿ 15th.
Grateful.
24.
For the petitioner, my lords, kindly week's time may be granted to file my rejoinder, my lords, objections.
Learned counsel for the petitioner seeks a week's time to file a rejoinder to the objections filed by Ajit Achappa, appearing for respondents 2 and 3. List the matter on 15th. Rejoinder, if any, by then entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ sir.
Next.
Great.
25.
Direction, what direction?
Short point, my lord.
What direction?
The direction is only to issue to execute the sale deed. May I request your lordship kind order dated 1/6, that may be date of your lordship.
10/6 Purti, I have captured everything in that order.
Yes, exactly.
Exactly, yes.
Your lordship may kindly appreciate here, my lord, they are acted upon by virtue of a consent award. May I request, my lord, page may be kindly be for a minute. That is at 1/3, my lord. Your lordship may kindly here. ಶ್ರೀ ಮಾದೇವ್ ಇದನ್ನೆಲ್ಲ ಹೇಳಿ ಅದರಂತೆ 4 ಎಕರೆ ಜಮೀನಿಗೆ ಸಂಬಂಧ ನೈಜತೆಯ ವರದಿಯನ್ನು ತಹಸೀಲ್ದಾರ್ ಉತ್ತರ ತಾಲೂಕು.
ಒಂದು ನಿಮಿಷ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ? ಎಲ್ಲ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ?
ಕೊಟ್ಟಿದೆ. ಅವ್ರದೇ ಫೈಲ್
ರಿಜಾಯಿಂಡರ್ ಹಾಕಿದ ಅಲ್ಲ. ಇನ್ ಮೈ ಆರ್ಡರ್ Respondent shall file statement including every document with regard to the claim of the petitioner and how it is tenable. Failing which this court will be constrained to direct execution. ಹಾಕಿದ್ದೀರಾ ಈಗೆಲ್ಲ?
There's a complaint. Lakshmi, kindly take page 7 of my statement of objection. Annexure R1, Lord.
Page 7, na?
Please.
ತಕರಾರು ಅರ್ಜಿ.
This is a complaint filed by one of the person, Lord, one Putswami. ಭೂ ಮಾಲೀಕರಾದ ಶ್ರೀ so and so ಅವರು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಕನ್ನಡಿ ಗ್ರಾಮ ಸರ್ವೆ 93 is the subject matter. 22 ಎಕರೆ 30.
Who is that person?
Lord, he claims to be an RTI activist. Yes.
Your Lakshmi kindly.
Wait, sir.
Lakshmi kindly. Thereafter, Lord, what has been said is, ಇದರಲ್ಲಿ ಮಹಾದೇವ ಬಿನ್ ಚಿಕ್ಕಮಾದು ಅವರು ಹನುಮಯ್ಯ ಬಿನ್ ಹನುಮಯ್ಯ ಅವರಿಗೆ GPA ದಾರರವರಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. GPA ದಾರರು ಹನುಮಯ್ಯನವರಿಗೆ ಯಾವುದೇ ರೀತಿಯ ಹಕ್ಕುಗಳು ಇರುವುದಿಲ್ಲ. ಇವರಿಗೆ ಕ್ರಯ ಪತ್ರವಾಗಲಿ ನೋಂದಣಿ ಹಂಚಿಕೆ ಪತ್ರವಾಗಲಿ ಕೊಡಬಾರದಾಗಿ ವಿನಂತಿ. Then Lord, there Lord, he says, Lord, as per the RTI information, there Lord, no records of grant are available in survey number 93. It's a government land. And Lord, that is why, and proceedings before Lord, land grabbing court is initiated. All the files are seized by the land grabbing court.
ಮೊನ್ನೆ BMTF ಅಂದ್ರೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಬಿಂಗ್ ಕೋರ್ಟ್ ಅಂತ ಇದ್ದೀರಾ?
Sorry, BMTF. BMTF.
Yes, sir.
BMTF court, all the files are seized by the BMTF.
Objections ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
I filed it on 27th June.
30th June rejoinder ಹಾಕಿದ್ದಾರೆ?
ಹೌದು.
Yes, sir.
Your Lakshmi kindly appreciate only few points, sir. I'm not troubling much. The point is, Your Lakshmi kindly. Here, my lord, the consent award is acted upon in 2018. The 13th sale deeds are executed. Now, because of my husband, that is a present petitioner's husband, due to COVID, passed away. Your Lakshmi kindly relating to the LR's authenticity, the BDA has verified the records. Your Lakshmi kindly appreciate that is on 31/1/2025. Law officer, just I'll read my lord for a kind information.
ಎಲ್ಲಿ ಹಾಕಿಲ್ವಾ ಇಲ್ಲಿ?
ಹೌದು, I produced along with the memo. Your Lakshmi kindly appreciate this document. On Srimati Maramma, one Maramma, wife of late Hanumaya, submitted a representation, the land situated at Kannahalli village bearing number 93, Yashwantpura Hobbli, Bangalore, North Taluk, measuring 4 acres was acquired by the authority for the formation of NPKL layout. According the developed sites have been allotted to her husband Hanumaya. Meanwhile, her husband died on 30/4/2020. Therefore, she sought for a transferring and executed sale deed in her favor. Peruse the Mahadar, death certificate, family tree, and other relevant documents on record. Therefore, the authority may proceed to consider.
What happens to this 31/1/2025 note?
Lord, this is with regard to Lord, they claim, the wife comes and claims that you have allotted a.
No. Therefore, the authority may proceed to consider the prayer of the applicant. What prayer?
Lord,
Execution of sale deed.
What has happened is, the wife comes and says, insofar as the allotments which you have made in favor of my husband, please transfer it to my name. This is the request that she
Correct,
makes.
that is accepted by you.
That is accepted, but the fact that survey number 93, it's being a Gomala land and a government land, and Lord, the proceedings are pending before.
Why did you accept it?
Lord, this is on what circumstance, Lord, this note.
Why
has
did you
been put
accept
up.
it? Who accepted it?
Lord, it is not virtually accepted of
Go
allotment.
proceed to consider the prayer of the applicant ಅಂದ್ರೆ ಇನ್ನೇನು?
But this is with
How
regard
can you
to-
blow hot and cold when you've already said this?
It is not that way. May I make this statement, Lord? This is with regard to the wife.
What have you said about this in the objections?
Objections, man, I produce the original grant register and also grant certificate and the Sagwali chit to show the grant is genuine.
Lord, that has been.
And also
fabricated.
further, my lord,
That is
ತಕರಾರು
fabricated.
ಪತ್ರ ಯಾರು ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ.
once they
That
acted
is
upon.
One minute. What is fabricated?
The allegation against.
ಇದ್ರ ಬಗ್ಗೆ no whisper about this law officer's opinion ಬಗ್ಗೆ no whisper in the entire objection statement. Can your lordship can kindly appreciate.
ಈಗ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡೋದು ಯಾರ ಮೇಲೆ?
ನಮ್ಮ ಮೇಲಿಲ್ಲ, no FIR. My name is not shown.
His name is not shown in the chat sheet also.
Since from 2018 till today, no complaint, no register, FIR is registered against me. Now they are stopped from by their own conduct, my lord, your Lakshmi. Here, my lord, they acted upon, they executed the shell, remaining to sell it.
But this is-
ಈಗ in the same survey in the same survey number 93,
Yes.
you have executed sale deeds to all those allottees.
No,
No?
no.
Where have you said so?
Lord, 93 insofar as.
Where have you said so that you have not executed sale deed in favor of other allottees?
Not an allegation, that is not a claim.
That is the prayer. See, look, come to the prayer. For remaining sites so and so.
Remaining sites, Lord, what are they asking is we have granted them the site, allotted them a site, execute the sale deed.
Correct. Remaining ಮಾಡಿದ್ದೀರಾ ಅಂತ ತಾನೆ.
ಇಲ್ಲ ಇಲ್ಲ ಯಾರಿಗೂ ಇವ್ರಿಗೆ ಯಾವ್ದಕ್ಕೂ sale deed ಮಾಡಿಲ್ಲ.
ಇವ್ರಿಗಲ್ಲ ಸರ್.
13 ಸೈಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇವ್ರಿಗಲ್ಲ.
93 ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ.
93 ಯಾರಿಗೂ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
Where have you said so?
But it is not.
In your objections, where have you said?
But what I have understood by the prayer is my
You,
apologies, Lord.
sir, whatever you understand about the prayer, I'm not on that. Now your law officer says it should be done. Law officer's opinion is an opinion. That's a different thing. But have you executed sale deeds in survey number 93 in favor of all others?
No, I shall file an affidavit, Lord of the.
File an affidavit. If you have not executed any sale deed in survey number 93 as he alleges.
Yes.
ನಿಮ್ಮ ಎಲ್ಲಿದೆ?
ನಮಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ 13 sale deeds.
ಎಲ್ಲಿ?
In fact, my father, my husband passed away because of that reason.
Adjacent lands ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
I'll produce-
Survey number 93 ಅಲ್ಲಿ adjacent
So,
sites
Lord,
ಮಾಡಿದ್ದಾರೆ. Where is
may
it?
Just I will read the one sentence from their own objection statement. By virtue of the order passed by the honorable court, the allotment bearing number computer, it is submitted, the entire acquisition records are in the custody of the BDA. That is their own statement in the objection statement.
Custody of the.
ಅಲ್ಲ ಅದು BMTF ಆಗಬೇಕು.
ನಾನು ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅವ್ರು ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
File an affidavit.
93.
ಅಲ್ಲ ಇವರ್ ಲಾಶಿಪೆ
You file an affidavit that 93 ಅಲ್ಲಿ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
even assuming for
I'll file an affidavit to that extent.
ಅಲ್ಲ
Lord.
Otherwise I'll have to grant this prayer.
Yes, if
No,
I have granted to
even-
somebody, Lord, I cannot come in the way of. Lord, if it is allotted to somebody, if it is sale deeds are
ಅದಕ್ಕೆ you
executed, I
should
can't
file an
come in the-
affidavit
yes, I can't.
properly.
even assuming for an argument's sake, my lord.
No argument. sir.
No,
Order sake ಅಷ್ಟೇ.
Order sake. Your lashback, can they keep it? Suppose assuming if there is illegality, they would have taken steps. In fact, 2008 to PN and 2010 is the FN. Till today, if a landowner has been denied, there shall be a fairness before the authority.
Correct. There will be fair.
No, there must.
Till 2024.
Attitude.
Affidavit ಹಾಕಿ sir. Yes. Madam,
Okay.
take the 12 o'clock matter.
Date may be
Next 15th.
obliged.
Further hearing it.
Lords,
They are making, seeking for a writ petition to include a challenge to Rule 3(1)D. We had filed it, but I think by not been indicated in the causes, but it is
That's
before
all
your
right,
lordship.
yes.
And they have filed their objections also. But it is a far, I'm making.
Yes, SG sir, what is about amendment can be.
so far as amendment is concerned, but I may not seriously object to it, my lords.
So-
I have filed my objections, which also contains objections on the merits of the amendment.
All
So
right.
that may be treated as my objections on the merits of the objection,
No problem.
of the amendment.
Is amendment, huh? The petitioner has filed an application seeking amendment, madam. Seeking amendment of the petition in IA 3 of 2025. The learned Solicitor General would submit that objections have already been filed on the merit of the matter as well as on the merit of the application as well, and the same may be treated as objections in the event the application is to be allowed. However, there is no objection to allow the application subject to what is aforesaid. In the light of the said submission, the submission of the learned senior counsel for the petitioner and learned Solicitor General of India, I deem it appropriate to allow the application for amendment, allow the IA 3 of 2025 seeking amendment of the petition. The petitioner should file an amended petition in the next 2 days, since objections are already in place. What is the
They are
other?
legal submissions, my lord. They are legal submissions.
There's an IA4, my lords,
It's not there.
for
It's
intervention.
impeding.
IA4, who are you?
Yeah, my lords, an association of digital media houses.
We have filed an application.
Digital media houses.
We are the content creators, my lords, who are ultimately affected by any takedown order. They've seen under the scheme,
The issue is between Government of India and Twitter.
intermediary is Twitter,
Yes,
but the content, my lords, is ours.
that's all right. How are you aggrieved?
Ultimately, it's my content, my right to speech, my lords.
Your
is
content, qua Twitter, not qua Government of India.
No, my lords, it's like this.
Hmm.
Under the 2009 rules, there is a hearing contemplated even qua a content creator, that is a news media house. Now, our case in support of the petitioner is that under the new framework, that is given a go by, 69A is given a go by, and directly orders are being issued, lords, to the intermediary, that is Twitter, to take down. So the moot question is,
You filed the
I
application?
filed the I. It's before
You
your
know, let
lordship.
application be also listed together, but
Very well.
he need not, my lord, support Twitter. Twitter is competent enough, my lord. It's an international body. It doesn't need, my lord, any such external support, my lord. Twitter
Then
and.
we'll hear it along with
Very well.
the main.
Very well.
the-
That would
But
be
I
fair.
would be opposing, my
While
lord, any.
I have no.
One moment, sir. Yes, yes, sir. Yes.
Lord, I would be opposing any third party my lord,
Yes, yes.
impediment.
No, we will not
Twitter is
allow the
competent.
application.
Yes.
Let it be heard along with the main matters.
Very well.
So now pleadings are complete?
Now, there's one other application, consequent to the amendment application, there's also an impleading. Impleading is only two ministries of the government of India. That's all.
That
may be
shouldn't be a
allowed.
problem.
Yes, yes.
That's fine.
Yes.
That-
I-
not
I-
even
I-
allowed.
number?
It is only two ministries.
I-
Yes,
number?
that may be allowed.
It's IA number? Three.
Two of 25.
Three.
Ah,
There's no-
The
Three is already
three is
allowed.
already ordered.
Four, is it? Four is there, sir.
Two is IA2, he's right.
IA2.
IA2 of 20. Impleading Ministry of Electronics and
Yes,
Information.
yes, MEIT.
The
We want to
petitioner has
implement, my lord,
preferred
Ministry.
an application
want
seeking
to implement, my lord,
implement
Ministry
of,
of Heavy Industries and Ministry of Rural Development.
correct,
Yeah, why?
seeking implement of several ministries of the Union of India. The learned Solicitor General would have no objection to allowing of the application, impleading several ministries as found in IA2 of 2025 for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. The application stands allowed. Petitioner shall thus file an amended petition with an amended cost title as well in the next 2 days. Next
My lord,
date.
I
sir.
want to point out, my lord, one thing.
So
Lord.
can it,
Your lordships, on the last occasion, my lord, passed an order that we are at liberty to bring to your lordship notice if there is any precipitate action. I want to point out, your lordships, my lord, a memo that we have filed. Kindly see, my lord, how this entire action is now. We are giving.
Memo?
Yeah, my lord, we're giving it to your lordships.
Do you have?
My lord, I want to show you, your lordships, what has happened. And this is the mischief, my lord, that I want your lordship to protect me against. Please be kind enough to turn, my lord, to page number 2 of the memo.
no, which is the memo? I don't have the memo.
Yes, my lord.
Aلا, where is
I
it?
know.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
You'll equal.
Achha, it's being given today.
Copy is given.
I understand, my lord. I understand, my lord.
No, that is a notice to
Yes,
the
yes.
intermediary for disabling
but from
access
Ministry
to
of
unlawful
Railways.
information.
I want to tell your lordship what has happened. Kindly see this notice. This is the reason why I want to bring it to your lordship.
No, let them have a copy.
Yes, my lord, it's been given.
Aلا,
May I just take 1 minute
Now-
of your lordship's time?
yes, all right.
I won't take more than that.
All-
The Ministry of Railways being the appropriate government in respect of all subject matters of Indian Railways and its attached officers is empowered under section 79(3)(b) of the IT Act to issue notifications to the intermediaries, including social media platforms, to remove, disable access to URLs, accounts, etc., where unlawful advertisements, endorsements, promotional content, etc., are published. And
So no,
whereas by Ministry of Railways,
Raghavan sir,
I'm sorry, my lord.
I'm sorry. If you're seeking any protection on this, they should have a copy at least. First time.
Yes.
They should have a copy. They should have time to reply. If you
This was
want any
no, my lord, this
protective
was only
orders,
on-
I should.
This came to us on 26th of June.
Then yes. sir.
Therefore, my lord.
Lord, I
That's
can
the
make
immediate-
one thing very clear. My lord, no
Yes.
social media intermediary can, my lord, expect completely unregulated functioning. They are
No
following
question.
all
No, no,
regulations
this
in
is
every
exactly what-
country.
Please see
In
what is the
India, they
complete-
want
no,
this
what-
luxury.
No, let them look into it.
No, I just want to bring it to your lordship notice for my
No,
satisfaction.
because
Please give me a
instead
minute.
of these piecemeal hearings, I'll fix a date, whenever it is convenient to all of you.
One day, one town note. Kindly see how it.
This is
and-
not
and-
only against ethical norms, that is what you want to
No,
say.
I
eh?
want to say how even according to them, 79 is not a standalone provision. It is to be read along with 69A. Kindly see what they have said in this communication. I just want to bring it, but I understand, my lord. I'm just bringing it to the notice of the learned solicitor so that, my lord, my learned friend knows what I'm going to say about this memo. It will be useful for him, my lord, ultimately. Please look at that page number 2. I want your lordship to kindly see that for a minute.
Hmm.
The undersigned has been designated as nodal officer for the purpose of notifying intermediaries in respect of unlawful information as per section 79(3)(b) of the IT Act, read with rule 3(1)(d) of the IT rules, along with section 69A of the IT Act. That is one I want to point out to you. Even according to them, my lord, 79A, 79(3) is not a standalone provision. It has to have the crutches of 69A.
No, it
And now,
cannot mean that.
That is a notification.
That's a submission, will
Both
answer.
are different
And then,
regime.
and then,
They
my
will
lord,
answer.
and then, my lord, I want your lordship to kindly see how the whole thing is misused, assuming they're right. Kindly look at, my lord, what is the unlawful content? And this is the danger, my lord, that is done now. If every Tom, Dick and Harry officer is
What is that,
authorized.
sir?
No, I'm sorry. Officers
What?
are not
What is-
Tom, Dick and Harry.
Lord, please
They
see
are
page 12.
statutory functionaries.
Please,
I
page 12.
strongly object to this.
I think it's
No,
crazy.
they are statutory functionaries, empowered to take action.
No. What is happening? No. What I'm
No,
saying
see,
is
It's
that
not, these are offices of the government of India.
Yes, they are not Tom, Dick and Harry. Please,
see page 12.
the
For a
international
minute.
bodies should
This is
not have
supposed to be
this
unlawful
arrogance.
content. Some lady, my lord, drives a car on a railway track. Now that is news, my lord. It is news, of course, my lord. As your lordship knows, my lord, if dog bites man, it is not news. If man bites dog, it is news.
Breaking news.
Breaking news.
Ah.
And if a car goes on a railway track, it is news. If aeroplane,
No.
no, it is news. If car goes on a railway track, it is news. If aeroplane lands on a road, it is news. If aeroplane lands on a runway, it is not news. Kindly see what is happening at page 12. I wonder, my lord, why all this? Please see, my lord, some
No, if designated things happen in designated places, no problem.
no news.
This is, the
This
problem
is
is
the
car
problem. Is it
running,
unlawful?
car running on a
No,
track.
is this unlawful? I run the car. Some lady drove the car on a railway track, and this is part of social media. Somebody takes a picture and put it on the social media. Now that is considered to be unlawful in this country for the purpose of exercise of power under section 79, read with 69A. This
Well,
is
I do not know, my lord, what is treated unlawful, in which context, under what
kindly see
circumstances.
page 12.
That is why if you had given a copy 2
I
days,
know.
2 days.
I. Well, page
Yeah,
12
Learned
says,
SG would have replied.
a lady drove her car on a railway track, causing halting of trains. Incident happened near Shankarpalli, Telangana. My lord, it makes interesting news.
Obviously.
What's wrong? What's unlawful about it?
That
is the question. This is how, my lord, provisions of the IT Act are misused.
We'll see. Yes. Yes. Sir, when do you want?
My
My lord, can it be on 8th, subject to your lordship's convenience?
8th Tuesday.
Yes,
Yes.
my lord.
8th at 12 p.m.
Very
Yes.
Please,
We'll finish off on that day.
12 noon.
Yes.
Yes. The pleadings are complete, I suppose.
Yes, my lord, pleadings are all complete.
And a short synopsis or list of authorities if you are wanting by.
Also we'll file.
By in the next 2 days.
We will file, my lord.
In the next
And, my
2
lord,
days,
we
if you
would
file over
oppose
the weekend,
any-
I'll also go through the file
Yes.
and we can.
And
We
we
will.
would oppose, my lord, any impediment, Lord.
Yes, sir, you can
Twitter
file your
is-
objections.
Already
I have
filed.
not,
Yes,
I have
yes,
not
but
allowed that
Twitter is a
application. It will be
responsible
considered
commission.
along with the main
They
matter.
don't need crutches of strangers, my lord, to come and help
We are
them.
not strangers, not, we are the bulwark of news. If your lordship just see the list, I'm not arguing on merits.
Yes.
The list of members, your lordship will see the cross section
I will see.
of all reporting, including legal report.
So they're entitled to file objections or object to it. Yes.
They want intervening, my lord. I don't take sides. But, my lord, if noble thoughts are coming from any side, I think it is welcome.
That's all.
No, my lord, I think, my lord, Twitter
Is
Twitter
going-
as an
is going
international
back to
company
Gita.
should not have played such.
No, my lord, I'm
tricks,
going
my lord.
noble thoughts come
I'm
from-
going back to the Vedas.
All right.
Rig Veda, my lord.
Rig Veda, correct. Yeah, correct. It's Rig Veda.
Rig Veda.
Yes.
Now,
on-
generating light is always welcome, but in
Yes.
such implement applications, it is generating heat, which is more problematic. Therefore, we are opposing. Veda
They are not
doesn't say
asking
about
for implementing,
Senior
generating.
they're
counsel
asking for,
Aditya Soni is appearing, so.
he is asking for intervention, not impleading, I suppose.
Intervention. anyway,
Intervention.
yes.
Well, why
He-
should Twitter argue on his behalf? My lord? Twitter should not have even brought him here.
Lordships in a matter of larger public importance can also call upon my lord's assistance if needed.
Well, see, it's up to the court.
Lordships.
Yes,
We will also file a short note, my lord.
yes, whatever.
Great.
Yes. So 8th will take it, sir.
Yes, my lord.
8th at 12 PM.
12.
The understanding
Grateful
is
to you.
it will be heard finally.
Yes, yes, my lord. Grateful to you.
Heard the learned senior counsel, KG Raghavan, learned Solicitor General of India, Tushar Mehta, and additional Solicitor General of India, Arvind Kamath, along with the learned senior counsel, Aditya Sondi, who represents the interveners in the case at hand, lists the matter on the learned Solicitor General of India submits that objections would be necessary for the intervening application.
No, it has been filed.
Already filed.
We have filed. We have already
Objections
filed.
to the intervening application has already been filed. Therefore, the pleadings are now complete. List the matter on 8th at 12 PM. The understanding, if a further hearing, the understanding is that the matter would be heard and disposed. Would be heard finally. Yes.
Grateful to you. Lord.
Yes.
Let's continue. 26.
Only consider the representation. The notification, compensation.
Madam, list ಕೊಡಿ, list. Yes, sir.
Page number 455. We consider the representation.
One minute. Seal number 20,
6.
26.
rectification of office objections. In representation, na?
Consider.
Yes.
Close. Office objection stands overruled. The petitioner is before this court seeking the following. ಇದು ಯಾವ್ದು ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್? 26 ಮುನಿಯಪ್ಪ ಅದೇನಾ?
ಹೌದು ಸರ್, ಅದೇ ಅದೇ.
Yes, Dhanraj. Is before this court seeking the following prayer.
47 prayer.
Page 47. Then representation for what?
For compensation ಕೊಟ್ಟಿಲ್ಲ 2 ಎಕರೆ 4 ಗುಂಟೆ
Acquisition.
acquisition ಆಗಿದೆ.
The
2000
representation of the petitioner is for the purpose of demand of compensation for the acquisition of 2 acres and
2 acres 4.5 guntas.
2 acres 4.5 guntas in Delhi.
ಇನ್ನು
2 acres 2.5 ಅಂತ ಇದ್ರಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ಸರ್.
ಅಲ್ಲ,
Representation ಅಲ್ಲಿ.
2 acres 2.5 guntas in.
ಕಾಡು
The
ಜಕ್ಕನಹಳ್ಳಿ
ಜಕ್ಕನಹಳ್ಳಿ village.
The representation narrates the acquisition and narrates the acquisition and all other necessities for claim of compensation by the petitioner. The learned counsel for the respondent submits that if reasonable time is granted, the representation of the petitioner would be considered strict consonance with law and appropriate orders would be passed. In the light of the said submission of the learned counsel for the petitioner, without going into the merit of the claim of the petitioner with regard to compensation, I deem it appropriate to dispose the petition with a direction to the respondent to consider the representation so filed on 8/1/2025 and pass necessary orders in accordance with law within 3 months from the date of receipt of the copy of the order and communicate the order so passed to the petitioner. All other contentions remain open.
27.
It's in 27. It seems there is a big history, my lords, of course.
ಇದರಲ್ಲೆಲ್ಲ ಅದೇನೆ.
My lords, acquisition is of 86. Only point today is, my lords, Annexure A is a denotification which apparently has not been brought to the notice of the.
And I have next week, my lordship.
Yeah.
Respond number 3, council, my lordship.
Who are you, sir?
Respond number 3, my lordship.
Beneficiary, my lords, they are the
Society, my lords.
beneficiaries, society. But my lords, Annexure A, the government, if they say whether that is because in their statement of objections, the society says this notification is not valid, or they don't say it's valid, they say it's a forged document.
Now
Annexure A.
notification, government
Annex-
says.
So the government has to answer whether it's a denotification or.
Yes, sir.
We have passed, my lord, I have also sought for instruction. As per my instruction, they have given one notification which is printed. But other respondent herein has taken a contention that that notification is not published in the books of.
ಏನ್ ಪಬ್ಲಿಷ್ ಯಾವ ಬುಕ್ ಅಲ್ಲಿ ಗೆಜೆಟ್ ಆಗಿದ್ಯಾ ಇಲ್ಲ?
Gazette ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Because it says it is sent to the Gazette, and 48(1), my lords,
ಯಾರು ಗವಿಪುರಂ ಎಕ್ಸ್ಟೆನ್ಷನ್
please,
ಹೌಸ್ ಬಿಲ್ಡಿಂಗ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ.
because of course.
But the
Gazette ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
learned senior counsel K. N. Panindra appearing for the petitioner. The learned senior counsel would submit that the government has to steer clear the problem with regard to issuance of the notification on 3/9/1993. As the contention of the Kavit respondent number 3 is that the said notification is a forged document.
It is there in the file.
Alla,
also.
is a forged is a forged document or a non-existent document. According to them, the said notification is never gazetted. Therefore, the respondent state shall now place on record as to whether the notification dated 3/9/1993 has been gazetted. Notification anta ide, has been gazetted or otherwise, as the notification itself would indicate that it is sent to the official gazette. Complier. ಏನೇನ್ ಬೇಕಿಲ್ಲ ಇದೆಯಲ್ಲ?
Allide.
Come to page 42 ಅಲ್ಲಿ
That is
ಇದೆಯಲ್ಲ?
our stand, but in the statement of objections, they say there is no such, because there are about 4 writ petitions. Nobody has brought to the notice that there is a denotification.
Subsequent to this, my lord, there was 2 writ petitions.
The government shall file its objections by the next date list on, ಯಾರು ಹಾಕಿದ್ದಾರೆ? ಇವ್ರು ಹಾಕಿದಾರ?
Only
List
3.
on 15th. Yes.
28.
My lords, I appear for the respondent BDA. Before my learned friend begins, I have a request, my lords. Can this be taken up next Tuesday, my lords? I'll file my statement of objections. It's ready. I have sent it for
No.
sign.
The learned counsel appearing for the respondent seeks Vinayak. Learned counsel appearing for the respondent Vinayak seeks 2 weeks' time to file statement of objections. Objections, if any, by the next date, list the matter on 15th.
Much obliged.
Yes, next.
29.
Lords, this matter, my lords, I apologize. I was unable to complete my instructions. Partition may kindly have it next Tuesday, my lords. I shall file my objections.
My lords, they had to only verify whether the scheme, because this court has already held the scheme has lapsed.
Correct.
At page 49.
I'm aware, my lords, it's covered by a judgment of the court. I shall formally file
But
my
under
objections.
clause man.
I shall formally file my objection next
But the
Tuesday.
learned senior counsel K. N. Panindra appearing for the petitioner. The learned senior counsel would submit that the issue in the list stands answered by plethora of judgments rendered by this court, as the scheme has lapsed due to effects of time. The learned counsel for the BDA na?
Please, my lord.
BDA finally seeks 10 days time to file statement of objections. Objections, if any, by the 15th, failing which the petition will have to be answered following the judgments of the coordinate benches.
Obliged.
Yes.
30?
Entry matter.
8, because the
15.
urgency is there. Is a-
15.
Yes, please.
None appears. 25. There was no representation on 25/4/2025. Even today, there is no representation by the petitioner. As a last chance, list the matter on 15th. In the event there would be no representation, the petition would be dismissed for its non-prosecution. Yes,
31.
next.
The last occasion, your lordships had asked interstate between the.
Well, this is his
That
partition.
between brother, sister, brothers,
Brother.
brother and sisters.
Well, I want to place one.
I have heard it. ಕೇಳಿದ್ನ ಮುಂಚೆ ಇಲ್ಲಲ್ಲ?
ಸ್ವಲ್ಪ ಕೇಳಿದ್ರಿ. ಅದೇ ಟ್ರಯಲಾಗ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ.
Your lordships had said, my lord.
Oh, I have passed a detailed order.
ಹೌದು ಹೌದು ತಾ ಮಾಡಿದಿರಿ.
ಅಲ್ಲಿ
ಕೋರ್ಮಂಗ್ಲ 5080.
ಹೌದು 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 ಹೌದು.
ultimate
ಅದು ನಾನು ಒಂದು ಲೀಗಲ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ
4 ಭಾಗ ಅದ್ರಲ್ಲಿ ಮಾಡಕ್ಕೆ.
ನಾವು ಡಿಸ್ಕಸ್ ಮಾಡಿದಾಗ 8:30
8 ಕೋಟಿ.
Well, I want to place a legal submission.
Yes, sir.
And I'm supported by authorities, my lord, I will place that and then, my lord, I am in hands of the court. My lord, the suit is for a partition. My lord, this is a self-acquired property of the father. Father died, my lord, and now the mother and the daughters and the son are the heirs, and therefore, my lord, each of them gets 1/4. There is no difficulty about it. Now, my lord, the problem comes at the stage of the final decree proceedings. Final decree proceedings, my lord, were filed with an, now that's important, my lord, in 2011, with an application for sale of the property by the plaintiffs, who are the respondents here. Then, my lord, on that, an order is passed appointing a court commissioner. Your lordships may look at the report of the court commissioner, my lord, which is available at page number 120.
Now you want to buy the property.
My lord, no, my lord, there is a difficulty. No, my lord, the difficulty, my lord, is.
No, that's what I think.
Yes, yes.
Sindhu
No,
appeared
I
and
tell you, lordship. my
left
lord,
no
buy-
stone
my lord,
unturned, taking the court to partnership act.
No, my lord, the buying of the, no, just one minute.
Yes, yes.
Buying of the property is not an issue. Now the question, my lord, is how under the statute that buying as between co-sharers has to be regulated. That's the issue, my lord. And the question, my lord, is
Section 3.
yes, that is the point, my lord. If section 3 is therefore a direction to the court, and in this case, admittedly, my lord, section 3 has not been followed. Admitted, there is no difficulty about it. That is the point I want to place for your
So
lordship's
if the
consideration.
co-sharer wants to buy the property, he
Yes.
should be given first preference.
Give it and please
Later
value
on,
it.
put the property to action. That's what.
And please value the property in accordance with section 3.
Eight-
Therefore, my lord, the question
The
of,
property is worth 8 crores.
my lord, property according to the report of the commissioner is worth, my lord, 5 crores 36 lakhs 32,200. Your lordships may kindly look at the valuation report. If your lordships are kind enough to turn, my lord.
No, but another co-sharer, ready
Yes.
and willing to buy at 8 crores.
That is not, if that co-sharer says, I want the property to be sold, the co-sharer, my lord, now came and said, I want the property to be sold. The co-sharer doesn't want to buy. The no, my lord, let me complete. The co-sharer already has taken a stand that the property must be sold. That is why, my lord, I want to take your lordship to the sequence. I will show to your lordship that the co-sharer says, I want this property to be sold and the proceeds to be distributed. Now, at that situation, the defendant comes and says, I am willing to buy the property. In a situation where one of the co-sharers comes and says, I want to buy the property, how should the court proceed in the matter? This is the question, my lord, that is before your lordship. Can the court say, I will do an auction inter-se between you, and whoever bids highest inter-se between the two of you can buy the property? That is impermissible, my lord. That is the mandate of section 3, not in respect to the parties. That is a mandate to the court. Now, can that be flouted is the only question that I want to place for your lordship's consideration.
No, that's why I passed a detailed order last time.
I know, my lord. Your lordship did. Your lordship
Section
did.
2 and 3.
Yes, my
both
lord.
are
And then your
considered.
lordships felt that if a trialogue is possible,
That's all.
between mother, daughters, and
ಅದಕ್ಕೆ have a trialogue and
the trialogue. ಅದೇನೋ ಆಗಿಲ್ವಂತೆ, so my lord. ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, trialogue ಆಯ್ತು. But the outcome of the trialogue ಏನಿಲ್ಲ. ಅಷ್ಟೇ.
Yes.
So, my lord, therefore, let me place the facts on the legal submission, my lord, then I'm in your lordship's hands too.
Yes.
Now, my lord, I want your lordship to be kind enough to see, my lord, the report of the commissioner, which is at page 122.
On synopsis ಹಾಕಿದ್ರಲ್ಲ last. You had filed some
But
synopsis.
ಅದಲ್ಲೇ, there are a few things that I want to point out.
ಹಾಕಿದ್ದೆ ಅಲ್ಲ,
Yeah.
I had filed
synopsis
one.
I find.
WP ಅಂತ ಹೇಳಿ ನೋಡಿ
List of documents and citations with.
ಇದೊಂದು
Sindhu, you have filed it.
Yes, sir.
ನೋಡಿ ಇದೊಂದು
List of documents.
List of documents ಅಂತ ಹಾಕಿದ್ದಾರೆ.
There's no synopsis. Anyway,
ಇಲ್ಲ.
yes.
My lord, if your lordship will take the writ petition, my lord, I just want to point out your lordships a few things. My lord, kindly turn to page 122.
Oh, instead of going back to history.
Yes.
The only issue is interpretation of.
No,
two
my lord,
and
there
three.
are some history is required for the purpose of making the point that I want to place for your lordship's consideration
All
on
right.
it as a question of law.
All right.
That is the reason why, my lord, because the law seems to be that section 3 is a direction to the court and that it is mandatory that section 3 should be followed.
Yes.
And now the question is, has section 3 been followed? If section 3 is not followed, my lord, then I respectfully submit, my lord, that in law I am entitled to the relief prayed for. My lord, may I request your lordship to kindly turn to the valuation report that your lordship will find at page 125.
So the crux of your submission is, it should not be put to auction.
No.
The court should give an option under section 3 to a co-sharer if he is willing to buy the property first.
Yes.
And once the other co-sharer has said the property should be sold, he will not become entitled to say that I am going to buy the
kindly see
property.
section 3 for a
That is your
Kindly
submission?
see section 3 for
No,
a
that
minute.
is your submission?
My lord, please see section 3 of the partition.
Yes. You had given a printout of that. Partnership Act
Yes. Give me my.
on printout ಕೊಟ್ಟಿದ್ರು last.
How? Yeah, fortunately, my lord, this is one of those statutes where there are only 4 or 5 sections.
That's fine. Very
So,
printout, yes.
yeah, though it's a very convenient statute.
Out to the back. That is out to the back.
Okay, it is for especially for us, where only 3 or 4 sections here.
ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ 3 ಕನ್ವಿನಿಯೆಂಟ್ ಆಗಿದೆ ಈಗ.
ಓದಕ್ಕೆ ಜಾಸ್ತಿ ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ. ಅದು ನನಗೆ ಫೇವರ್ ಆಗಿದ್ಯೋ ಇಲ್ವೋ ಅದು ತಾವು ಹೇಳ್ತೀವಿ.
Yes.
But
Procedure when sharer undertakes to
kindly
buy.
see section 3, my lord.
Yes, sir.
If in any case in which the court is requested under the last foregoing section to direct a sale, which the plaintiffs did,
Yes.
any other shareholder applies for leave to buy at a valuation, the share or shares of the property or parties asking for sale,
Yes.
the court shall order a valuation of the share or shares in such manner as it may think fit, and offer to sell the same to such shareholder at the price so ascertained, and may give all necessary and proper directions in that behalf. If 2 or more shareholders severally apply for leave to buy as provided in subsection, that doesn't arise, my lord, here. If no such shareholder is being, doesn't apply. Now, therefore, if the court is requested under the last foregoing section to direct a sale, that's what the plaintiffs requested the court. Any other shareholder, namely the petitioner before your lordship, the son, applies for leave to buy at a valuation, the share or shares of the property of the party or parties asking for sale, the court shall order. Your lordships may mark the word shall. There seems to be, my lord, according to the case law, no option by to the court, excepting to order a valuation afterwards. After this process of one party coming and saying, please sell, the other sharer coming and saying, I want to buy, at that stage, there should be a valuation. Admittedly not done.
ಅಲ್ಲ valuation ಇದೆ ಅಂದ್ರಲ್ಲ.
No, that was earlier.
Now at this point in
At
time, you
this
want
point,
valuation.
yes, that's the point, my lord. When one sharer says sell the property, another sharer says I want to buy the property, then the only course for the court to do is to order a valuation. The valuation that was done, no, my lord, that's why I wanted to point out here what happened in this case. Now, please permit me, my lord, just quickly to run your lordships through the facts of the case. My lord, along with the FDP, an application was filed for sale of the property. So, my lord, at that point of time itself, the plaintiffs' decree holders made their mind clear that they do not want to buy the property, that they should sell the property. For whatever reason, my lord, at that point of time, there was no offer from the son saying, I want to buy the property. But in spite of it, the court, my lord, appointed a court commissioner for the purpose of valuing the property. And well, my lord, that what is the legal value of that valuation report? My lord, under the Partition Act, I don't see any value.
Yes.
So that valuation report. Now, please look at, my lord, that valuation report which begins at page 122, and what is relevant for your lordship's consideration, my lord, is is at page 125.
125.
Yes, my lord. Of the writ petition, my lord.
Yes.
Would your lordships be kind enough to turn to page 127?
Yes.
Therefore, I ascertain the warrant schedule property value is about 5 crores 36 lakhs 32,200.
Building value, final
Yeah, now
valuation.
whatever, man. The valuation is given at that.
Public auction is for that value.
No, this is just a valuation.
No, public auction notice at 129.
No, my lord, yes, my lord. Then I'll come to I'll come to that, my lord. Then what happens, my lord, is on 20th of February 2013, a memo is filed by all the plaintiffs for sale of the property.
Page.
In the compilation which is filed on 29 4.
Give me that. My lord, at page 6 of the compilation that was filed before my lord on 29th of
Memo
April.
regarding commissioners. Yes.
Your lord, the commissioner has submitted a report stating that the suit schedule property cannot be divided in 4 equal shares, which
Correct.
involves demolition of existing structure.
Yes.
The petitioner also having reservations for any physical partition of the property, and therefore all the 3 petitioners.
Now, what do you want? That matter should be remitted back for the procedure to be followed under section 3.
Yes. I'm saying that that here is my offer. I am willing to buy. Now we have come to the stage
Your
of
different
section
number?
3. I am the defendant, my lord. I am
Only
the sole
different.
defendant.
Sold
Sole
it. Yes.
I am saying I am willing to buy. Now, therefore, we have come to the stage of section 3. In section 3, follow the procedure prescribed under section 3. No difficulty. Whatever is the valuation, my lord, if I am willing to buy at that value.
So you want a revaluation of the property as on today and
In
procedure.
terms of section 3.
Correct. And procedure to be followed under section 3.
Yes, that's right.
Whoever is willing to buy first, and not the plaintiffs, because they've already.
They've already expressed their intention to not to buy the property. So, my lord, once I offer under section 3, it is the court shall order a sale of the share or shares of the shareholder who offers to pay the highest price above the valuation made by the court. That, my lord, your lordship may kindly now see the.
Now, for a plaintiff, when he says that sell the property, that is over. He cannot go back on that and say that I would want to buy.
No, because we have come to the next stage, section 3. Kindly see section 3, my lord, for a minute. That's exactly the position. If your lordship reads section 2 and section 3, the point I'm making, my lord,
correct,
may become clear.
Power of the court to order sale.
Yes. Whenever in any suit for partition, in which if instituted prior to the commencement of the society, a decree for partition might have been made, it appears to the court that by reason of the nature of the property to which the suit relates, or of the number of the shareholders therein, of any other special circumstance, a division of the property cannot reasonably and conveniently be made, and that the sale of the property and distribution of the proceeds would be more beneficial for all the shareholders. The court may, if it thinks fit, on the request of any of such shareholders interested individually or collectively, to the extent of 1 moiety or upwards, because they are 1 moiety,
yes,
they are 3/4, therefore they are more than 1 moiety, or upwards, direct a sale of the property and a distribution of the proceeds. Now, for this purpose, the valuation was made, which came to 5 crores 63 lakhs. Now, at that stage, I step in and say, I am now willing to buy. That is why, my lord, kindly see the opening words of section 3.
Correct.
If
In any case which the court is requested.
Yes.
All right.
I have said I am willing to buy. Now, if I am willing to buy, they are wanting to sell, and therefore they want a valuation. Then, my lord, what should the court do? It is not the valuation under section 2. It is a fresh valuation under section 3. There are 2 valuations, my lord. Now the valuation is under section 2. That's over now. That is behind us. Now we have a valuation, my lord, which is required to be done.
2 and 3 speak of different valuations.
Different valuations.
According to you. We'll hear
Yes.
the other side.
And, my lord, I want to place 2 authorities, my lord, at them.
Authorities. Sir.
Yes. My lord, please be kind enough. My lord, the first one, my lord, is the judgment of this honorable court. Would your lordship be kind enough to turn, my lord, to page 5? After having, my lord, looked at the provisions of section 2 and 3 of the Partition Act, at page 5, the scheme of sections 2 and 3, your lordship got it?
Yes, yes.
The scheme of sections 2 and 3 apparently is that if the nature of the property is such or the number of shareholders is so many, or if there is any other special circumstance and a division of the property cannot reasonably or conveniently be made, the court can, in its discretion, on the request of any of the shareholders, interested individually or collectively to the extent of one moiety or upwards, direct a sale of the property and distribute the proceeds among the shareholders. Now, where the court has been requested under section 2 to direct a sale, any other shareholder can apply for leave to buy at a valuation the share or shares of the party or parties asking for sale. In such a situation, it has been made obligatory that the court shall order a valuation of the share or shares and offer to sell the same to the shareholder who has applied for leave to buy the shares at a price ascertained by the court. So, my lord, the position appears to be that this is an obligatory provision under section 3. And I filed a memo before the court that I am willing to buy at the valuation as determined by the court even under section 2. I have no objection if the valuation is to be done afresh in terms of section 3. If the property value, my lord, is more, it's more, so be it. But the question, my lord, is as to whether a valuation that has been done under section 2 can be used for the purpose of section 3.
Yes.
And if it is so, my lord, in fact, I benefit. Because under section, the valuation under section 2 was only 5 crores 63 lakhs. Maybe if the valuation is made under section 3, the valuation may be higher. Whatever it is, my lord. Then, my lord, your lordship may kindly see the next judgment. Kindly turn to page number 33, my lord. Lord, may I trouble your lordship to kindly see para 34. This is a judgment, my lord, of the Honorable Rajasthan High Court.
One was here also.
My lord?
One was here also.
Yes. Yes, man, I know. Yes, man. Kindly see para 34. The application under section 3 and 4 of the Partition Act, giving preemptive right to co-sharers to purchase a share of a party who is not the member of the family, who has asked for division and partition of the property by metes and bounds, and such a division cannot reasonably and conveniently be made, and the court directs such sale of property, such co-sharer can exercise his right under section 3 of the Act at any stage of litigation in a partition suit from its inception till its termination. And the mandate of section 3 of the Act is that the court shall direct the valuation of the property so as to determine the valuation of the share or shares of the party asking for sale and offer the same to such shareholder at a price so ascertained so as to achieve the object of the Act itself enshrined in the said provision, namely having regard to the strong attachment of the people in this country to the landed possession, to give opportunity to such co-sharers to exercise his preemptive right to purchase a share of the property asking for sale. The power given to the court under section 3 is discretionary one to be exercised on consideration of circumstances of the case. Such preemptive right is an equitable right and therefore can be defeated by circumstances like waiver, acquiescence, etc. There is no such thing in this case. Then, my lord, I request your lordship to kindly see the next judgment, which is at page 50.
Yes.
My lord, kindly see, my lord, page 49 onwards, para 6.
Yes.
The purpose, according to the Honorable Apex Court, underlying section 2 appears to be to prevent the property falling into the hands of third parties if that can be done in a reasonable manner. It would appear from the objects and reasons of the enactment of the Partition Act that as the law stood, the court was bound to give a share to each party and could not direct sale or division of the property. It is in this regard the statement of objects and reasons are relevant and they are reproduced below. That is extracted, my lord. I will kindly see, my lord, the last line at page 50.
Yes.
It is proposed to make the consent of the parties interested at least to the extent of a moiety in the property a condition precedent to exercise by the court of this new power. In order at the same time to prevent any oppressive exercise of this privilege, it is proposed to give such of the shareholders as to not desire a sale the right to buy the others out at a valuation to be determined by the court. The power, moreover, which it is proposed to give to the court will be discretionary one to be exercised on the consideration of all the circumstances of the case. It should be added that where the court is obliged to direct a sale, a right of preemption is given by the bill to the parties similar to that conferred on shareholders by section 310. Now, my lord, please be kind enough to turn to page 52.
Yes.
The decision rendered in Ramurthy
has been subsequently laid down by the Honorable Apex Court. In the case of Rani Aloka versus so and so, sections 2, 3, 6 and 7 of the Partition Act have been discussed at length in the said decision. What is ultimately held in Rani Aloka is that in a case where section 2 and 3 of the Partition Act are invoked, the court is bound to comply with the mandatory provisions and it has no power to direct sale of the property and dehorse the mandatory provisions of the above act. This is the emphasis, my lord, that I want to place for your lordship's kind consideration.
Yes.
Anything else? My lord, there are other judgments, my lord. I'm not going to detain your lordship's reading that. Serial numbers 4, 5, or 5 to 7 are all, my lord, on the same point.
Straight away, come to para 53 and 54 of Rani Alok.
My lord,
Page 53, para 53, 54
Yes,
at
yes.
page 104, 102, 103.
Yes. My lord, yes.
Yes, sir.
So, para 53, my lord. Lordship, sir. Subsection 2 of section 3 mandates valuation to be made by the
Same
court.
what is followed by Justice A.V. Chandrasekhar.
Yeah, exactly. Exactly. Therefore, my lord, my respect to
I have
submission.
seen
is-
all.
Yes. Now, my lord, kindly see what happens now. If the your lordships ask me a question, is the valuation under 3.1, can it be used for 3.2 or should a separate valuation be made? I would think, my lord, 3.1 valuation in the instant case is 5 crores 36 lakhs. The 3.2, I am willing to buy at 5 crores 36 lakhs, no difficulty.
It
I am
may be
willing
more, it may be more now, you are willing
Maybe
to buy.
more, I am willing to buy.
My lord, 8 crores, my lord,
There's
was,
one- No, my lord, they are not, the valuation has to be done by the court. That is the point, my lord. There cannot be an inter se auction between the parties. If that is not the procedure contemplated under section 3 of the Partition Act. It is a matter regulated mandatorily and obligatory for the court to follow under section 3.2.
Now come to page 79 in the list of judgments,
My lord.
paragraph 17 there.
Yes, my lord. Yes, my lord. 79,
70
paragraph 17.
Page 79, para 17.
Yes, my lord. In short, neither in substance nor in form, any request within the purview of section 2 had been made by any of the, we had made a request, my lord. We have filed a memo.
Oh,
itself.
that's all.
We have done. That condition precedent for invoking section 3 was lacking in that case.
So once you have made under section 2, you have made you filed a memo, whatever.
Yes, we
it
did.
is.
The court said,
Now,
please indicate the
that-
value.
On the valuation that was already there,
Yes, we did.
you have filed a memo that
Yes.
you are willing to buy.
Yes.
Section 3 contemplates a fresh valuation.
Correct, madam.
Now,
Please do
the
it.
court should hold a fresh valuation
Exactly.
and then ask the part
Yeah,
to
exactly.
you. what-
Exactly. That is what I'm saying. There cannot be therefore a inter se bidding between the parties and say, well, I am willing to pay 8 crores to 40. No, that's the valuation. No.
According
The-
to you, plaintiffs have lost their right to say
They have
so
lost
because-
their right. Now it is for the court to ascertain the valuation. This is my.
Yes, Ashton.
my lord, please look at the conduct.
Conduct.
Yes, I'll tell your lordship why. Please take, my lord, my note. Now, continue. Please have a look at it. Property bearing, my lord, number 5 belonged to Mr. Satish. 1, he died intestate, leaving, my lord, behind him his wife, son, 2 daughters. Petitioner before your lordship is in Bahrain for the last
Bahrain,
20
correct.
years.
Yes.
Anyway, he is not residing here. Affidavit, my lord, wife was residing here. The petitioner, my lord, did not agree to partition. Ultimately, mother and sister had to file a suit. When was the suit filed? 2003. Mother has been struggling. There is an order passed by your lordship's court to direct him to pay, my lord, 2 lakhs to the mother. Not
Also
one
is
penny.
not paid, yes.
Not 1 penny is paid. Not 1 rupee is paid. And, my lord, he is in Bahrain. Very, my lord, cushy job, pocket full of money, and yet he does not want to share it. He does not want, my lord, to have an equitable share. Then, my lord, trial court, please look at, my lord, the paragraph 20 and 21. Trial court has considered this. If your lordship look at the order, then, my lord, what has happened is there was, my lord, in the court, we offered, my lord, the 3.2 was invoked. We offered, my lord, 7 crores 20 lakhs.
No, one clarification, sir. Now, as plaintiffs, did you give up your right to buy
No, my
the
lord.
property?
No.
That's a submission made.
Because
on the memo of the commissioner's report, you say let the property be put to sale.
if your lordship, my lord, look at the trialogue that your lordship's ordered,
Yes,
my lord, we have filed a memo.
yes.
When did you file this? Last date of hearing, it was filed. My lord, small, short memo was filed. Please come to page 2.
I have noticed that memo.
Yes. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ? 8 ಕೋಲ್ ಅಂತ ಹೇಳಿ. Last page ಬನ್ನಿ ಸ್ವಾಮಿ.
Yes.
4. At this juncture, Kodige offered to pay 8 crore 60 lakhs to the scheduled property, one of the sharers. 3-2, my lord, came into existence. Moreover, what has happened is, in the court, my lord, page 79, if your lordships look at, with the writ petition, 75.
Yes.
6 crores, my lord, 80 lakhs.
No, I have captured that
That's
also.
all, I know that.
640, 680,
I know.
and now it's
My lord,
720.
I must say, your lordship's memory, my lord, is something phenomenal.
Right.
I don't know how your lordships will are able to scanning and petitioner challenges, my lord. What has happened is, my lord, when plea was rejected, my lord, what happened was, he, my lord, claimed adverse possession. If your lordship come to, my lord,
yes,
serial number 4,
yes.
Look at the conduct. Is not, my lord, writ petition a discretionary remedy, my lord? I ask myself. When the conduct of a person, my lord, is atrocious, your lordships will decline to, my lord, interfere. My lord, even in case, my lord, he has the excellent case.
There is only one clarification.
Please, my lord.
Can discretionary relief? Yes. Can a conduct of a party, militate against the mandate of the statute?
Yes, my lord. Because writ petition is a discretionary remedy.
That I'm aware, sir. Yes, that we will.
Even, my lord,
Now,
the best.
Mandate of the statute is not followed, is what is said.
My submission
So
is
the
mandate of
conduct would defeat the petition itself being entertained without going into the mandate of the statute.
My lord, my submission to your lordships is, first of all, my lord, the mandate of law itself, my lord, is, please look at 3.2.
Yes.
Let's look at 3.2, my lord.
The proviso there.
Yes.
Yes. If 2 or more shareholders
Correct. Correct. My lord, we made 1 and 3, my lord, came before the court. They, my lord, hold the majority. They said, we'll purchase it. And we, my lord, offered, my lord, as your lordship saw, my lord, in page 73. Morning session, respondents, my lord, he files. Afternoon session, my lord, we file, my lord, saying that we are prepared.
Yes, 640, 680, 720 finally. Yes.
And thereafter, my lord, when all this, my lord, he was not willing.
And now before me, 8 crores.
8 crores. And he wants, my lord, at 5 crores. And please look at this. My submission to your lordships is, even, my lord, the best of the cases, conduct has to be looked into. 23 years, my lord, are over. Mother, my lord, is languishing. Sisters are languishing. Mother ultimately, my lord, passed away without a penny, my lord, being given to her. And, my lord, the son, my lord, is very in a cushy job in Bahrain. My submission to your lordship is 3.2, my lord, was implemented. 3.2, my lord, your lordship's earlier order, my lord.
The court went on increasing the price.
Yes.
On the submissions
between
made by-
intersay between the parties. And that time, my lord, he did not have any objection. 3.2, my lord, was. And then, my lord, can I persuade your lords to look at just one judgment of the Punjab and Haryana High Court?
On 3.2?
3.2, my lord. Paragraph.
It's at page 328,
Yes,
I guess.
Yes, 328.
The next question, argued defendant agreed with the.
My lord, that's why I said, your lordship's ability to scan and, my lord, come to the correct thing is something phenomenal. I don't know, we'll all have to, my lord, come to your lordships, try to learn, my lord, how your lordships do it.
Yes, sir.
Merely because, my lord, 2 is invoked, my lord, doesn't mean 3, my lord, doesn't come into.
That is what is said.
Correct,
Yes.
correct.
So long as the property is not sold, any co-sharer can make an application under section 3 of the Act.
Yes.
For the purchase of shares, those who want the same to be sold. Of the shares of those who want the same to be sold.
Correct.
So it includes you also.
Correct.
Is what you're submitting.
Correct. Therefore, my lord, my submission to your lordships is, first of all, my lord, 3.2, my lord, has been invoked. We, my lord, said, my lord, we will buy it. He did not, my lord, offer any higher price. Therefore, my lord, we ought to have got it, my lord, at 7 crores 20 lakhs.
Because there is interpretation here. On a plain reading of these two sections, 2 and 3 at page 327.
Correct.
And the finding is at 329.
That's right, my lord. ತಾವು ನೋಡಿರ್ತೀನಿ ನಾನು ಅದನ್ನ ಮುಂದೆ ಓದ್ಲಿಲ್ಲ. ಇಲ್ಲ ತಾವು blood, your
Now
ability to scan and blood correct, come to the correct paragraph is something. Therefore, my lord,
Yes, sir. In bail,
Lord,
any other judgment?
Even the best of the things, you know, I told
Because they have given plethora of them.
my lord, please have a look at the plethora of judgments, my lord. Let
Yes.
us have a look at it. It's, my lord, fully distinguishable, and my learned friend will give one judgment, my lord, Mr. Jowli. Please have a look at, please come to, my lord, page 5, which my learned friend said. First judgment of Justice Dinesh Kumar.
Yes, sir.
3-2, my lord, was not, what the, my lord, the learned judge has held is, scheme of section 2-3 apparently is that if the nature of the property is such that a number of shareholders is so many, or if there is any other special circumstance and the division of the property cannot reasonably or conveniently be made, the court can, in its discretion on the request of any of the shareholders interested individually or collectively to the extent of 1 moiety or upwards, direct the sale of the property, distribute the sale proceeds. Idralli, we hold, my lord, 3/4. He holds, my lord, 25%.
Correct.
Therefore, my lord,
You are major shareholder.
this judgment doesn't apply. Then, my lord, the second judgment which my learned friend referred to, my lord, is at page 34. 33, my lord, it starts at 7. 34, my lord, my learned friend read to. That also, my lord, has 3 and 4.
Yes.
Applicants are not completing the sale within a reasonable period. All that.
The
Previous paragraph.
entire fulcrum of the submission is that court has not followed procedure under section 3 and got a revaluation done. Now you have filed a memo where I have captured it saying the court went on increasing the value. What is that? What is that?
My lord,
that's the valuation.
Ultimately, my lord, is it not a valuation? I ask, what is a valuation, my lord? Valuation is one. Whoever is the willing purchaser and willing buyer, that's, my lord, valuation.
No, that valuation is done. I sitting here will not evaluate the valuation.
No, my lord, not your lordship.
Yes.
There was, that's why, my lord, your lordship directed trial town, where 8 crores, my lord, 60 lakhs was offered. And of course, my learned friend's client, my lord, does not want it. He wants it at 5 crores.
No, now if a fresh valuation is done, he is willing to buy for more.
I know that.
Yes, Ashtala, sir. Even the end
And
court
section 2 also is more beneficial.
I want to, if my learned friend finished.
Division bench of this court.
He is also there.
He's a very.
Our 8 crores, higher than all. Raghavan sir.
No, I didn't know, I'm sorry.
Allah, he's there. He's at 8 crores, his highest. Yes.
Your lordship, division bench of this court.
If it is adjourned by 1 more week,
It
it
will
will
be
become
60.
9 crores.
I will
But
offer,
is that the way in which it is done under the statute?
I will offer 10 crores right now.
That's what I'm saying.
Done with it.
Anyway, he doesn't want to, my lord, he
At
does
the
not
end
want
of the day,
equitable.
all should get a proper share.
Ultimately, my lord, equity is what is needed. Justice is, my lord, what meant. Courts are meant for justice. He doesn't want all that, my lord. He wants to, my lord, take it at a throwaway price, pocket it, sit in Dubai, sell it, and then, my lord, at 10 crores and make, my lord, another 5.5 crores at our cost.
Yes, sir.
Lordship, division bench judgment. along
Which
with,
one?
RFA 10049.
Page.
Page,
We have filed it separately.
Separately.
Two judgments.
only 2 judgments. Respondent 6.
Respondent number 6.
Put your copy.
ಎಲ್ಲಿದೆ RFA? ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್.
Respondent number 6 ಅಂತ. ಅಂದೇ ಕೊಟ್ಬಿಡಿ.
There is no judgment. Papers ಅಲ್ಲಿ ನೋಡಿ ಅಂತ. ಏನಾಯ್ತು ಇದರಲ್ಲಿ?
That the valuation of the court is only indicative is the issue.
ಅಷ್ಟೇನಾ?
That's what, to that limited. So to harp on that figure would be incorrect.
All right. Now the court has rejected his application. Yes, anything else, sir?
Yes,
My lord, your lordship asked a very pointed question. Have you given up your right to buy the property? And my learned friend's answer was no.
Yes.
On the contrary, please see IN number 7, which has been filed before the trial court by
Page.
plaintiffs 1 and 2. Please be kind enough, my lord, to turn to page 74.
70?
4 of the. ಇದು ಕೊಟ್ಟಿದ್ದೀರಾ ಕೊಡಿ. ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ.
Lord, before he says,
This
can
is
I, my lord,
the
pass on one judgment? Even the most unassailable, my lord, order, writ petition, my lord, liable to be dismissed on the basis of the conduct.
I showed the conduct. I'm going to answer
Paragraph
that
3.
conduct. My lord,
Paragraph 3 of this.
I will answer the conduct also with reference to the order sheet. Please be kind enough to. ಅವ್ರಿಗೆ ಕೊಟ್ರಲ್ಲ ಅದೇ. My lord, kindly see page 74. This is an application filed, my lord, by plaintiffs 1 and 2. For the
Correct.
reason.
Both of them are not ready to
They
purchase
were
the
not.
property.
Therefore, where is the question of saying,
So-
no, we
So
wanted
the property was put to auction.
They were not willing to buy.
That is what.
That's
The
therefore, my
court,
lord.
court records
Yes.
petitioners as well as the respondent. Who is the respondent?
Now,
You are at liberty to purchase the property on the basis of
that is the
valuation.
problem, my lord. Where
But
is
you-
the?
If
where-
both the parties in the suit are not ready to purchase, the property will have to be
But
sold
therefore,
to
that
third.
is the problem, my lord. Therefore, why not? And how can the court now make this type of an order without complying with
Prima
section?
facie, section 3 is complied at page 75.
My lord,
Prima facie.
kindly see section 3 for a minute.
Yes.
My lord, 3.2 was relied upon. 3.2 has not been complied. In fact, 3.2 doesn't apply at all. Please see section 3.2.
No, if we go by punctilious exactitude in observance of procedure in section
Should be done, my
3,
lord. That is the law. I mean, however much we may not be in consonance with
Yes.
what has been said, my lord, but the law appears to be that way, and no discretion appears to have been given to the court insofar as following section 3 is concerned. Now, please see section 3.2 on which reliance is placed.
yes.
If 2 or more shareholders severally apply for leave to buy, on the contrary, in this case, there are three plaintiffs, but not only one. Plaintiff number 2 has not offered anything. It is only plaintiff 1 and plaintiff number 3 who are offering. Now, my lord, if 2 or more shareholders apply for leave to buy, there was no application. On the contrary, the application was, I don't want it. So I ask myself, where is section 3.2 applicable in this case? And that is why, my lord, we are now to follow section 3.1. And what is it that can be done, my lord? Under section 3.1, kindly see the language of section 3.1. To direct a sale or any other shareholder applies for leave to buy at a valuation, the share or shares of the property or parties asking for sale, the court shall order a valuation of the shares in such manner as it may think fit and offer to sell the same to such shareholder at the price so ascertained. My lord, therefore, my lord, to say that the valuation report is simply a opinion.
No, page 75.
Yes. Your lordship may kindly see. This is the order.
During the morning session,
Yes.
files a memo,
Yes.
their counsel, to purchase the property at 680.
Yes.
Afternoon session, advocate for petitioner files a memo,
Yes.
but petitioner 1 and 3 are the respondent.
That is impermissible, is what I am saying.
The what, 7:20. After filing this memo, advocate so and so, the earlier commissioner's report for the purpose,
Yes.
issue warrant to the court to auction the property following
No,
all
that is
procedures.
this is the error, my lord. Can this, once one of the parties who are entitled to a
No,
share.
public auction baralla.
ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ,
Public auction ಬರೋದಿಲ್ಲ, inter auction ಬರೋದಿಲ್ಲ. It should be a valuation to be done by the court, and the property has to be sold at a valuation to be done at such valuation. That, my lord, seems to be the law on the point. And to say, my lord, by conduct, I am entitled, my lord, I think, while on a principle of law, my learned friend is right. My
No,
lord, I
that's
don't-
why what conduct militate
Irrelevant.
against the mandate.
And not only conduct, in this case, there is no such conduct. I can show you not.
2 ಲಕ್ಷ ಕೊಟ್ರಾ?
ಯಾವುದು? ಅದು charge on the property. Kindly
on
see
the
what the
property.
court has said. Kindly see what the court has said on that. Kindly see what the court has said. ಅವರು ಕೊಡ್ಬೇಕು. Have they paid it? Please see what the court has said. My lord, in the, one minute. One minute. My lord, kindly see the,
Mother was not staying with you apparently.
obviously. My lord, kindly see, my lord, what the court has said at page 80.
You are in the Middle East.
Page 80.
Yes.
Page 80, my lord. If it is not paid, it will be a charge on the property. Of course, it will be a charge on the property. There's no difficulty about it. But that is no
When
reason.
was the order passed?
Which one, my lord?
Payment of 2 lakhs.
My lord, this was in 2020, 2021. It will be a charge on the property. Yes, it will be a charge on the property. No difficulty about it. But the point, my lord, is that a ground for saying, even if the law is violated, I will not. I will
That's what-
condone. That's the point.
Conduct would not militate against this
No,
statute.
my lord, conduct will not. And this is, I would say, my lord, I put it in a slightly higher footing. It is a direction not to the parties. This
No,
is
to
a
the court,
direction
you
to the
say.
court. And similar to Section 3 of the Limitation Act. I ask myself, will conduct of the parties militate against the application of Section 3, a direction to the court? No, obviously not. my lord. That is the principle I would place for your lordship's consideration.
Heard, ಎಲ್ಲ senior counsels ಹಾಕಿ, reserved.
Read.
Now your 9 crores also is ready, yeah? 10 crores.
I'm ready for 10 crore.
Market
ಇಲ್ಲ ಇದು ತಾವು ಒಂದು ವಾರ ಅಟೆಂಡ್ ಮಾಡಿ 11 ಕೋಟಿ
Proper share.
ಮತ್ತೆ 5 ಕೋಟಿ ಏನು?
ಇಲ್ಲ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿ ನೋ ಪ್ರಾಬ್ಲಮ್ ಇಫ್ ದ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸೇಸ್ ಇಟ್ ಇಸ್ 11 crores, so be it. That's
Yes.
32.
So one mandamus milord to.
Mandamus.
For payment
Consider
of,
what?
Representation milord annexure.
Yes, Vachan, we close it.
He is the agreement holder from the landowner. Landowner has not been made a party. They are not even entitled to.
Reject ಮಾಡಿ ಅಷ್ಟೇ.
Compensation, they are seeking a positive direction.
Positive direction, no positive.
Let them consider.
Release the compensation amount of 30 guntas of land.
Because
You are an agreement holder.
agreement.
An agreement holder. Landowners have not been made party in the petition.
Yes, sir.
Let them consider. milord. I am not saying that.
Party ಮಾಡಿ.
ಅಲ್ಲ ಅಲ್ಲೇ you lordship kindly say part performance. Payment of sale.
Agreement post acquisition notification.
No right at all.
Agreement ಮೊದಲೇ
Agreement, post preliminary notification.
ಇಲ್ಲ
Shivram Karan.
prior to that.
ಶಿವರಾಮ್ ಕಾರಂತ್.
2016 2016 ಅಲ್ಲಿ agreement ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
16 agreement, 2008 notification ಅದು.
2008.
ಶಿವರಾಮ್ ಕಾರಂತ್ is 2008. Final notification pursuant to order of Supreme Court is 8/8/2018.
ಅಲ್ಲ ಫಸ್ಟ್ ಏನಂತಂದ್ರೆ ಅವೆಲ್ಲ ಡ್ರಾಪ್ ಮಾಡಿದ್ರು ಆಮೇಲೆ
ಆಮೇಲೆ ಆಯ್ತು,
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಮೈಂಡ್ ಆಗಿ
But anyway, preliminary notification is in the year 2008.
ಅಲ್ಲ of course that is there milord. Earlier it was passed. Again Supreme Court remanded that matter. That is there.
Supreme Court remand ಮಾಡಿಲ್ಲ, directed to
ಮತ್ತೆ
issue
here ಮಾಡಿ
notification,
ಅಂತ
final notification.
ಅದನ್ನೇ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. Let them consider my representative because milord part performance but I am entitled for compensation.
For what?
Compensation I am entitled.
You have no right in law at all, sir.
I will
To
implement
seek
that.
compensation, post notification purchase, ಅದು agreement.
I will implement.
Look into.
ಅಲ್ಲ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ತೀನಿ ಓನರ್ ಅಂತ.
ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ you hear the owners and then
ಅಷ್ಟೇ
pass
ಅದು
out.
ಮಾಡ್ಬೇಕು.
I'll obtain the status, my lords. By then, now they might have even passed an award.
ಇಲ್ಲ
I'll obtain the information, my lords.
ಆಯ್ತು, obtain information. Yes.
Please, my lord.
ಅಲ್ಲ ಅವರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Learned counsel for the petitioner seeks leave of this court to implead the landowners as party respondents, as he is an agreement holder from the hands of the landowners, having entered into an agreement of sale in the year 2016, 8 years after the issuance of the preliminary notification. The learned counsel B. Vachan submits that he would seek instructions with regard to the award also being passed way the said lands which is subject matter of acquisition for the formation of Dr. Shivram Karanth layout. List on 17th.
Obliged.
Yes.
33.
So as for dispensation of my lord, what has happened is 19 my lord 54, there was my lord an acquisition by CITB. Thereafter, my lord, they have not taken possession. My lord, we continue to be in possession. Khata is in our name. Please come to my lord page 38.
Even today you are in possession?
Yes, my lord. Allah tavu idik bandre. Please come to my lord page 29. Khata stands in my name. More important is 30 bani. 29 my lord is a khata. 30.
Preliminary notification ಯಾವಾಗ?
My lord, the 19 47 ಒಂದು, 54 ಇನ್ನೊಂದು.
Final?
Final ಇಲ್ಲ.
ಹಾಗೆ ಇಲ್ಲ.
BDA ನಾವು there is a building, ಕಟ್ಟಡ page 30 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
Anyway,
We have constructed hotel.
Heard the learned senior counsel, Shri Uday Holla appearing for the petitioner. Learned senior counsel taking this court to the documents appended to the petition would seek to demonstrate that the preliminary notification twice over was issued concerning the subject property, once in the year 1947 and again in the year 1953, both of which did not attain finality. The petitioner is said to be in possession even as on date, and all the records, statutory and otherwise, stand in the name of the petitioner, is a submission of the learned senior counsel. What is this 94 page?
94, my lord, is, sorry.
Identical?
Correct.
Or
ಹೌದು.
identical?
Same kind of this thing.
The learned
94 and 88, two are there, my lord.
learned counsel, BDA, Ajay Kumar is director to accept notice for the first respondent, learned HCGP for the second respondent, petitioner to serve set of papers upon the aforesaid counsel, if not already served. Till the next date of hearing, there shall be an interim order as prayed for, as sought for in the case at hand. List the matter on 24th.
Please. Please.
Objections, if any, by then, by the next date, yes.
34.
ಏನ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಏನೋ ಹೇಳಿದಿರಲ್ಲ, ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಲೋ ಮಾಡಿ, ಇಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಲೋ ಮಾಡಿ ಫಾರ್ ದ ರೀಸನ್ಸ್.
Lords, the first petitioner's land measuring 708 square meters has been acquired, and for the second petitioner 324 square meters is acquired. Lords, there was some aberration in the revenue entries. The proceedings were before the revenue authorities. They rectified the entries where they had shown certain portions of the land as Kara, which is already rectified in the year 2020, even prior to the date on which the acquisition took place. Now, the compensation was awarded only for 324 square meters out of 708 square meters.
Ignoring the rectification.
Ignoring the rectification. Then what happened? Lords, it doesn't stop there. The land acquisition officer, the project officer says, this is the discrepancy which is pointed out to me, and directs the special land acquisition officer, you please look into it and then report back urgently. But then the land acquisition officer requests the ADLR to file a report as to the present state of affairs.
What is the report?
The report says that we have now rectified the entries. The actual extent of the hind land or the arable land or the assessed land is 708 square meters out of the acquired area and 324 square meters so far as the second petition is concerned. We are given a notice. If your lordships were to see, this is what is making the case interesting. They give me a notice at Annexure J, page 41. Second paragraph. ಮಾಣಿ ಗ್ರಾಮದ ಸರ್ವೆದಲ್ಲಿ ನಿಮಗೆ ಸೇರಿದ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 181 ಸೋನ್ಸೋ ರಲ್ಲಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನಂತರ ಇತ್ತೀಚೆಗೆ ದುರಸ್ತಿಯಾಗಿದ್ದು, ಅದರಂತೆ ನಿಮಗೆ ಪರಿಹಾರ ನೀಡುವ ಜಮೀನಿಗಿಂತ ಅಧಿಕ ವಿಸ್ತೀರ್ಣದ ಜಮೀನು ಭೂ ಸ್ವಾಧೀನವಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿ ನೀವು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ನಮ್ಮ ಕಚೇರಿ ಸರ್ವೇಯರ್ ಅವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅವರ ವರದಿಯಂತೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಭೂ ಸ್ವಾಧೀನವಾಗಿರುವ ಮಾಣಿ ಗ್ರಾಮದ ನಿಮ್ಮ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಅಂದಾಜು 384 ಚದುರು ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಖುಷ್ಕಿ ಜಮೀನು ಬಾಬ್ತು ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡು ಶೀಘ್ರವಾಗಿ ಅವಾರ್ಡ್ ಅಥವಾ ಒಪ್ಪಿಗೆ ಅವಾರ್ಡ್ ಮಾಡಿ ಪರಿಹಾರ ವಿಸ್ತರಿಸುವುದು. ಆದ್ದರಿಂದ ನೀವು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಕಾಮಗಾರಿ ಯಾವುದೇ ಅಡಚಣೆ ಮಾಡದೆ ಜಮೀನಿನಲ್ಲಿ ಕಾಮಗಾರಿ ಮಾಡಲು ಅನುಕೂಲ ಮಾಡಿಕೊಡಬೇಕೆಂದು ವಿನಂತಿಸಿತ್ತು. So we did this. We have actually surrendered the property. They want to use the property. After this is done, if your lordships were to see, there is an endorsement at page 43 and page 45, which indicates that after the body is done, what is the extent of the property. Now at Annexure N, page 47.
Well, you're seeking damages, costs and compensation.
Yes. But after that, at Annexure N, what they do, the ADLR's report is referred. After that, the special land acquisition officer secures the report.
NHAI alva?
NHAI.
They're given to this. No worries. Yes.
We have entered appearance, my lord.
Entered.
Learned counsel Shobhit Shetty was.
Who has entered up? Shobhit Shetty.
Learned counsel Shobhit Shetty was directed to accept notice, my lord, but we have been instructed to appear.
Yaar Padmanabha Holla?
Please, my lord, my senior.
Padmanabha Holla?
No, my lord, my senior, my lord. We have filed wakalat, my lord. I shall seek instructions and place my objections on record.
Yes.
Lords, they have
We
to.
will have
this
to
is-
consider this.
Lords, they have to, Lords, now the question is this.
Objection ಹಾಕ್ತಾರೆ interim
Let
order
them, let them, if they are filing the objections, I want to put them on guard, my lord, that I'll be insisting for heavy costs to be imposed because they
Okay.
held out to me saying that you please give the
Lord,
land, I'm going to give you additional
So
compensation.
can you make costs as a condition precedent to file objections or
Lords,
not to file?
They
objections?
can't come out with an objection is essentially
them
what I'm
come out
saying.
with
They'll have to come
whatever
out
they
with the
want.
checks.
No, I
Let them
shall
come out with
Very well,
whatever
Lords.
they want.
I shall seek instructions.
No, ಬರೀ instruction ಗೆ ಇಳಿದ್ಬಿಟ್ರೆ ಎದುರ್ಕೊಂಡ್ರು objection ಅಂತ.
No, Lord, I'll place my objections as well. Lord.
Yes.
Lords, my land, they promised me that I'm going to give you the compensation. ADLR report is secured.
No, no.
Land
this
is
will-
utilized.
We will answer, yes. If they have utilized the land or meddled with your property rights, appropriate relief will be granted.
Lordships.
Heard the learned senior counsel, the first petitioner. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. The learned counsel Padmanabh Holla, who is appearing for the NHAI, seeks time to seek instructions or file his statement of objections as the case would be. List the matter on 17th.
Please, my lords.
Instructions or objections be secured and
At the same stage, my lords, in the.
At the same stage.
Lordships.
One humble, name of the learned counsel.
Registry to delete the name of Shobit Shetty as appearing for respondent 1 and 2 and retain the name of Padmanabha Holla as appearing for respondent 1 and 2, na? 1 and 2.
Could it be, my lords, after 1 week, my lords, in case?
We need
17th.
Very well. I'm in your lordships.
1st August.
17th.
ಅಲ್ಲ ನಾನು 17th ಹಾಕಿದ್ದೀನಿ 1st August.
ಆಯ್ತಾಯ್ತು, ಗೊತ್ತಾಯ್ತು. Grateful.
Obliged.
35.
Here for the petition.
Yes, sir.
Let this.
Same
Number of
identical matter is
cases,
what
my lord,
I have granted
his
some order. Where is it?
No, his lordship just, Devdas has reserved these matters.
Correct.
Your lordship
Agilva?
posted after 4 weeks.
List after 4 weeks.
Let
Two and
notice
three,
will have, well, it's first time it has come.
I forget your name.
HN Vasudev.
Sachin Vasudev is directed to accepts notice for respondents 2 and 3. 1 HCGP. List after 4 weeks.
Please.
The learned counsel for the parties would, respective parties would submit that the coordinate bench has heard and reserved identical matters. Therefore, list this matter after 4 weeks.
Please.
36.
Please.
Non-compliance.
Filing objections matter, my lords.
Filing of copy kodi.
Please.
Counsel for the respondent BDA files a statement of objections. The same is taken on record, rejoinder if any, by the next date, list on 15th.
Please, intermodal.
Intermodal, list on 22nd, intermodal subsisting.
15th, we may be moving for vacating also otherwise.
Hagar 15th, yes. 15th, intermodal subsisting would continue to the next date of hearing. Second list ಹೋಗಿ ಮಾಡಿ.
List number 2. Preliminary hearing. Seal number 1.
Petitioner, my lord.
ಕೊಡಿ.
Pay for the petitioner. Kindly pass over.
Pass over it. Yes, yes. Your claim is it is nursery.
Yes, my lord. Petitioner number 1 is the land.
1 minute. You are still in possession.
Yes, my lord. Till today possession, my lord. Petitioner is the
Learned HCGP 1. ಇವರಲ್ಲಿ
2 and
ಕುಮಾರ್ ಅಜಯ್ ಕುಮಾರ್ 1 and 2 BDA.
Please.
Counsel Ajay Kumar is directed to accept.
one HCGP.
Sorry, 1 HCGP, 2 and 3. Ajay Kumar is directed to accept notice for the respondents. His claim is that it is a nursery and he is in possession of the property.
Please.
Division bench, I have written an order. Just check that. And
Interim order.
Shivram Karat.
No, my lord. Biman Kuppe.
ನಿಮ್ದಲ್ಲ ಸರ್ ಗೊತ್ತು ಎಸ್ ಸೊ list the matter on 15th till such time the petitioner if not dispossessed as on today in accordance with law shall not be dispossessed. Yes. Next.
Number 2.
Sim conversion.
My lords,
P&SC.
my lords, we had requested my friend, apparently his clients are not even ready to talk to us.
Why
There's
is
a lot
that?
of unnecessary ego.
That is unfair. What I'm saying is on the very next day I had sought instructions and then yesterday my learned friend reached out to me, proposed a name, they are not fine with it. That is, one CA's name was proposed, I put it to my clients, they are unwilling.
ಆಯ್ತು, unwilling.
Because I'm saying, my lord, that CA is based out of Chennai. We do not know the antecedents of that person.
Why is your close friend?
No, no,
Then-
no, 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 I'll just explain. My lords, what has happened is, the reason why all of this is happening is there's an undertaking saying he'll not alienate the property. That means he can't sell the land. If he doesn't sell the land, it doesn't benefit any of us.
That is why I said sit across and.
My lord, they're not ready to talk to us because the submission which was made was that they're not ready to talk to us. If they talk to us, then we can find some solution.
I put it to my client on the
I'll
very.
take it on Friday finally. If you don't strike out anything, I will pass out on merits.
Very well.
Yes.
My lords, I have only one request, my lords. Tomorrow the matter is in the trial court. My friend can let him just undertake here, my lords. That's enough.
I'll not precipitate before the
The
trial.
learned
court.
counsel for the respondent submits that he would not precipitate the matter before the concerned court, which, in the matter that is slated to be listed tomorrow.
My lord, may I just make one submission? Up team number of times we have made efforts. Now, if we look at the Indian Succession Act also, there's no provision for an outsider to be appointed.
That is not correct. That is not correct, my lords.
We will answer it on merits then Friday. Yes.
Very well.
ಅಷ್ಟರಲ್ಲಿ ನಾವು ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ yes.
Number 3,
Consider representation.
For the petitioner, my lord.
Vachan is here.
Is writ of mandamus, my lord.
Threat of mandamus.
Writ of mandamus.
Writ of mandamus. ಗೊತ್ತಾಯ್ತು.
This is considered the representation of.
ಹ್ಞೂ ಸರ್. Pradeep Kumar, you appear for BDA also? You serve on, ಅವರೆಲ್ಲ ಅಜಯ್ ಕುಮಾರ್ ಇದ್ದಾರಾ ಇಲ್ವಾ? ಯಾರು ಇರೋದೇ ಇಲ್ಲ. ರಾಮಕೃಷ್ಣ ಸರ್. ಓ ನೀವು KID. ಮುರುಗೇಶ್. ಮುಂದೆನೆ ಬರಲ್ವಲ್ಲ ಯಾರು BDA ಅಂದ್ರೆ ಭಯನಾ? Yes, learned counsel, consider representation. Dispose ಮಾಡ್ಲಾ notice ಕೊಡ್ಲಾ? ಎಲ್ಲ will post all this representation consideration on the 8th ಇದೆ ಇಲ್ಲಿ. ಎಲ್ಲ next Tuesday ಹಾಕ್ತೀನಿ.
Please.
Counsel Murugesh Charati is directed to accept notice for the BDA. BDA respondent. Hey, yeah, sorry. ನೀವಿಲ್ಲ, sorry, not the BDA. Assistant Commissioner Hassan PW, ಏನ್ acquisition is? Why do you want the Panchayat Development Officer?
My lord, first the gazette as per the gazette
Comment
notification.
copy ಕೊಟ್ಟಿಲ್ವಾ?
Government copy, sir.
What not served? It is served. If you have not allocated your files properly, then it will not be correct. What is this chaos? ಯಾರಿಗಾಗಿದೆ ಇದು? ಎರಡು ದಿನ ಇರೋದು, ಎರಡು ದಿನದಲ್ಲೂ ನೀವು ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? Learned AG, HCGP, AG and HCGP na? HCGP is directed to accept notice for the respondents 1 to 5, 1 to 3. List next Tuesday. Dispose ಮಾಡ್ತೀನಿ next Tuesday. Consider representation ಇರೋದು.
My lord.
Notice ಎಲ್ಲಿದೆ? ಬಿಡಿ ಮುರುಗೇಶ್, ನೀವು ವಸಂತ್ ಇದ್ದಾರಾ? ಹಾ, ವಸಂತ್ ಅಂದ್ರೆ ಕೃಷ್ಣ. Learned counsel K. Krishna is directed to accept notice for the respondent 2 and 3, 1 HCGP 15th.
My lord, interim prayer, my lord.
When interim prayer?
Because since 23 years, my lord, it's been 23 years, they have not
If the
acquired land.
petitioners are in possession as on today,
We are in possession, my lord.
if the petitioners are in possession as on today, their possession shall not be disturbed till the next date of hearing.
Much of.
List on 22nd.
5,
My lord, it is a pretty old litigation.
Pretty old.
Yes,
Pretty old illa, it's 2025.
but we are seeking the justice since 1967.
Correct, sir. You are seeking return of land that was taken in 1967.
No, land was acquired in the year 1928 for the construction
58, oh, sorry, yes, even little.
I will take note.
One moment, sir. ಯಾರ್ಯಾರಿದ್ದಾರೆ ಎಲ್ಲರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. government ಅಲ್ಲಿ. Yes, learned HCGP is directed to accept notice for all the respondents.
Special land acquisition officer.
ಯಾವ್ದಕ್ಕೆ?
ಹೇಮಾವತಿ ಕೆನಾಲ್.
1, 2, 3, 4, 4 up to 4 ನೀವಾ?
1, 2, 3. 1 and 2.
Huh?
Amended copies.
What amended copies? ತೊಗೊಳ್ಳಿ ಯಾರ್ಯಾರಿಗೆ ಅಂತ ಹೇಳಿ. Take this.
ಒಪ್ಪಂದೊಂದು ಹಾಕಿದ್ದಾರೆ. ಕಾವೇರಿ ನೀರಾವರಿ ನಿಗಮ 6 my lord.
ನಿಮ್ದು ಯಾವ್ಯಾವ್ದು ಅಂತ ಹೇಳಿ ಸರ್.
1 to 5 my lord.
1 to 5 learned HCGP is directed to accept notice.
7 to 9 my lord.
1 to 5, 7 to 9.
6 my lord. Somebody has to be direct.
6 yaru Kaveri Niravari. Case Bhimaya is directed to accept notice for the 6th respondent. The petitioner in person shall serve complete set of papers upon case Bhimaya forthwith. List the matter on 22nd.
Thank
Yes,
you.
next. Government. ಯಾವ್ದ್ರಲ್ಲೂ ನೋಡಿಲ್ಲ. GA served ಅಂತ ಇದೆ ಅಷ್ಟೇ. For what purpose service of notice? Learned AGA is directed to accept notice for the respondents. Consider representation irodu next week, Tuesday. Make a note of it. List on 15th. Twitter.
7.
General award covered.
Covered by the my lord.
Annexure D,
Page.
Annexure
82.
D, my lord, sure. 82 page.
ವಸಂತ ಇದರಲ್ಲ. Page
82.
Page 82. Annexure D, same order. Next.
Much less. Appearing for the petition this matter. Of mandamus. Change of land is. 213 my lord.
Council Murugesh Charati is directed to accept notice for respondents 2 and 3. Learned AGA for the first respondent. List on 15th. Copy ಕೊಡಿ.
Please.
Yes. ಇದು consider representation ಅಷ್ಟೇ. ಯಾರ್ಯಾರು BDA ತಗೊಂಡಿದ್ದೀರಾ, consider representation, please secure instructions, will close it.
Please.
Yes.
9.
ಇದು ಅಷ್ಟೇ. Page 17. ನೀವಿದ್ದೀರಾ already?
But I didn't know how the copy was sent to me, but
Very good.
BDA has already sent me a copy
Ah.
filed and along with Wakalat. I'm sorry.
Page 17 is the prayer.
Where not 38D Lord they have sought for. Lord will consider it in accordance with the subject to their satisfaction.
4,000 square feet.
4,000 square feet subject to they proving the existence of a building as on 2008. Lord.
Yes, sir.
Yes, my lord. Lord, before 2002, the building is existence. The
ಆಯ್ತು,
committee is
password.
held that.
2:30 ಗೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
Please.
Yes. Next.
10.
TP Vivekanand is directed to accept notice for respondents 2 and 3. R1 HCGP. The petitioners, if in possession as on today, shall not be dispossessed till the next date of hearing. List the matter on 22nd. Petitioner to serve set of papers upon TP Vivekanand forthwith. Next.
11 my lord.
Same order I have passed earlier.
So one.
Cost impose ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಹಂಗೆ ಬಿಟ್ನಲ್ಲ ಅದು.
Please, my lord. There's one
ಅದೆಲ್ಲ
more
ಯಾವ
matter.
order ಅದು?
My lord, there is one more matter similar because there is.
ನೋಡಿ ಎಲ್ಲ ಸೇರಿಸಿ ಒಂದು ಕಾಸ್ಟ್ ಇಂಪೋಸ್
My
ಮಾಡ್ಬೋದು.
lord, sir, writ petition number 17205 of 2025.
ಎಸ್ ಪ್ರದೀಪ್ ಕುಮಾರ್ ನೀವಿದ್ರಲ್ಲ ಅದರಲ್ಲಿ.
Ajay.
ಬಿಡಿ ಏನಾಯ್ತು?
BDM, my lord.
Ajay
Ajay
Kumar,
Kumar sir
correct.
was there. I shall serve on him.
Learned council ಸರ್ವೆ ಯಾಕೆ ಕ್ಲೋಸ್ ಮಾಡಬೇಡ.
My lord, see, there is one, my lord, we will go before the committee, my lord. I am not seeking.
The
for
only ground you have urged is that you are not a party but you are a party. ಅಷ್ಟೇ, ಅದ್ರಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದೀನಿ ಅದೇನೆ.
ಇಲ್ಲ ಅದೇ ಸ್ವಾಮಿ, but ಇದ್ರಲ್ಲಿ ಏನಿದೆ after dropping the land, my lord, there are construction.
Learned council Ajay Kumar is directed to accept notice for respondent 2 and 3. HCGP ne AG na? HCGP for 1. Petitioner to serve set of papers upon Ajay Kumar forthwith. List the matter on 15th.
Please.
ಅವತ್ತಷ್ಟೇ.
Please, my lord. But only guidelines, my lord, because construction ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ committee.
Yes, ನೋಡ್.
Please. Oblige.
Tag Ajay Kumar, same order which I passed. He said he was not a party. I have dismissed one petition.
Yes, my lords.
I did not impose cost because he had not said anything. Idena different anta.
The only
ಸ್ವಲ್ಪ
construction is
ಕಹಾನಿ ಮೇ
come out.
twist ಇದೆ. Yes.
I'll take instructions.
I have directed him, sir. ಇನ್ನೊಂದು petition ಯಾವ್ದದು?
It's 17205 of 2025.
Tag this petition along with so and so. ಅದರದ್ದು copy ಕೊಟ್ಬಿಡಿ ಅಜಯ್
Please,
ಕುಮಾರ್.
both I shall serve.
I'll get instructions.
15th, yes.
Please.
General award, page
23, my lord, annexure D.
Lord, madam,
ಕೊಡಿ.
serial number.
ಯಾವ್ದಿದೆ?
Lord, serial number 12, 14, 16, same.
Same.
And my lord, this is 23 and 24 same. My lord, in that 12, 13 and 14, developed land.
14, 16, my lord.
ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ sir, ಮೇಲ್ಗಡೆ.
12, 14, 16, same.
ಈ my lord, instead of monetary compensation, petitioners my lord sought for developed land. Last paragraph ಅಲ್ಲಿ ಇದೆ.
In lieu of compensation, same order.
Same.
12, 14, 16, same order.
My lord, ಇದು 23 and 24 same. ಇದು
20
general award.
23 and 24 ಕೊಡಿಯದು.
Monitor compensation.
Monetary compensation.
General award.
Notice.
ಎಲ್ಲದರಲ್ಲೂ ಪ್ರದೀಪ್ ಕುಮಾರ್, HL Pradeep Kumar is directed to accept notice for respondents 2 and 3, learned HCGP for the first respondent. ಎಲ್ಲದರಲ್ಲೂ ಅದು ಬರೆದ್ಬಿಟ್ಟು covered and close ಮಾಡಿ.
Obliged.
Grateful.
Next.
13.
Learned counsel, ಯಾರು notice TP Vivekanand is directed to accept notice for second and third respondent Muda. Learned AGA for the first respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. 15th. Yes. Next.
15.
Consider compensation is reference. Learned AGA 1 to Vachan. B. Vachan is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 17th. ಹೌದು ಮುಗಿಸೋಣ ಎಲ್ಲ representation consider ಅಷ್ಟೇ.
17.
TP Vivekanand.
Learned counsel TP Vivekanand is directed to accept notice for respondent 2 and 3. Learned AGA 1. Petitioner to serve set of papers upon the aforesaid counsel. The petitioners, if are in possession as on today, shall not be dispossessed till the next date of hearing. List on 22nd.
Grateful.
Yes. Next.
15.
For the petitioner.
Consider.
Yes, ma'am.
Learned counsel TP Vivekanand is directed to accept notice for respondents.
18, I'm sorry, I have paper. 18 and 17. 18.
Consider representation. Second, prayer B is consider representation.
Only apprehension is that
That
28 to notice.
KDB
Take notice for that.
serve on Ramkrishna.
Yes, ma'am.
Counsel Sri S. Ramkrishna. C. Ramkrishna. Yes. C. Ramkrishna is directed, heard the learned senior counsel Vikram Huligod appearing for the petitioner. Counsel C. Ramakrishna is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel appearing for the KIADB. Take it on 17th.
Very well.
List on 17th. ಅಷ್ಟರಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ತೀನಿ. ಏನ್ ಕೇಳಿಲ್ಲ ಅವರು.
Yes.
Serve on TP Vivekanand. Counsel TP Vivekanand is directed to accept notice for the respondent Muda. Petitioner to serve set of papers upon the aforesaid counsel. List on 22nd. Yes, next.
20.
Nadaprabhuna. Covered.
No, my lords, this is a matter where.
Nadaprabhu Kempegowda layout.
Please, my lords. My land was left out from the acquisition.
Left out.
Please, my lords, there's a notification issued saying that we don't intend to
You
acquire.
are in
the
possession today?
Please, my lords. And now they are not giving permission for me to put up the residential building, saying that they intend to acquire the property.
Ega.
Please, my lords. That is the endorsement which they have issued at annexure Q, page 87.
One AGA. Ajay Kumar. ಇಲ್ಲ ಯಾರು? Who else is there? Bidi. Ajay Kumar idara? Counsel Ajay Kumar is directed to accept notice for respondents 2 and 3. Interim prayer nilvala. That's what. Petitioner to serve set of papers upon the aforesaid counsel 22nd.
I'm grateful.
petition.
Notice TP Vivekanand is directed to accept notice for respondent Muda. Mudana ಏನದು?
Shumaga.
Shumaga. Accept notice for the respondent. List the matter on 22nd. Petitioner to serve set of papers upon the aforesaid council. Shumaga Urban Development Authority ಅವರೇ ಪೇರ್ ಆಗ್ತಾರ? Correct. ಅಲ್ಲಿ AV Gangadhar is directed to accept notice ಅಂತ ಮಾಡಿ. Not yes. List on 22nd.
Stay.
ಏನ್ ಸ್ಟೇ? ಡಿಸ್ಪೋಸಸ್ ಮಾಡ್ತಾ ಇದಾರ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಸ್ಟೇ ಎಲ್ಲ ನೋಡ್ಕೊಂಬಂದಿದೆ.
Appearing for the petitioner in this matter.
Learned Counsel PV Chandrasekhar is directed to accept notice for the board KIDB 1 AGA.
That challenged the notification.
Correct.
And the order under section 28(3).
Yes, sir. 28(4) is challenged.
28(4) issued in the March.
ಅದೇ ಈಗ ಹೊಸದಾಗಿ ಆಗಿರೋದು. What ground?
That's Lordship may kindly see page 49 minutes. This is the order passed under 28(3).
Circular ಮೇಲೆ agriculture.
Circular, it's contrary to the circular minutes.
The learned counsel PV Chandrasekhar is directed to accept notice for respondent.
213 my lord.
2 alla 3 and 4.
3 and 4.
3 and 4 AGA 1 and 2. Status quo where the property be maintained.
Stay of disposition if not already disposed.
The petitioner shall not be dispossessed if not already dispossessed as on today till the next date of hearing.
Grateful.
23, 24 disposed, 25.
Acquisitions are challenged. The
2022.
2022. Petitioner is not notified, petitioner is not named, though they have purchased the property prior to.
28(4) ಯಾವಾಗ ಆಯ್ತು?
28(4) is.
You have taken possession?
No, my lords.
I'll just ನಾಳೆಗ.
Learned counsel ನಾಳೆಗ.
ನಾಳೆ ನೋಡು ಹೇಳ್ಬಿಟ್ಟು.
Learned counsel PHL Pradeep Kumar is directed to accept notice for the board. Respondents 2 and 3 AGA 1 petitioner to serve complete set of papers upon HL Pradeep Kumar day after tomorrow.
Stay.
Day after tomorrow. Let him see. Yes.
Lord, in this seal number 26, I seek for a password.
Okay.
The Advocate General appears in this case. Lord, in this case, we have filed caveat. Lord,
We filed the writ petition afterwards.
Lord,
they come
caveat
up
has been
ಆಯ್ತು ಸರಿ ಏನ್ ಗೇರ್ ಮಾಡೋಣ ಬಿಡಿ.
caveat ಹಾಕಿದೀವಿ ನಮಗೆ.
urgency
ನನ್ನ ಹೆಸರು ಕೂಡ ತೋರಿಸಿ.
ಪಾಸ್ ಓವರ್ ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಎಲ್ಲ ಕಾಪಿ
Lord,
ಕೊಟ್ಟಿದ್ದೀನಿ.
Lord, one submission, Lord, the writ
Sir,
petition.
Advocate General will come pass over. Yes.
27.
Alternate site. Vachan. Learned counsel B. Vachan is directed to accept notice for the respondent BDA. Petitioner to serve set of papers upon the aforesaid council forthwith. 22nd, yes. 28 same, Vachan, same alternate site. 28 same, B. Vachan is directed to accept notice. 22nd. Copy kodi. 20, ಇನ್ನು ಬಂದಿಲ್ಲ ಅಲ್ಲಿಗೆ wait.
29.
29.
Petition challenge is 28(4) notification.
ಯಾವುದು March 2025?
ಅಲ್ಲ 2020 March 25.
No, the identical matters
28(3) is
HL
not a
Pradeep
reason.
Kumar ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ. Counsel HL Pradeep Kumar is directed to accept notice for the respondent 1, 2, 3 and 4, 1 AGA day after tomorrow. Preliminary hearing. Yes.
30.
Lords, appear for the petitioner, my lords. Lords, I sought for stay on further proceedings, my lords.
Why?
Lords, because there's an appeal pending before the Honorable Supreme Court, my lords, and the Honorable Supreme Court has passed an interim order as well, my lords.
Page.
Lords, page 256, my lords.
What is-
257, my lords.
What is that order?
Lords, last line, my lords. In the meanwhile, no third party rights shall be created. 257, my lords.
ಯಾವ್ದಿದು? This is arising out of the same.
No, my lords. My lords, the issues, my lords, the petitioner is second wife of Maharaja Sahadev ji, my lords.
Maharaja?
Sahadev ji, my lords.
Sahadev Ji.
Sadeji, my
All
lords.
right.
My lords, the dispute is between the petitioner and the second wife of the petitioner's husband, my lords.
Second wife of the petitioner's
Ma'am,
husband.
sorry.
You do one thing, you have lunch, get to know the relationship properly.
My lords, I
I'll
will
come at
explain the
two-
case,
we'll-
my lords.
We'll take it at 2:30.
Please, my lords.
ಮ್ಯಾಮ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಮಧ್ಯಾಹ್ನ ತಗೊಂತಾರಾ?
Please, please. Yes, and madam. Madam.
ಅದಕ್ಕೋಸ್ಕರ please that we shall. We shall come back with not a stay. Your lordship may kindly give it after 8 weeks. I will come back with one more status report. Not really.
Much obliged, my lord.
These status reports you need back or? Court. Yes. It is in the chamber only. Madam Madhu. Status report. Status report. Ah, 230. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲಿ ಅದು ಇವತ್ತೊಂದು ತಗೊಂಬಿಡಿ. Yes.
30.
Now you tell me whose husband, whose wife and whose property is acquired.
My lords, the dispute is between the petitioner and daughter of first wife, my lords.
Petitioner, daughter of first wife.
Petitioner and the daughter of first wife. Petitioner is the second wife of Maharaja Sahadev ji, my lord.
Which, who ji?
Sahadev ji, my lord.
Sahadev
That's
ji.
his name, my lord. The dispute is between the first wife's daughter and the petitioner, who is the second wife. So the first wife's daughter is also deceased now, and the LRs have been brought and recorded, my lord.
Now LRs are continuing the fight.
Please, my lord. That's in the year 1990.
ಇಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
My lords, I will explain, my lord. Lords, a suit for declaration and permanent injunction was filed in, a suit for declaration and permanent injunction was filed in the year 1999, my lords. In the said suit, 17 issues were framed. The first issue is, my lords, whether the petitioner is the legally wedded wife or not. My lords, may I request my lord's attention to page.
What is the issue? Negative or positive?
Positive, my lords.
All right.
Affirmative.
Affirmative, yes.
Affirmative, my lords.
ಆಯ್ತು, ಈಗ ಇದ್ರಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿ?
My lords, the said
land
order
acquisition.
was set aside by this honorable court, my lords, and we preferred an appeal before the honorable Supreme Court, and the honorable Supreme Court has issued notice and passed an interim order, my lords. That is at page 257, my lords. This property is not included in those schedule, my lords. However, my lords, the question, the issue is, my lords, whether the petitioner is the legally wedded wife or not. My lords, if I succeed in the said case, my lords, I will have right over the property and all of the properties that belongs to my husband, my lords.
All the property.
All the properties, my lords. I will be the legal heir to his property.
How many properties?
My lords, the property is worth more than several thousand crores, my lords.
Several thousand crores.
Yes, my lords. I mean,
ಈಗ ಇಲ್ಲಿ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ?
my lords, here, my lords, the award has been passed and I have sought for a mandamus not to release the compensation in favor of respondent number 2 or any other third party, my lords, till the disposal of the suit in Supreme Court, my lords.
SLP in Supreme.
SLP, yes, sorry.
Who is this? What's the name of the second respondent?
My lords, Bijakshari, my lords. Granddaughter of first wife, my lords.
Granddaughter of first wife.
First wife, my lords.
You are granddaughter of second wife.
I am the second wife, my lords.
Oh, you are the second wife.
I am the second wife.
Shivaram Karantle hutta.
Please, my lords.
Compensation is determined. Award is passed already.
Passed, my lords. Annexure B, my lords.
ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಇದೆ ನಿಮ್ದು?
My lords, idralli 1 lakh square feet has been awarded, my lords. This property has not been included in the scheduled property which is pending before the honorable Supreme Court, my lords.
Anyway, you serve on the respondent.
My lords, I have served on respondent number 1, my lords. 2 I will serve.
BDA.
BDA, my lords.
ಯಾರಿಗೆ ಮಾಡಿದ್ದೀರಾ?
My lords, Murgesh
ಚರಾಟಿ. ಕೌನ್ಸಿಲ್ ಮುರುಗೇಶ್ ಚರಾಟಿ ಇಲ್ಲೇ ಇದಾರಲ್ಲ. ಯಾಕೆ ನೀವು ಯೋಚನೆ ಮಾಡ್ತೀವಿ ಹೂಸ್ ವೈಫ್ ಹೂ ಅಂತ?
ಇಲ್ಲ.
ಮತ್ತೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ?
Honorable Court has not issued notice on the petition. It may not be proper on the, so that's why I didn't come forward.
No problem. But you know the facts. Yes, the learned counsel Murugesh Charati is directed to accept notice for the respondent number 1 emergent notice to the second respondent. The squabble in the case at hand is for the purpose of receipt of compensation. The parties to the squabble are the petitioner and the second respondent. The petitioner is said to be the first wife,
Second wife.
second wife of Sahadevji, Narendra Devji, Rana.
Narahari Devji.
Narahari Devji Rana.
Please, my lord.
All right. The second respondent is said to be the granddaughter of the first wife.
Please, my lord.
Correct?
Correct.
Fine. Granddaughter of the first wife. The learned counsel for the petitioner submits that this court had rejected the claim of the petitioner for a determination of she being the second wife.
Second wife. Legally wedded wife.
She being the legally wedded wife of the aforesaid G. Yes. The petition the civil court appears to have determined in favor of the petitioner. This is upturned by the division bench of this court. The petitioner then prefers a review. The review also comes to be rejected. All of which are now before the apex court in SLP. 267 alla? Page?
257, my lord.
257.
256, my lord. Annexure F.
257 in SLP 23225 of 2023. The apex court on 2/12/2024 has passed the following order. Page 256, 257. The parties are directed to maintain status quo. In that light, the disbursement of compensation also, the respondent shall not disburse compensation to any person till the next date of hearing. List the matter on 24th.
Kindly, this 12-2 notice is dated 31/8/2023. Lordship may say that if not already disbursed.
If not already disbursed as on date.
Please.
Further hearing.
Further
2:30.
further hearing at 2:30 PM, 65.
Well, it's before my friend starts.
You want to end it?
No, my lords.
Then,
These are the list of cases which have not been listed, my lord.
That's why I said before my friends start, I am going to end it today.
In fact, my lord.
Yakanದ್ರೆ tag ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆ ದಿನ ಹಾಕಿದ್ದು.
In fact,
As far as I am concerned, my lord, we are worried about 4 criminal cases which are pending. I will.
What are these petitions?
That's, my lords will see, the top matter is the one in which my lord had protected.
No, these are before the other courts, sir.
Well, it's my lord's order. In the top matter, my lords had stayed the proceedings.
ಇದು further hearing ಆಗಿದೆಯಾ?
My lord, the matter which is before your lordships now, my lord, has been further hearing.
ಅದು ಗೊತ್ತು. ಇದು part heard ಆಗಿದೆಯಾ?
I have not.
ಇಲ್ಲ. Then it is before the other court.
No, my lords, it's an offshoot because my lords have quashed.
Maybe an offshoot, but I have not treated as part heard. You are not appearing in any of these cases today?
Well, it's today I'm appearing in 65.3, 65.6.
Anyway, you are there in some case, so don't worry. Yes. Where is Gautam?
I'm.
You are appearing for it. All right. Yes. In a nutshell.
Yes, my lord. My lord, easy reference, my lord.
Because I've already heard it.
I've just done a synopsis, my lord.
Just a refresh.
Of the cases which are there, so that, my lord, there's no confusion. My lord, there are total 4 criminal cases which is filed as against the petitioners. My case is concerned. My lord, if your lordship kindly see the synopsis which I. My lord, the first, my lord, WP 19792 of 2023. Kelgade, it's in crime number, my lord, 153 of 2017, which was transferred and it became.
All these are criminal petition. All these are 482.
All 482 petitions.
Fine. So common thing is 482.
My lord, in all these cases.
Who appears for the respondent?
He appears for the impleading respondent.
Impleading. Where is Madhukar Deshpande?
Allah, that is, my lord, in the respect of ED's case. Now, my lord, if I am able to succeed in this
Prasanna
case.
Kumar? Oh, he is not there. Who is Gautam? Oh, respondent is Gautam, is it?
Gautam.
Then why are you
Yes.
standing? Come this side.
What has happened is my friend probably mentioned one matter. And what has happened is these matters do not even have any bearing or connection
My lord,
with
I
the
will start,
matter.
my lord,
I
my
think
case.
Manoj has put a question to me. That's why I
I
wanted to-
wherever Bipin Hegde is appearing, you start.
Yes,
Well,
I
it's
will.
because my friend wants to derive benefit of probably this order.
Which order?
This is where Malad had quashed the predicated offense.
Could you?
But my friend's FIR is different. It's 157 of 153 of 17 and 46 of 17. Whereas my crime number is 182 of 21.
This is settlement.
This is settlement, but my friend's ECIR is different. My friend's ECIR.
I have not yet come to the ECIR. We're still in the FIR.
Because Munne Raju's matters have no connection with the ED matters which are before Malad.
My lord,
That's
I will
what I
submit, my
wanted.
lord.
Allow me, sir. Allow
My
me.
case, I will submit.
Bipin held that.
Yes, I will submit.
You are for the respondent. So please be
Respondent.
this side. You respond later. Yes. Yes, Bipin.
My lord, in the cause list, your lordship may kindly take serial number 65, 65.4 and 65.5. This, my lord, crime has been registered in view of a complaint given by one Dinesh Kallalli, who claims to be a RTI activist.
These three matters.
These three matters.
That is 65, 65.4, 65.5.
65.4, 65.5.
All right.
Now, my lord, in view of this predicate offense, in view of this case, that is, my lord, 65.4, 65.10, my lord, ECIR has been registered.
That's all right. That we'll see later.
Yes.
First you submit on the predicate offense.
Yes, ma'am. And the fourth case is, my lord, 65.1 and 65.2 are in respect of the same offense by two different accused.
All right.
65.1 and 65.2.
All right.
Are in respect of A1 and A2 different accused, one crime. It is registered by one Nagaraj, who claims to be the general power of attorney of one Pratik Kumar. Now, my lord, coming to 65, your lordship may kindly turn, my lord, to the, my lord, in nutshell, if your lordship may kindly, sir. Their main grievance is that these are the property which has been attached by the committee which was formed by the Lodha committee which was formed by the Supreme Court. There, my lord, a district judge was appointed. He has attached the properties. Though there is an attachment order, we have sold the property. That is the allegation. That is the allegation made by the right to information activists. Who, my lord, according to me.
Who is representing the complainant?
Mr. Bharadwaj, my friend is.
Oh, you are the complainant.
That's why I said these two
No,
matters
don't worry.
should not be clubbed.
I'm just asked who is the complainant. That's all. Yes.
So, my lord, my first submission before your lordship would be, my lord, I have, my lord, produced the synopsis. Your lordship may kindly turn, my lord, it is in respect of two survey numbers, my lord, two complaints have been filed. Now, if your lordship may kindly see the first synopsis which I gave, my lord. My lord, it is hit by doctrine of sameness.
Which are the two crimes on the same issue?
My lord,
crime number.
Crime number. My lord, it has been subsequently charge sheet has been filed.
Now, crime number.
Crime number, my lord, 107 of 2018.
107 of 2018. Yes.
First matter.
Yes.
Second matter, crime number 47 of 2017. And my lord, third matter also crime number 46 of 2017.
All on the same cause of action?
All on the same cause of action. So in all these cases, but first two cases, my lord, in respect of the same survey number, 51/2 and 192. Your lords may get it in page number 3, my lord.
Yes.
In the same thing, page number 3. I have mentioned the survey number.
Yes.
51/2, 192. Second is also 51/2, 192.
Okay. Yes.
But third is different survey number, but same cause of action, same complaint.
So these two survey numbers are also same.
Survey numbers are also same.
All right.
Same incident, my lord, same. They say, my lord, this is the attachment order which was passed. Now, my lord, the first submission would be, my lord, though, my lord, in criminal matters, the question of locus standi will not arise. But in certain cases, where, my lord, it is not against the society as such, when private interest is there, your lordships have held, my lord, that the question of locus standi can be gone into.
Katil.
My lord, Katil case.
ಇದ್ರಲ್ಲಿ ಒಫೆನ್ಸ್ ಏನು? 417, 418, 420 ಎಲ್ಲದರಲ್ಲೂ ಅದೇನಾ?
ಅಷ್ಟೇ. My lord, I have mentioned the offences also, my lord, in the chart. My lord,
ಏನಿದು?
in.
Oh, judgments and documents.
My lord, I am sorry, my lord, not in. Not the ones.
Returned with thanks. Yes. ನಾನು ಕೊಡ್ಲಾ?
ಅದು ನೆಕ್ಸ್ಟ್ ಕೇಸ್ಗೆ.
ಬೇರೆ ಕೋರ್ಟ್ದಾ? ಬೇರೆ ಕೋರ್ಟ್ದಾ?
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಕೇಸ್.
Yes, yes.
Now, my lord, as far as in the first judgment, para 23, Mohammed Ibrahim's case, my lord, your lordships have. My lord, 465, 468, 420, my lord, have all been dealt with. In para 23.
Yes.
Lords may kindly see, when we say that execution of sale deed by a person purporting to convey a property which is not his, as his property, is not making a false document, therefore not forgery. We should not be understood as holding that such an act can never be a criminal offense. If a person sells a property, knowing that it does not belong to him and thereby defraud the person who purchased the property, the person defrauded, and that is the purchaser may complain that the vendor committed the fraudulent act of cheating. But a third party who is not a purchaser under the deed may not be able to make such a complaint. My lord, the next judgment is also, my lord, in respect of the same paragraph 8 and 9, my lord, I am relying on.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಯಾಕೆ ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ?
Well, my lord, architect.
Yes. ಬರೀ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿದ್ರೆ ನಾನು ನೋಡ್ಕೊಂತೀನಿ. ಪ್ಯಾರಾಗ್ರಾಫ್ ಹಾಕಿ.
Yes, I'll
ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ. Yes.
ಅಲ್ಲ, ನಾನು in fact I had, my lord, written notes here that ಆ ಪೇಜ್ ತೆಗೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, yes.
Paragraph 8 and 9. Of, my lord, the second judgment, my lord, Subramanian Swami judgment.
All right.
Paragraph 8 and 9, my lord, kindly see. My lord, that is on the same point of law. Paragraph 8. We must hasten to add that in crime in.
ಈಗ ಫಸ್ಟ್ ಮೊಹಮ್ಮದ್ ಇಬ್ರಾಹಿಂ ಅಲ್ಲಿ ಓದಿದ್ದು 23 ಅಲ್ಲ?
23.
Para 23.
Para 23. My lord, in Mohammed Ibrahim, my lord, other than para 23, para 8 and para 13 also might be relevant, my lord.
ಅದಕ್ಕೆ ಒಂದು
criminal cases and civil cases settling of scores.
ಅದು ಗೊತ್ತಾಯ್ತು.
Because, my lord, there are almost 13 civil disputes, my lord, in respect of the same survey numbers.
All right, next.
And, my lord, paragraph 13 is about forgery, how a forgery will come into force. Now, my lord, second, my lord, paragraph 9 and 10.
No, in Subramanian Swami.
Subramanian Swami.
9 and 10.
Para 8, 9. Para 8 and 9. That is on locus standi, my lord.
All this is on locus.
Locus standi. My lord, third judgment, page 19. This is, my lord, 2 FIRs in respect of the same offense cannot be.
T. Anthony na?
Yes, my lord.
Yes, ಆಮೇಲೆ.
ಅಲ್ಲ, ಇದು
Kishan Lal Chawla, same. Yes, yes.
Same.
T. Anthony, same.
Yes, my lord. Paragraph 6 in that Krishna
You
Lal.
need not go into that. Yes.
My lord, sixth judgment, my lord, is page 65. Page 65. Delay in filing the FIR. The lordships have, my lord, dealt with paragraph 9, page 9, my lord, internal page 9.
Chanchalapati Das, yes.
When there is a delay, my lord, in the last paragraph page also.
Yes.
Epic, my lord, internal page 12. Apex Court has delineated the delay caused in registering the complaint could undoubtedly become fatal to the case of the complaint. Unless there is a plausible explanation of such delay, I do not find such explanation in case at hand. The delay in registering the case is unexplained or it is shoddy explanation as it found in the complaint. Therefore, permitting further proceedings could become an abuse of process of law.
Bairegoda, sameness. Next.
My lord, yes, my lord, doctrine of sameness. Now, my lord, the next page, my lord, 112. The same complainant filed a public interest litigation, my lord, to refer
against you.
Against me, to refer the matter to the CBI. Now, my lord, the honorable
Dismissed.
dismissed,
Huh.
saying that, my lord, the honorable Supreme Court has referred the matter to CBI already in respect of all cases, in respect of Lodha, in respect of, my lord, Subrata Banerjee case, which is, my lord, offshoot of that case we are here. Therefore, my lord, the question of referring to the CBI will not arise.
All right.
And CBI has already taken over the case. So my humble submission is, when CBI is already investigating the case, the question of, my lord, again filing against second complaint will not arise.
This Dinesh Kallalli is a RTI activist.
These are RTI activities. He has nothing to do with this
All right.
property.
Yes,
My lord, that was challenged before the Supreme Court.
that is dismissed anyway.
Supreme Court, my lord,
Infractures are closed.
ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರು withdraw ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಆಯ್ತು.
Now, my lord, the next judgment is
Nalin
of
Kumar
Nalin Kumar
Katil,
Katil.
that's my judgment, I know, yes.
Page 46, my lord, it is in respect of locus standi.
Yes, sir.
That is, my lord, in respect of the first three cases as concerned.
ಈಗ first three cases, no locus is your submission.
No locus is my submission.
Who is,
And if
1 minute, next three ಹೋಗೋಣ ಆಮೇಲೆ. Yes, answer.
My friend has already made me a party in the petition. Since I'm an
No, that is
activist-
because you are the complainant.
Yes.
That doesn't mean a locus is absolved.
Yes, since I'm an activist, my lord, my limited role would be to assist, my lord, how the this honorable court and honorable Supreme Court have dealt with the Lodha committee matters. Honorable Justice Natarajan had quashed one of the matters, my lord, where Lodha committee issue was involved, and that was set aside and the matter was sent back for trial.
This is by you.
Sorry, my lord.
So who is the complainant here?
The complainant is another gentleman. Same argument was raised that he has no locus. He was not an activist, but he was a third person who never claimed any loss. In Supreme Court, they went to the extent of even opposing his locus. I can try and produce those papers, my lord, but that was brushed aside. Same thing, my lord. Lodha committee survey numbers, and they dealt with that property. One argument was raised that if any remedy is there, it is contempt. That argument also was dealt with by this honorable court, and ultimately the honorable Supreme Court, after some deliberation, set it aside. In this, in fact, the complainant turned hostile, my lord. He said, I have settled with the accused. Accused in this case was a police officer.
They have withdrawn the matter.
No, my lords, one,
At the time of hearing, counsel for the respondent submits that he may be permitted to withdraw his writ petition.
yes.
That is one.
So
thing,
he
one filed
withdraws,
here
but the state continues.
And which has been filed before the so and so with liberty to raise all the contentions at the time of framing of the charges.
Yes.
There's no determination on locus here.
But the judgment has been set aside.
That's all right. He is not relying on this at all. Why are you worried?
Right.
And now you come on merits independently, sir.
Well, as
What is your
far
locus?
as,
That's
as
all.
far as my contention is, as an activist, I have moved the police.
all.
Yes, that is,
No reply to any of his contentions.
well, it's, I was being led in this matter by Shri C.V. Nagesh. In fact, one of the impediments was argued by him in one of the matters. So, my lords, I would only request, as far as these matters are concerned, where I'm for the complainant, my lords may kindly have it next week. We'll respond through the learned senior.
What is it? How many times should? You,
Because, my lord, in fact,
can't you tell what your locus
in fact,
is?
my lord, my only humble submission before my lords is these Munne
I see.
Raju matters.
You are an RTI activist, no doubt about it.
Certainly, my lords.
Yes.
I'll leave it to my lords. And I don't want to say more because as an activist, I should not be saying more.
Yes.
But my lord, the other matters have
Others
no.
I'll come back. Yes. Yes, these three.
I think my friends' matters are there.
One, the moral, all three, I forget your name, sorry.
My lords, Ashwin Vesh, my lords,
Ashwin
Dinesh
Vesh.
Kalali is
Now,
only there in
this
65.
65.4 and 65.5.
Yes, my lords.
These three are the same? Yes, Bipin.
Yes, my lord.
The Dinesh Kalali matters, my lord.
Idella, RTI activist is the complainant.
Yes,
Yes, my lord.
All right, these three reserved.
65,
Third reserved.
65, 65.4, 65.5.
65,
0.5, my lord.
65, 65.4 and 65.5, three matters.
Just in this matter.
My lord,
65.1 and 65.
ಈಡಿಗೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್ ನಾನು.
ಅದು my lord,
ಅಲ್ಲ ಇದ್ರದ್ದು ಆಫ್ ಶೂಟ್ ಯಾವ್ದು? RTI activist ಆಫ್ ಶೂಟ್ ಯಾವ್ದು?
6510. ಅಲ್ಲ 6510.
Yes, sir. 1 minute, sir.
65.10.
10 ಆಮೇಲೆ
Output of 65.4.
then
That's
ಅದೊಂದೇನಾ?
ಈ ಮೂರಿಗೆ ಇದೊಂದೇ.
yes sir.
65
and 65.1.
Milord, I appear for the Pradeep Kumar who has been subsequently impleaded.
ಯಾವ್ದು 65.1 ಅಲ್ಲ, ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
Complainant is,
Impleading in a criminal petition in what capacity?
Milord, your lordships allowed the application because complaint is filed on behalf of the impleading applicant.
No, I'm
He is
sorry,
the-
my lord.
one
it is-
second.
In
He
in
is
the
the
connected
landowner of
matter,
the
your
property.
lordships have allowed, by mistake, my lord, it is shown here. In the connected matter, that is
ಇದ್ರಲ್ಲಿ
what-
one ನಿಮಿಷ sir.
Your lordships
One
allowed the
minute, these
application.
3 matters activates is the complainant, no doubt about it.
Complainant.
Then why are you
Complainant-
entering into that shoes?
Complainant is the power of attorney holder of the.
that is in 65.1 and 65.2.
65.1.
Yeah, we have not. yet
ಅದನ್ನ
come
ಇನ್ನೂ
there.
ತಗೊಂಡಿಲ್ಲ.
Yes.
Wait. Only 60.
Milord, to answer the question of locus standi, your lordship judgment is there in.
ನಿಮ್ದ್ರಲ್ಲೂ ಲೋಕಸ್ ಇದೆಯಾ?
Allah, that's what he has.
ಬೇಡ, ಅದು ಬೇರೆ, ನಿಮ್ದ್ರಲ್ಲಲ್ಲ.
ಯಾವ್ದು ಕೊಡಿ?
Milord, 2022, Ravi Gerard, Milord, in case of forgery and Milord, anybody can set the criminal law in motion is what.
ಕೊಡಿ, we'll see.
Para 14, Milord.
That is with regard to a trust, sir.
Okay, yes.
Forged documents and other things. He was a complainant there.
Para 14.
That I know. That is settled principle.
Yes.
That locus is alien to criminal law.
If you go into the merits of the case also, their only allegation is we have, my lord, violated the court's order, violated the order of the Lodha committee. Now, my lord, if there is any violation of any court's order, section 206 of the IPC might be kindly be seen. My lord, 206 ali, they have to give a complaint to the same court. The same court, my lord, has to take cognizance of the offence under section 195. Then they have to file an application under section 340 of the CRPC. They have to
Yes.
file an application under section 340.
Yes.
Without doing that, they cannot, my lord, say that just because there is a violation, my lord, the offence will not.
More on locus you have argued, we'll answer on locus.
Yes, ma'am. Now, my lord, 65.1 and 65.2.
ಇದು ಎರಡರಲ್ಲಿ ಹರ್ಷ ಡಿ ಜೋಶಿ is the appearing for the complainant.
Yes, ma'am.
ಅದ್ ಬೇಕು. Yes, sir.
But here, the lords may kindly turn to the memo, my lord, which was filed on 4/9/24. The matter was heard on the last occasion. The memo was filed.
Yes.
Lords got the memo, my lord, which was.
No, wait. ಇಲ್ವಾ? What is that?
My lord, the complaint was given by one Nagarajappa, who my lord says, adidya another copy idea. Allah, that was filed. In my lord, criminal petition 6277 and criminal petition 5835. A memo was filed.
Complaint is by Nagarajappa ಅಂತ ಇಲ್ಲಿದೆ.
Allah, in that case, my lord, we had filed a memo along with the copy of the charge sheet, with the copy of the settlement agreement which was entered.
Bipin sir, each of the petition li one synopsis ಹಾಕ್ಬೇಕು, whatever it is, not this way.
It is ready, my lord, I will file it. Allah,
Each of the there are about 11 petitions.
Allah,
Now
we are-
ಮೂರರಲ್ಲಿ ಲೋಕಸ್ ಆಯ್ತು, ಅದು ಬಿಡಿ. In ಎಂಟಕ್ಕೆ whatever is.
In respect of other only two, my lord, I am there. In that is, my lord.
ಇನ್ಯಾವ petitioners ಇನ್ಯಾವುದ್ರಲ್ಲಿ?
ಇದು ಅದ್ಯಾವ್ದು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. Criminal petition 5835 and criminal petition 6277.
Madam, one ನಿಮಿಷ.
My lord, 65.2 and 65.3 are the only two cases, my lord. 65.1 and 65.2 are the only cases which we are concerned with. Other cases, my lord, I am not aware how they are.
ಅಯ್ಯೋ ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾರೆ separate synopsis ಒಂದು ಕೊಡಿ sir.
I will file it.
And whichever Gautam is appearing in that, you file separate synopsis.
My lord, then
Madhukar
you also have it
Why is the
65.1.
ASG waiting?
Allah, the offshoot.
This is the offshoot of 65, 65.2 and 65.4.
Yes.
The predicate goes, that goes.
Yes.
We'll see, we'll answer the, ಅದು reserve ಮಾಡಿದ್ದೀನಿ. ಆಮೇಲೆ we'll hear you.
Predicate is heard and reserved.
Heard and reserved now. On the issue of locus, if I hold that the complainant has locus, then we will hear him on his merit. Yes. ನೀವು ಬೇರೆದ್ರೆಲ್ಲ synopsis ಹಾಕಿ.
65.1, 65.2, my lord, I will file my synopsis. Your lords may have it.
Yes. And in ಯಾವ್ದಲ್ಲ ಸುಯೋಗ್ is there, ಅದ್ಯಾವ್ದು?
ಅದು ಯಾವ್ದಂತ ಗೊತ್ತಿಲ್ಲ.
Where is Suyog?
Your lordship is held up in another court if you like.
Seriously?
If your lordship may permit me, I'll call him now.
Call him.
I'll call him if he's,
ಆಚೆ.
he might be in another court, your lordship.
ಕ್ಯಾಂಟೀನ್ ಇರ್ಬೇಕು ನೋಡಿ, ಕರ್ಕೊಂಬನ್ನಿ. ಎಸ್. ಅದಲ್ವಾ? ಓ, ಆಯ್ತು, ಎಸ್.
Lord, 65.1 and 65.2, my lord, I will file synopsis. Your lord.
ಆಯ್ತು, ನಿಮ್ದು ಯಾವ್ದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ. Wherever you are appearing, each case file synopsis, and ED we will hear it after the predicate offense matters are taken up.
I think every case is, there is a predicate offense which your lordships are hearing.
Every case there is a predicate offense. ಅದಕ್ಕೆ if I, that is why I'll hear you later. If the umbilical cord cannot be cut, we will take it later. Yes. Madhukar's favorite phrase ಅದಕ್ಕೆ. Yes. Next week ಎಲ್ಲ file synopsis, detailed synopsis. These three matra reserved.
Yes, my lord.
And the others file your detailed synopsis in all the cases.
The date might be fixed.
What is the allegation?
Yes.
And what are the others? Next Tuesday beda.
Tuesday.
Next
Interim
Tuesday
orders
beda.
of criminals.
List on 10th Thursday. Interim orders wherever subsisting will continue till the next date.
Much
Yes, yes. Heard the learned counsel Bipin Hegde appearing for the petitioner, the learned additional Solicitor General Sharvin Kamath along with Madhukar Deshpande appearing for the Enforcement Directorate, and Vaishnav
Ashwin Vaishnav.
Yes, so appearing for the respondent complainant. Three matters are, adರಲ್ಲಿ you are not there. Three matters reserve ಆಗಿರೋದು. ಮಿಕ್ಕಿದೆಲ್ಲ heard.
Much.
Yes.
Other than the three matters, my lord.
Other than three matters, others will come on 10th. ಇದು RTA activity.
My lord, Pearl group ಅಂತ.
ಅಲ್ಲ, yes, public spirited person. Yes.
Public spirited person, my lord, is engaging senior counsels going to the Supreme Court.
Public spirited, sir.
That shows, my lord, what is the spirit is. And what is the reason, my lord?
That's all right. Let's see. Yes. Yes, next.
66.
Preparing for the petition.
Start.
Thus, the learned AG is held up in another court.
No problem. Let him come. You start. The ender will not, then I'll proceed to pass orders. Last time I told you, the understanding is it will be heard.
Two other writ petitions.
You forget about two other. Answer this. That is pending in special orders. You tell me now.
My lord, the matter may kindly be passed over, my lord. Seniors on his legs.
Yes.
We'll go ahead.
Where is Udayholla sir, Dhyan Chinnappa sir, where are they?
The
matter
where Mr. Valla sir is appearing.
is
has
not been listed today.
Two matters which were directed.
Madam, ಯಾವ್ದಿದು hospital?
Two petitions, alert.
Totally four petitions are there, my lord. Two in which I appear for, two in which
All right. Who appears in these two matters?
I appear for the petitioner, my lord, in these two matters.
No, senior counsel ಯಾರು appear ಆಗಿದ್ದು?
Mr. Dhyan Chinnappa.
Where is he?
He is on his legs, my lord. It may be kindly passed over.
Pass over. Yes. Because he has given the scrutiny committees decision.
In sealed cover.
Yes. So we can't keep these tender matters.
Not to take up the matter tomorrow, I'll brief Holla sir also and I request him to be present in the.
Both
matter.
are bidders, my lord.
Any day convenient, tomorrow if it is convenient to the honorable court.
ನಾಳೆ AG ಇಲ್ಲ sir.
Ah.
When is he available?
No, no, pass over, get him. Yes. Two thirty ಮುಗಿತಲ್ಲ? Now go back to the list.
List continue.
Yours is 3:30, 10 minutes, yes.
Admission, 37.
I appear for the petitioner.
Yes,
You know, the petitioner, my lord, is the accused number 3. Is arraigned as accused number 3 in this. The offences are section 8, 22C and
NDPS.
NDPS Act.
I have quashed the other two.
Please, my lord. Your lordships have taken a view with respect
Voluntary
to accused
statement.
number 2.
Voluntary statement. Is that
No,
the
my
one?
lord, 50A, my lord. Controlled
50A,
delivery,
yes.
please. We filed a memo, my
Page,
lord.
page. Where is
Lord-
my order, madam?
My lord, we filed a memo on 1/4/25. Maybe seen. Page number 9, my lord. Relevant para.
Which memo?
1/4.
10/3/20. Memo, madam, which memo? ಈ memo ಇರಲ್ಲ, ಏನಿಲ್ಲ. Started matters.
We've passed one now also, my lord. Page number 1 is your lordship's order.
What happened to this? It's become final,
It's become final, my lord.
not challenged?
No,
And the other should be Justice Hemant. I followed that
Please.
order.
your lordships have also considered the present petitioner's, the bail order also, my lord, by the
This
past.
is Vishwesh Shetty.
Please.
Yes.
And held that non-compliance of section 50A will vitiate the entire
Anyway,
proceedings.
she's not there. Will intermod ಇದೆಯಾ?
It's them. Just pressing for
Correct.
it
But
because,
respondent should be there.
please.
Heard the learned counsel, Srimati Kirti Reddy appearing for the petitioner. Coordinate bench by an order dated 23/4/2024 had granted an interim order of stay. Que the other co-accused, this court, que the other co-accused, accused number 2, this court has quashed the proceedings in criminal petition 917 of 2024. The petitioner undoubtedly would get the benefit of the observations made by this court while quashing proceedings que the accused number 2. There is no representation on behalf of the respondent. Awaiting the appearance of the counsel for the respondent. List the matter next Thursday as a last chance. In the event there would be no representation, appropriate orders would be passed. Interim order subsisting will continue till the disposal of the petition.
It may be on 11th, my lord.
11th, Friday, yes.
I'm grieved. Obliged.
38.
For the petition. Correct. This matter will be taken up day after tomorrow.
Why, sir?
Senior counsel is engaged on his could be.
ಅಂತ ಏನ್ ಮ್ಯಾಟರ್ ಇದೆ ಇದು?
Your lordship has granted interim order in
And
so
then
far as
what,
wife is
sir?
concerned. And husband is required to be.
Husband?
Yes.
ಹಾಗಾದ್ರೆ.
And he need to come from Dubai. In view of the.
Oh, that matter is.
Yes, ma'am.
ಎಲ್ಲಿ ಜಗದೀಶ್ ಯಾವಾಗ ಬರ್ತೀರಾ?
Day after tomorrow.
You're coming day after?
He'll come within a week. ma'am.
Yes, list day after tomorrow.
Please.
Yes.
Interim order is there in so far as.
Interim orders ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
Second.
38.1 ಅಲ್ಲಿ interim order ಇದೆ.
7419.
ಅದೇ 38.1 ಅಲ್ಲಿ interim order ಇದೆ. Let that continue.
Yes.
B group 39.
Yes, for petitioners. First, I had filed a synopsis, my lords, in this matter.
2014.
Please, my lord.
Only the identification of the dispute is regarding the identification.
Of the property.
Please. Let's say.
ಏನ್ ಸರ್ವೆ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಆಗಿಲ್ವಾ?
Inspection we have conducted, my lord. ಅಲ್ಲಿ ನಾವು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಹಾಕಿದ್ದೇವೆ. ಯಾಕಂದ್ರೆ 25 ಗುಂಟಾಸ್ is left out, my lord. My lord.
ಇದು ನಾಡಪ್ರಭುದ?
ಅಲ್ಲ, ಇದು
ಅರ್ಕಾವತಿ.
ಅರ್ಕಾವತಿ.
ನಾನು ಸಿನಾಪ್ಸಿಸ್ ಜೊತೆಯಲ್ಲಿ ಸ್ಕೆಚ್ ಹಾಕಿದ್ದೇನೆ. ಬಿಟ್ಟದ್ದು
ಅಲ್ಲ, ಈಗ ಪ್ರಾಪರ್ಟಿ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ ಆಗ್ತಾ
The
ಇಲ್ಲ.
property identifier, my lords, what has happened, my lord, out of, my lord, total extent, my lord, 25 guntas has been left out in the notification.
Acquisition.
Please, my lord, it was
Ah.
left out in the accusation. My lords, I also own 25 guntas and the private respondent 4 to 7 also owns a 25 guntas. My lords, when the first notification was issued, my lord, they gave me an endorsement that my land has been dropped. My lord, the private respondent, my lord, where award is passed in favor of them. My lord. My lords, lordships may take the writ petition 7038 of 2015, my lords.
7038 ಕೊಡಿ madam.
Please, it's a connected matter. So, my lords, annexure is a preliminary notification, lordships find at page 1717.
You have filed your synopsis?
Please, my lords, I had filed it, my lords.
I have produced the notification along with my synopsis, compilation.
ಇಬ್ರು ಹಾಕಿದ್ದೀರಾ?
Please,
ನಾನು ಹಾಕಿದ್ರಲ್ಲಿ ಬರೀ ಇದು
And ಇದರಲ್ಲಿ ಸ್ವಲ್ಪ documents.
What is this judgment?
It's Lordship Justice
That is
Arvind
the
Kumar.
Correct.
committee referred the matter to the.
Adu, my lords, my petition is also one of the petition. On a review petition, my lords, restored back, my lords. Because my issue, my lord, grievance, my lords, is different.
Oh, it was recalled.
Recalled, my lord, and present petition is restored. My lord, that,
Yes.
my lords, in that
Based
petition.
on 17th, I'll go through the synopsis.
Please,
Enter ಮಾಡಿದ್ಯಾ?
ಇದರಲ್ಲಿ ಏನು entry ಮಾಡಿ?
Yes, next.
40.
Yes, Sarvana. ಏನ್ ಇಷ್ಟೆಲ್ಲ ಇದು?
ಇದು RMB second stage ಇದು annexure.
ಸರಿ, ಇದು applications ಎಲ್ಲ ಏನ್ ಇಷ್ಟೊಂದು?
That may not, there is a order that should be considered along the merits. Impleading applications ಇದೆ.
All the applications shall be heard along with the main matter. Registry not to print any of the applications as pending.
That's my request for day after tomorrow. Senior counsel is saying.
Day after tomorrow.
2014 matter, not sorry.
ಆಯ್ತು, day
Annexure
after
FLE.
ಆಯ್ತು, day after tomorrow. Next.
Entry matter may be kindly.
Entry matter subsisting will continue to the next date of hearing.
41.
17th, yes.
42.
Same 17th. We'll have it on 17th.
A little, my lord, in this case, I have to file the objection, my lord.
ಹಾಗಾದ್ರೆ 24th.
Much.
Learned Counsel K. Krishna seeks 2 weeks time to file statement of objections. ಯಾವ್ದು serial number?
42.
42. File statement of objections. Objections, if any, by the next date. List the matter on 24th.
43.
In this, my lord, we are not using any of the part of the portion of the land of the petitioner. My lord. We are only forming the road which was pre-existing, and only that portion is been, means, we are constructing a drain, my lord.
My lord, they are requiring, my lord, repeatedly, your lordship, another, also earlier when they appear, they have tried to file objections, but they have not filed objections. till
Any
this day.
objections?
They are sent, my lord,
Learned HCGP seeks 2 days time to file statement of objections.
Week, next Thursday, my lord.
ಆಗಿಲ್ವಾ ಇನ್ನು?
Objections, they are sent, my lord. I will just-
List the matter on,
First, can you see the
one ನಿಮಿಷ
order?
sir. List the matter on 10th. Objections, if any, by the respondent by then. ಈಗ dig ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
But they have already formed the road, my lord.
Already,
formed.
yes,
Yeah.
10th, we'll see, yes.
Yeah, because my party is 87 years old, lady.
10th, sir, yes.
44.
I appear for the respondent VDA lordship. Lordship, this is with regarding to Nada Prabhu Kempegowda layout. Lordship, they have not challenged the notification. They have only challenged a government endorsement asking to leave, denotify the land because it's a nursery. He purchased.
Covered matter alva ಇದು? Covered alva?
But apart from that, it is not maintainable also, your lordship.
But list the matter day after tomorrow.
Lordship, kindly have it on 10th. your
No, day after, ಅದು covered ಆದ್ರೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ, wait, yes, day after tomorrow. ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ layout ಅಲ್ವಾ? Yes.
No, but he is.
ಆಯ್ತು, whatever it is, we'll see day after tomorrow.
45.
22nd.
Response.
Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Objection ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ವಿ, subsequent ಬರ್ತೀವಿ.
No representation by the petitioner list. ಅದೇನ್ ಬೇಡ, 22nd ಅಂತ.
46.
Happy for the petitioner, my lords. Because this is the matter which is related to Dr. Shivarama Karanth layout in Sri Lanka, my lords. My lords, when,
Acquisition challenge ಮಾಡಿದ್ದೀರಾ?
please, my lords,
Acquisition ಅಂದ್ರೆ division bench ಗೆ ಹೋಗ್ಬೇಕು.
no, my lords, only submission is, during that time, they had verified this particular petition of mine, and they excluded by saying that it doesn't fall within the boundaries what has been fixed by the BDA during the acquisition.
You are
notice.
challenging acquisition mandamus in terms of the judgment of the apex court.
Please,
Wait, list the matter after 3 weeks. Ashwa the bench constitute ಆಗಿರುತ್ತೆ. Yes.
my lords, let them file objections.
Objections if
Serve the
any by
copy.
then. They'll file it. Yes. Next.
47.
My lord, 2 days time, my lord, kindly have it on.
Our short point was on the last occasion which came up. The lordship wanted to know, my lord, why this property was not left from acquisition. Because, my lord, the earlier order of the
We'll file, statement is ready.
BDA has, my lord, sent a letter to the state government saying that, my lord, in view of the order passed by the single judge, that the acquisition has to be left out, my lord.
My lord, 2 days, my lord, we will file.
Heard the learned counsel Bipin Hegde appearing for the petitioner. The learned HCGP seeks 2 days time to file to place the statement of objections on record. List the matter next Thursday, 10th. Next.
48.
Lord, 92 notification, my lord, there is no award and also position is not taken.
The respondent number 2 and 3 in this case, my lord. I seek a week's accommodation, my lord.
Intermodal ಇದೆಯಾ?
The intermodal.
ಏನ್ ಕೇಳಿಲ್ವಾ?
My lord, ಕೇಳಿದ್ವಿ, my lord,
You are in possession still?
Position still, I produce the documents, your honor. Kindly direct not to take any precipitated action in the view of.
1 minute. Yes, sir.
My lord,
The learned counsel TP Vivekananda.
no, I appear on behalf of Sachin VR, my lord.
Of Sachin VR, registry to delete the name of TP Vivekanand as appearing for respondents 2 and 3 in the light of Sachin VR being in possession. The learned counsel objections ಹಾಕ್ತೀರಾ?
We'll file objection.
Learned counsel seeks 2 weeks time to file statement of objections. List the matter on 22nd. The respondent shall not precipitate the matter till the next date of hearing. Precipitate the issue with regard to possession of the petitioner till the next date of hearing.
Achha.
49.
Appearing for the petitioner, my lord, this is the same case that came up yesterday with regard to the striking of defense and the squatting on the property. My lord, if I may take your lordship.
Who appears for the respondent? Avin.
Lord, my
Who are you?
advocate, I'm the defendant, Tejaswini. I request the honorable court to kindly pass over because he is on the way.
My lord, this has been the modus operandi even in the civil court and the matter will not reach if you're.
ಈಗ intermodal ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ಇದು striking of defense.
Striking of defense, yes.
And the entire abuse of the orders of this honorable court, my lord, not one order but 2 orders.
Yes, he is here.
My lord, if I can
Yes,
go
madam,
through
tell me.
the entire documents and the
I
modus.
asked you this preschool alva? When are you vacating ಅಂತ ಕೇಳಿದೆ.
Pre-primary school.
Whatever it is. When are you vacating the property? You said you will seek instructions, reasonable time
Please,
to vacate the property.
please,
ಯಾವಾಗ?
please. We are prepared to pay the arrears of rent.
I did not ask that at all. I said, when do you vacate the premises?
Who may be permitted to continue in the premises for a reasonable time. We have invested a lot of amount.
Correct, sir. When you invested, you can't default.
My lord, even the
They have
preschool
invested
which
lot
they
of
are running, there's no lease, so it is an illegality.
Because our license.
You
was
have to have
cancelled
a proper lease.
And anti-propaganda was made in the social media. We are not.
Fella,
able
that
to-
is not the issue at all. Now, are you going to vacate it or not? What arrears of rent ಎಷ್ಟಿದೆ?
58 odd, my lord. I've made a calculation of the same.
Other than COVID period, 27 lakhs. About.
How much?
COVID
We are-
period
we'll
also
pay.
has been looked into.
1 minute.
We are prepared to pay. We wanted some 1 or 2 months, 3 months time is there. Monthly. This month only we will pay about 10 lakhs and the remaining amount we will also pay monthly, reasonable time.
My lord, the
It's a primary
COVID
school,
period
pre-primary.
also has been looked into by the honorable judge while passing the order under 39 Rule 10. If I may take your lordship through that order, which is at page 90 and 91.
They are at liberty.
And
to
in
rec-
fact.
we-
1
we are
minute,
prepared
1
to-
minute.
We are prepared to pay that amount, except COVID period, we will prepare.
Now the school is functioning?
No.
Then?
License was cancelled, my lord.
Then what are you doing in the property?
Precisely.
If license is cancelled, what are you doing in the property?
We are training this mentally retarded children and all those.
No, if license is cancelled to run the school, what are you doing in the property? As simple as
Training
that.
this pre-primary school. Now we are not training.
Then what are you doing?
There is a 2.5 children, daycare children.
What are you doing in the property when you have no license to run the school itself?
Daycare children. Daycare.
Daycare. What daycare?
Children, the parents who are.
What license do you have for that?
For that, a license is not required.
My lord, if
That
your
doesn't mean you
lordship,
can squat over the property. Yes.
This license was cancelled long back by the.
They will answer on merits.
my lord, if I may just take your lordship through the relevant document. Firstly, if I may take your lordship through the order under order 39 rule 10, which is now they have deviated from or violated, that is at page 103, annexure G, the relevant para to be looked into with regard to the force majeure
No, the
clause.
striking of defense is rejected.
Yes, it's rejected. Why have we filed a striking of defense? Because the order that is at page 103, 15 July 23, has not been complied with. And therefore, we were compelled to file a striking of defense. Now, if I take your
What
lordship.
was this order 103?
103 is an order under 39 rule 10,
Rule
my
10,
lord, with
yes.
regard to deposit of arrears. Now, if I take your lordship through the reasons,
Now, what are the arrears as on today if they deposit?
58 as of today, 58 lakhs. Now, if I look, if I take your lordship through page 110, my lord, the lordship also looks into the covenant in the lease and license agreement, leave and license agreement, that is clause 14, which speaks about force majeure, wherein it says 3 months, a period of 3 months of leeway should be given if there is a question of force majeure. Now, if I read further, no doubt there is an agreement to the effect that due to the disaster, the defendant is entitled for a waiver of 3 months. Even in such a situation continues for more than 3 months, the defendant shall opt for the cancellation of license. In the present case, the defendant claims waiver of rent from 1/3 to 2020 to 1/3/2022 by referring to COVID-19. Now he claims this is looked into COVID-19 pandemic and also relying on the aforesaid covenant of the leave and license. Now, by going on the said covenant, the defendant is entitled to claim waiver only for a period of 3 months. In case he was unable to pay the rent for further period, he is required to opt for cancellation of the agreement. Under the said agreement, he has never allowed to squat upon the property forever. Admittedly, no government order issued to the effect that the educational institutions are exonerated from the payment of rents during that period. Further, the defendant has not chosen to pay the rent even after the prescribed period.
Now, deposit of arrears was directed page 114.
Yes.
Correct?
Yes.
Yes, that is
And
not
all this
complied.
has been, now, my lord, if I take your lordship
No,
to
not a
their
rupee.
very
Not a
objections.
rupee is paid after that.
Not a rupee. Now, if I take your lordship to their very objections that they have filed at page 67, they have put in the tabular format of the arrears. Page 67 for a moment, my lord.
Yes.
Page 67, they have serialized the contract period starting from 2014 and ending
This is according to them 51 lakh.
according to them. Now look at it, my lord, for a moment. From serial number 7, that is 1/7/2019 to 31/5/2020, they have paid, and over there, from December, January, they have not paid. December, January, February. Now March is when they have paid a partial amount of 10,000. So the COVID period has also been looked into while passing this order, is my humble submission. So they cannot now come and claim for COVID period to be waived. Now, if we look into their statement of objections that they have put, what are they seeking? 100% waiver and 50% waiver. From which stretch of imagination they're squatting on the property and abusing the process of the court of not adhering to the orders of this court. Now look at the conduct also, my lord, of this respondent herein. Now this order is passed 15 July 23 at page 103.
Yes.
After that, they file an MFA.
Hmm.
MFA is at page 121.
Hmm.
And that also gets dismissed because they filed this MFA against the order.
All right. Yes.
That also gets dismissed. And if I read the MFA order, it is dismissed with cause because again, the learned single judge appreciates that they have been squatting on the property. Do they pay at that period of time? No, they do not. They think it fit to just squat on the property even at the MFA stage. Then they, after that we filed a striking of defense because there is an order which has been willfully disobeyed and maliciously disobeyed. Now, the cantankerous behavior of the respondent, sorry for the use of words,
All right,
but this is how it is. Then they file an IA for modification of that order. Now, look at the modus operandi of this respondent, that relentlessly.
The modus operandi, the ultimate effect is to stay there.
Yes, just
Nothing
squat
else.
over there
Adike all
and not
modus.
to pay. So
No, now,
if
one moment. Now, if you're accepting payment of whatever they have said,
So
51
my
lakhs or
first
whatever.
point, my lord, is can we encourage such an attitude? Can they be heard on merits? I have certain decisions, I'll put it before your lordships, but finally I'm at your lordship's hand.
Yes. Judgments, Kodi.
Yes, sir.
You have nothing to
My
say?
lord, the proper MD is that to file execution petition to recover the amount.
ಎಲ್ಲಿದೆ ಇನ್ನು ಡಿಗ್ರಿ ಆಗಿಲ್ವಲ್ಲ?
No, for the interim
yeah,
order,
interim, all
interim
right,
order. They
yes.
can get it executed, my lord, instead of going striking the defensive, my lord. They even the interim order can be executed by filing execution. Is a only recovery of amount, recovery of arrears of rent. Only they can instead of because we have got a counter claim. We have got counter claim. We have paid court fee and all those things. We have paid, and we have got a very good case on merits.
For
Now
what?
the question.
Not paying rent and staying in the
No, my
property?
lord, they are during the, because the agreement itself says that, see, in extraordinary circumstances, they could not do, make use of the premises for which it was let out, then that period, it can be excluded.
No, even according to you, in the written statement, you have filed the arrears is 51 lakhs.
Yes, sir.
When are you paying it?
We are paying it, sir. We are paying. We are not being permitted to run the schools there.
Who is
Yes,
petitioner is not
yes,
permitted?
yes, the plaintiff came to the institution and they are making galata, disturbance.
There's
And,
no galata.
One minute.
My lord, one
Madam,
minute.
1 minute. Where
My
is your-
lord,
1 minute. You want to run
one submission, my
1
lord.
minute, sir. You want to run the school. You are running the school
Earlier, running earlier.
earlier. What?
Now, my lord,
Where is your license? When did it expire?
I think in 23.
23. So since 2 years, no school because of no license, not petitioner.
Yes,
Not
yes.
reason is not the petitioner.
Yes. We are
Then
not
why
running
did you
school.
say petitioner is making galata?
One thing, my lord, if we want to get a alternative premises, my lord, they are coming there and they are even instigating those persons not to let out the premises to these people. We lost 3 premises now.
If you don't pay, what can be done?
No, other persons also, we are not able to get premises. They are creating disturbance and all those things.
Now, when will you pay this amount?
Within 15 days, we will pay 10 lakhs. 5 lakhs DD we will pay, issue DD, and 10 lakhs check.
And when will you vacate the
And
premises?
the remaining every month we will pay.
When will you vacate the premises?
1 minute. Every month 5 lakhs we are paying till the arrears of payment of all the arrears. And we'll go on paying rent, current rent every month. As per stipulated every month.
My lord, we
You
want
want
the
premises.
premises because now the lady, that is the wife of the petitioner herein, her parents are aged. They are 80 years old and she wants the premises for their parents to live over there. Now, it's a bona fide reason and
Anyway,
we also
let's-
try to settle this, my lord. For a moment, we sent letters to them and look at the tenor in which they come. I mean, reply to our settlement offer. I mean, this is blatant. I have no words to say. I mean,
I'll read.
yes, please.
Yes. You said you have no words to say, so I'll read. Yes. Hand over the keys on 30th April 25.
ಏನು ಮಾಡಿಲ್ಲ.
ಅದು ಸುಮ್ನೆ ಏನು ಮಾಡಲ್ಲ. ಈಗ ದುಡ್ಡು ಕೊಡ್ತೀವಿ ಅನ್ನೋದು ಅಷ್ಟೇ, ಏನು ಕೊಡಲ್ಲ.
ಅದಕ್ಕೆ ಸ್ವಾಮಿ,
Payment
please.
ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, payment we have prepared.
ಸರಿ.
Payment we have prepared.
This is
We'll
like,
answer it on merits. Yes, on merits, what do you have to say?
Merits, my lord, order 39 rule 10, the direction is there to deposit rent only during COVID period, not the remaining period.
All right.
And the proper remedy is only to file execution petition for execution of the interim order also. They can get it executed. They, this honorable court earlier, while disposing of the MFA, observed that we are at liberty to get it executed. At the most, they can get it executed. Not to struck off the defense, because there is a counter claim is also there. There are so many objections, some contentions. I have taken so many contentions in my written statement, my lord. They are only because it is a commercial property, they cannot be used for residential purpose. They don't need, they are staying in
You
USA.
don't worry about how they will use it.
my lord, just one submission. The judgments I've given, basically it speaks about how when orders of the court is flouted, then a person cannot be heard on merits. That is the first. And under the Delhi Control Act, they have a stipulation that as soon as a case is filed, they need to pay the arrears. So that is the first case. And the second case is about flouting of the orders of the court and how cannot be heard on merits. The third case, my lord, is striking of defense is a valid ground to take for non-payment of arrears. And that was upheld in this case of Asha Rani, my lord. The relevant paras are 37, 38, 43 and 45. I have not mentioned 37, 38 and 43 in that column, my lord. And the last judgment is Suraj Mohammed, wherein it also speaks about, that is our Honorable High Court
Suraj
itself.
Mohammed. Suraj son of
Versus
Vasudevan anta ide.
Sorry, the
Suraj son,
last,
last page 33.
please, my lord, sorry.
You said Suraj Mohammed
Allah, Suraj versus Mohammed. GV
versus
Su-
Mohammed.
Suraj versus Mohammed.
Hmm.
So Adu, that is a case of our very own High Court, wherein the defense was struck down. And why? And over here, we are looking at an order of the year 2023 that has not been complied with. And then there is an MFA and a subsequent modification also that they filed, which was again dismissed. So such gross violation of the orders cannot be allowed, is my submission. And secondly, execution, coming to execution, just because I have a remedy for execution, does it militate my right to ask for striking of the defense, knowing the conduct and the abuse of the order? And that is given by the statute. If you look into the statute, any abuse of orders, I have a right to seek for striking of defense. And this is not talking about 6 months or 4 months. We are talking about 4 years of not adhering to an order. And now also, even when we speak about settlement, they are not coming forth. They want 100% waiver of payment of arrears. Is my humble submission.
Yes.
Yes, sir.
Only they can go for execution.
My lord, my,
That is
Adho,
my defense.
since it is now before the civil court, a time-bound manner of it being disposed over there.
You want to
and this-
withdraw?
No. No. When your lordship also
Vasu is
orders
the final lord, yes.
on merits, please let there be a time-bound for the civil court to finish and wrap up also.
We'll see. Heard reserved.
Much obliged, my lord.
Madam, for 3:30 matters. More.
230 more matters. Orders number 1, Chukkareddy.
The partition should filed by the sister, my lord. The properties acquired by the father under the judgment and decree, my lord. And trial court
ನಾಳೆ
has,
ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ?
no, my lord, the trial court has refused to grant the interim relief or not to create third party right against their elder brother.
All of them are contesting defendants?
But this is the ex parte interim order has not been granted to the petitioner, my lord. Some
ಈಗ
properties are,
ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರ ಅಲ್ಲಿ?
No, my lord, next date is 10/7, my lord. And the, my lord, some portion of properties are acquired by the
Just
National
a ma-
Highway. And
Heard the learned counsel appearing for the petitioner. The petitioner shall serve the defendants by way of hand summons and file an acknowledgement of such service by the 7th of July 2025. List the matter on 14th July. Till such time, the respondents, defendants are restrained from alienating or creating third-party rights. Yes.
Bill number 2.
In the event no steps are taken to serve the respondent, the interim order would get automatically vacated. Yes, next.
Bill number 2.
Yes. The plaintiff had filed in the commercial court, my lord. At the time of the cross-examination, it came to light that he has filed a suit for different thing, different cause of action. He sued for 50,000 amount and 2 lakh 60 as the cost for the non-returned cylinders.
Cylinder? Gas cylinder?
Gas cylinders. Gas cylinder. We had to return the thing only after using the cylinders. He hadn't disclosed. At the time of the cross-examination, we came to know, it is highlighted that he filed for a different cause of action from to a different time. Then he filed additional documents at that time.
What are you challenging, sir?
The impugned order number 8, the trial court rejected my application for production of document.
Order 11, Rule 1.
Yes, my lord.
Commercial wise,
Commercial court.
Yes.
My case is based only, in the beginning, he had filed the suit, wherein we filed a written statement also, thinking that he is demanding the cylinders pertaining to one particular transaction. Then, actually, in that, at the time, the advocate abandoned the suit.
No, what? Abandoned the suit?
Means he did not appear before the thing, he did not file a thing. Then email, I came here for in appeal. Then again, it was remanded back to the trial court for fresh from the starting point of cross-examination. There, when I was cross-examination the thing, then I came to know that he hadn't pleaded properly. It is all disclosed in the.
Who had not pleaded properly?
Plaintiff, my lord.
You are the defendant.
I am the defendant.
Why are you worried about his pleading?
No, because what he is pleading is for 23 cylinders. We thought it is already covered. What we had already returned. Then.
Anything else, sir?
One moment, sir.
Yes.
What he is asking for the 23 cylinders, I have a regular order. I mean, we have maintained regular records for it.
Very gas is cylinder.
That's all. Only now several. Even I filed my earlier IA number 7, demanding the plaintiff to give the serial numbers of the cylinder so that I can verify in my account and
serial number of cylinder.
Yeah, that is how when the serial number, when the cylinder is returned, the numbers are returned. It is not that empty. Only those particular cylinders have to be returned.
Commercial OS of 2022.
Yeah, this, my lord.
The court will decide it. No,
he has already rejected. It is posted for further evidence.
Correct,
I do not have any further evidence, my lord. This
Then
is the
case
only
goes.
thing. Unless these documents show that I have already written those documents and they were pertaining to the year 2008. That is why he was avoiding all.
When did you file the WS, sir?
In 2022, that time it was not known to the person. It was not understood properly.
Oh,
yes.
Can't
no,
help,
earlier
sir.
advocate.
Can't help, sir.
No, if this is the document, these documents are not filed and marked. I will not have any document to show that I have written written the cylinders, my lord. One opportunity might be, please, my lord. Or else he belatedly he brought the and he filed the additional documents after my cross-examination. Plaintiff filed
additional documents were not filed after cross-examination, after WS.
No. While even I will give you the thing, my lord.
After you filed WS,
after
you filed WS, additional documents were filed.
No. I
Anyway,
was cross.
All right, you serve on the plaintiff.
Yes, my lord. Until then, kindly.
Until then illa, serve on the plaintiff.
Tomorrow is the hearing date, my lord.
Take an adjournment.
He has already said that I am going to post for argument if you don't have anything.
You should know the art of taking adjournment. Yes. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 9th in preliminary hearing. Yes.
RB Sadashiv.
Plaintiff's writ petition, my lord. Plaintiff filed an application for appointment
In
of
the
the
meantime,
commissioner.
compliance with officer elections. NVJ ಕಾಣೋದಿಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲ ಇದು ಅಡ್ಡ ಇದೆ. Yes.
The appointment of a commissioner was made by the honorable court, and commissioner went to the spot and his report was opposed by both the parties, plaintiff and defendant. But the learned judge allows the application, says the report is correct. And
Why was the commissioner appointed?
To find out
For the
whether
court's
there is-
problem or
whether
your
there
problem?
is any encroachment. Our case is for
Encroachment.
declaration and for mandatory injunction to remove the encroachment. And the
Heard-
commissioner herself
Heard the
says,
learned counsel appearing for the petitioner, Shri R.B. Sadashivappa. Petitioner shall serve, who is the contesting plaintiff here? You are the plaintiff, sorry. The first contesting error.
1, 2, 3.
both, all the three men.
The petitioner shall serve on the counsel who represents the respondent defendants before the concerned court. The issue that brings the petitioner second plaintiff to the court, to this court, is an order of the concerned court accepting the report of the court commissioner appointed by it under Order 26 Rule 9, notwithstanding the fact that both the plaintiff and the defendants objected to the report, as according to them, the report did not indicate what was the brief to the court commissioner. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List the matter on 17th. Not 17th, sorry. List the matter on 16th.
Please, wait.
Serve ಮಾಡಿ acknowledgement file. Yes, next.
Number 4, Vandana P.
Ozone Urbana. ಹೂ ಮಾಡಿದ್ರ ಇವರು? ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗಿರುತ್ತೆ ಓಝೋನ್ ಅರ್ಬಾನ್ ಅಷ್ಟೇ. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್. ಎಸ್. No representation on behalf of the petitioner. List the matter after 4 weeks. ಬರ್ತಾರೆ ಈಗ. Yes.
In the hearing, cell number 5, Sharon case.
This is the plaintiff's writ petition, my lord. Suit for specific performance.
ಏನಾಗಿದೆ?
The agreement is at annexure B, page 17. Now, my lord, as per annexure D, the deficit court fee is directed to be paid by the honorable court, my lord. Page 32.
ಏನ್ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ವೆಕೆಟ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿರ್ಲಿಲ್ಲ. ಇದರಲ್ಲಿ ದಿ ಅಗ್ರಿಮೆಂಟ್ ಆಧಾರದ ಮೇಲೆ ಡಿಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಲಿಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಈಸ್ ರಾಂಗ್, my lord. It's my respectful submission. My lord, may I read page 32?
Day after tomorrow in plenary hearing.
ಅಲ್ಲ, ಇದು ನಾಳೆಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
The concerned court shall defer its proceedings to the next date of hearing. Yes.
May I seek for a hand delivery?
Yes, next.
Mahesh BJ.
Writ petition by judgment debtor, my lord, page 24 is the order. But by virtue of a cryptic order, my lord, then arrest warrant is issued. But without
ಅದಕ್ಕೆ ಏನು ಡೀಟೇಲ್ ಆಗಿ ಬರಿಬೇಕಾ?
Allala, there is, what I, my lord, meant is that there is no inquiry or no satisfaction among the, but by the executing court with respect.
Satisfaction is your conduct ಅಷ್ಟೇ.
No, my lord, no, it is an ex parte judgment, but I filed miscellaneous.
That you tell me. Ex parte judgment
Yes,
ಬಗ್ಗೆ ಬನ್ನಿ.
there is a miscellaneous petition.
Yes.
Under 9 rule 13.
Come
But
to
both
page
the matters are
page
not-
33.
Yes, my lord, both the matters are not being taken simultaneously, my lord. My application for stay is still pending in the miscellaneous proceedings.
The petitioner is before this court calling in question an order of the concerned court which issues an arrest warrant to the petitioner. The petitioner suffers an ex parte decree and files a miscellaneous petition in miscellaneous 4 of 2023 seeking recall of the said ex parte decree. In the meantime, the impugned order is passed, notwithstanding the fact that the miscellaneous application is still pending consideration. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. The petitioner shall serve on the counsel who represents the decree holder, State Bank of India, by the next date of hearing. Serve and file an acknowledgement by the 7th, list the matter on 18th.
Seal number 7, Shri Badrinath.
ಇಲ್ಲ ಇದು ಹ್ಯಾಂಡಲ್ ಕೊಟ್ಟಿರಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ಬಿಡಿ. Your flight landed now.
I'm sorry, my lord. I was, my lord, in that public interest litigation, my lord, that KCA matter.
So you should not come here.
I apologize, my lord. It's not so. I was just on my legs there.
That's why I thought your flight landed. Yes. That is dismissed.
I'm sorry, my lord.
Arrest warrant, ozone arbana mele ಏನು
bit of a biting arrest, my lord. I have only one legal ground.
You have to wait till 5 o'clock.
I'm so greatly obliged. Greatly obliged.
I have passed it over.
I greatly obliged. In any case, my lord, it's a pleasure to wait in your lordship's court.
Correct. That's why I passed it over by 4 weeks.
Greatly obliged, my lord. Greatly obliged. My lord should kindly recall the 4 weeks and my lord make it, my lord, till 5 o'clock. I know a case, my lord, there is to be imprisonment till the rising of the court. My lords may kindly impose that imprisonment upon.
All right. Yes, sir.
So greatly.
Yes.
I shall wait.
ಇದು ಯಾವುದು madam?
7, Shri Badrinath.
ಯಾಕೆ ಕೇಳಿಸೋದಿಲ್ವಾ? ಇಲ್ಲೇ ಇದ್ದೀರಾ, ಎರಡನೇ ಸರಿ ಕರೆದಿದ್ದು.
It's a filing of the return. There is a delay in filing of the return statement.
ಕಮರ್ಷಿಯಲ್ ವಾಯ್ಸ್ ಅಲ್ವಾ?
ಇಲ್ಲ Karnataka.
ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ?
2 years, 4 months.
Why?
Where
ಕಾರಣ?
I am not feeling well and I have
ನಾಟ್ ಫೀಲಿಂಗ್ ವೆಲ್. ತುಂಬಾ ಈಸಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗೋಯ್ತು.
Where documents also not been secured.
ಅದು ತುಂಬಾ ಈಸಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗೋಯ್ತು. 2 ವರ್ಷ ಬೇಕಾಗಲ್ಲ.
That is the only where I had filed an application came to be rejected.
Plausible explanation ಕೊಡಬೇಕು. ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಏನಿಲ್ವಾ?
No, I'll produce the medical certificate.
ಏನು ಆರಾಮಾಗಿ ತಗೋಬಹುದು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. WS rejected.
It's already on the record.
If it's not a commercial OS, ಸ್ವಲ್ಪ.
It may be.
You serve on the plaintiff. Plaintiffs.
Other respondents may be dispensed, only the plaintiff.
Petitioner shall serve on the counsel representing respondent 1 and 2, plaintiff 1 and 2 before the concerned court. List the matter on 17th, ಮುಗಿಸ್ಬಿಡೋಣ.
Till then.
Further proceedings before the concerned court shall remain stayed till the next date of hearing. 16th, sorry. Yes, 16th. Sandesh.
Number 8.
Let's, line, petitioner has filed in suit for injunction before the civil court, my lords. She's a tenant. Let's, without giving notice, my lords, she has closed one shutter, my lords, and also disconnected electricity also, my lords.
One shutter?
Yes, there are 2 shutters.
ಇನ್ನೊಂದು ಶಟರ್ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
My lords, they disconnected electricity also, my lords.
ಯಾವ ಶಟರ್ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಕರೆಂಟ್ ಇಲ್ಲ ಅಂತ. ಎಷ್ಟು ವರ್ಷ ಕೊಟ್ಟಿಲ್ಲ ರೆಂಟ್?
My lords, rent has been paid up to date. Last month rent they have not received. Still my advance is with her, with him only.
ಎಷ್ಟು ಅಡ್ವಾನ್ಸ್?
Advance 60,000, my lords. Rent 7,000. Now 8,000 I'm paying, my lords.
What shop?
Tailoring, my lords.
Tailoring. ಕರೆಂಟ್ ಇಲ್ದರೆ ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಟೈಲರಿಂಗ್ ಅಲ್ಲಿ.
That's impossible, my lords.
ಏನ್ ಕೇಳಿದಿರಾ ಇಲ್ಲಿ?
My lords, interim order has not been granted till, my lords, not to dispose without due process of law, my lords. I will vacate, my lords, within 90 days, my lords. I want only 90 days time because she is not interested. Landlord is not interested to continue with me. That is why, my lords.
Petitioner to serve on the counsel who represents the respondent defendant before the concerned court. Till the next date of hearing, the petitioner shall not be dispossessed from the property. List on 22nd, 21st.
Order may be handled, my lords.
Madam. Taylor.
I will submit a memo.
Yes.
9, VB Sidram.
Appearing for the petition, my lord. My lord, petitioner is the plaintiff.
suit is for the partition and separate position.
Hmm.
That after completion of the evidence, petitioner has filed an application at page number.
ಏನ್ 670 ನಾ?
ಇಲ್ಲ, for 26 rule 10A.
Ah.
To compare the admitted signature.
Signature.
With the
Who has
signature.
filed?
The petitioner plaintiff has filed.
That is rejected.
That has been
Correctly rejected.
My lord, after completion of the evidence, to assist the honorable court for a sound adjudication of the dispute in controversy. It is not for collection of evidence. Evidence has been already completed. After completion, rightly at the prime stage, we have filed the application. my
I
lord.
serve on the defendants. Who contesting ಎಲ್ಲರನ್ನ?
My lord,
The petitioner shall serve on the counsel who represents all the defendants before the concerned court and file an acknowledgement by the 7th.
my lord,
List the
my
matter.
lord, second respondent
One
is,
ನಿಮಿಷ.
is
List the matter on 10th till such time further proceedings shall remain stayed.
my lord, notice to D2 only, my lord, R2. He has filed objection to IA. Others have not filed objection.
Memo
I filed.
ಮೆಮೊ ಹಾಕಿದ್ಮೇಲೆ ಅದು ಯಾರ್ಯಾರಿಗೆ ಅಂತ ಅದು ನೋಟಿಸ್ ಮಾಡಿ.
Yes, please.
By 7th. In the event no steps are taken, interim order would stand automatically vacated. ಅವರೆಲ್ಲಿ ಹೋದ್ರ? ರಾಮಸುಂದರ? ಕರೆದ್ ಬಿಡಿ ಅದು ಒಂದ್ಸರಿ. ಪಾಸ್ವರ್ಡ್.
Number 4. Vandana.
Kindly short password, my lordship.
Again, you're not there.
5 o'clock ಅಂದ್ರಲ್ಲ, my lordship.
ಓ 5 o'clock ಅಂತ ಹೇಳಿದ್ನ. 4-5 ಆಯ್ತು ಅದಕ್ಕೆ. Yes. For the hearing.
3:30 PM. 67.
Yes. ಈಗ ಶುರು ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
senior counsel is
ಸುಪ್ರೀಂ ಕೋರ್ಟ್
online.
ಇನ್ನೊಂದು ಡೈರೆಕ್ಷನ್ ಬರ್ಬೇಕಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, we've been ready, my lords.
Then who? I am not ready.
ಇಲ್ಲ, he's online.
Please, your lordships. With your lordships, kind permission, may I assist
Who's
your lordships
appearing?
online?
Mr. Vaibhav Gagar for petition number 2.
All right, yes.
My lords, I appear for petition number 3
Yes.
in the matter.
Which
My lords would
that's
recall your
67,
lordships.
right?
I'm so sorry.
Yes, sir.
Sir, your lordships would, may recall this matter. This is a matter that had come to your lordships in the
Yes,
first
yes.
round as well.
Indian Bank went in appeal and
And-
back here.
That's right, my lords.
Yes,
And
sir.
if I could just please have your lordships have a look at the Supreme Court order once, because all rights and contentions were left open, and the Honorable Court remanded it back on the limited point that whether it was a defaulter or not was not going to be the issue alone by itself. Having said that, there are a couple of paragraphs which may be relevant just to put the case in context, my lords.
Just a moment, sir. Where's the Supreme Court order?
Supreme Court order.
You've not placed it?
We have, my lords. At the time of. You have a copy?
It's here, yes. Yes, sir.
Please, your lordships. Your lordships would kindly just have from para 6 onwards. We have perused the relevant findings of the High Court. In para 14, the High Court noted that the review committee of the appellant bank is examining the question whether the first respondent can be declared as a defaulter. In paragraph 15, the High Court concluded that the action of registration of crime is on the footing that the first respondent is a willful defaulter. Thereafter, the High Court refers to the interim order in which statement of learned counsel for the appellant was recorded that the review committee is seized of the matter. Only on the footing that the outcome of the decision of the review committee will affect the FIR, the learned single judge has interfered. We have perused the allegations in the FIR. The same do not depend on the question whether the first respondent becomes a defaulter. Therefore, in our view, the grounds on which FIR has been quashed are not at all legal and proper. Only on the ground of pendency of the review proceedings on the question whether the first respondent is defaulter, the High Court could not have quashed the FIR without allowing the investigating agency to investigate. Learned counsel appearing for the appellant, the civil appeal so-and-so, is right in contending that in the petition under 482, not a single ground of challenge has been pleaded. Faced with these difficulties, learned senior counsel appearing for the respondent submitted that an opportunity may be granted to the respondents to amend the quashing petition for incorporating the grounds of challenge, which has been done there. Now, my lords.
Yes.
For the reasons recorded above, impugned judgment and orders quashed and set aside, and the criminal petition number so and so is restored to the file of the High Court of Karnataka at Bengaluru. Restored petition shall be immediately placed before the roster bench. High Court will permit the respondents to amend. Thereafter, the High Court will examine the petition afresh and also the question of grant of interim, which your lordships have passed. To enable the respondents to move the High Court, we direct respondents shall not be arrested in connection with so-and-so, and all issues, paragraph 12, all contention in the restored petition are kept open to be decided by the High Court. My lord, subsequent to this, the certain additional grounds, etc., were also taken before your lordships. And for your lordship's consideration over here, some issues, with greatest respect, that your lordships may want to have a look at in the
Yes.
background of this is,
Yes.
number one, my lords, as I will be showing factually speaking, that the transactions date back, the relationship between the banks and us, that's the petitioners, relate back since 2004. And I'll be giving details of
One
that.
clarification, sir.
Please,
Sorry to
please, your
interrupt, but what happened before the review committee?
It's still pending, my lords. To the best
Still
of my
pending.
knowledge, it's still pending.
All right. Decision pending. How long do you take?
My lord, they have been given an opportunity to appear before the revenue committee, but they have not.
It's 2 years.
No, my lord, it was issued
That only
3
hap-
months, 4 months.
All right. Yes. Yes, sir. Continue.
Yes, only 3 months back, I'm grateful to my learned friend to point that out.
All right. Yes, sir.
We have been called upon. So some of the questions for your lordship's consideration,
Yes, sir.
would be, my lords, whether in a transaction of this nature, which I would be humbly submitting before your lordships for, is a pure civil dispute. There is no criminality which should come to the fore, especially the sections sought to be invoked in the present case. Considering that the transactions without any default or problems started way back in 2004, until the time that I was declared to be a defaulter in 2019, I'd consistently serviced all loans, etc. To say that there is a case of cheating in this would, with greatest respect, be a bit of a travesty, because there cannot be an inducement, a dishonest inducement, which led to the transaction happening, when for 15 years there was none. Be that as it may, that's something that I would be placing before your lordships.
Yes, yes.
Secondly, my lords, the question for your lordship's consideration would be whether the CBI in this case at all has jurisdiction. And the reason for that I would be putting forth, my lords, is number one, as per the Honorable Supreme Court Order Para 7, the issue of defaulter cannot be the premise of launching the criminal case and or of the quashing of the case. Number two, the fraud circular itself, therefore, would not be applicable in this particular case. Number three, the FIR, when I show to your lordships would see there are no allegations against public servants whatsoever. Whatsoever. In fact, there's a positive statement to say that nothing has been found against any of the public servants. Number four, there is no consent which has been taken under Section 6 of the Delhi Police Act. Number five, there is no sanction under Section 17 of the Prevention of Corruption Act.
Are you a public servant?
No, my lords, I'm not. But my point, my lords, relating back to the third point, that there are no allegations against a public servant whatsoever. And if the fraud circular is not, I'm sorry.
Against you, the company rather. The offense is 420, 468, 471 and 120B.
Please, my lords.
That's it.
Read with
the Section 713(2) of the PC Act is against public servants. I think there is no allegation against them.
No allegation, and therefore that has to be out of the purview.
That's all.
Unless they were alleging that it's a 120B and therefore in conspiracy with the public servants, etc. If your lordships would see the complaint, there was, I mean, my reading of it was that's what they were alluding. That's right. So therefore, only to that extent that this case would not come under the Prevention of Corruption Act whatsoever. And therefore, the question would be whether the CBI at all gets jurisdiction in this matter. And then, my lords, would see, as I said, positive statement that there is nothing whatsoever where the crime or prevention of corruption, and if the defaulter issue is not something which becomes the premise for
That's all you
launching.
need to, that's all you need to convince the court, because section 420 on the face of it will not get attracted if you see
I'm
its
so grateful.
ingredients under section 415.
That's
It's an
right,
agreement,
Manoj.
it's an agreement of loan was being paid, it is defaulted. Where is the
That's
question of luring the bank by
I'm
the
so
accused
grateful.
to grant loan? There is nothing like
I'm
that.
so grateful.
A subsequent default cannot become an inception cheating, because right from the inception, his intention
I'm
should
so
be
very grateful.
dishonest, correct?
Absolutely.
So section 415 ingredients, if you see, it does not
Yes.
meet even to its iota in this case. So 420 is over. 468,
420.
where is the question of forgery?
That's right, my lords. In fact, I'll show, therefore, I'll take your lordships to the complaint
Yes.
and show that actually none of the provision sections sought to be invoked can even prima facie, let alone ex facie, even prima facie be made out or made applicable in this case. And that read in the context, my lords, also, and is something that your lordships would keep at the back of his head while looking at the complaint is, the entire basis of
No,
launching
if
this,
I
quite apart from,
remember
I'm so
on the
sorry.
last occasion, what was argued is only that what I have written. They did not
Right.
argue on the ingredients of the offense. I would have answered that also.
I
Now it
bow
has
down,
come
my
back to
lords.
answer, because earlier it is only because of the review committee, that submission was restricted to that. Yes.
That's right. That's right. That's right, my
Yes,
lords.
yes.
In fact, in hindsight, we're always better armed in hindsight. I would have perhaps gone with this argument to begin with, to say
So
how are
this
the
is
allegations
a
made
better
out.
submission than that.
But that found favor, and with greatest respect to the Honorable Supreme Court, my lords,
Yeah,
I would
that's
very
correct. Yes.
respectfully disagree, but be that as it may.
Yes.
It is what it is.
That you can always say, yes.
At the risk, my lords, at times.
Yes, yes, sir.
And my lords, just one more very important point, and this would also tie back in to the fact of the allegations really not being met at all, is that the entire case has been launched because of it becoming a defaulter. Now the court says, Honorable Supreme Court says defaulter is not an issue. The fraud circular is not going to be applicable as per the contentions of the opposite side. And this is based on a forensic report, an audit report that was conducted, my lords. As per the procedure, an
Yes.
audit report was conducted.
Yes.
The complaint is a verbatim repetition of the audit report,
Yes.
where they say, oh, this entire scam has been uncovered. But
Yes.
what I will show to your lordships is that because the case is also before the NCLT in IBC, my lords, under the Insolvency and Bankruptcy Code. Over there, the COC, that's the Committee of Creditors, my lords, took cognizance of the audit report.
Yes.
And they categorically held that no case of fraud is made out. So the very same banks which have
Where-
launched this massive prosecution.
Which page do I get that?
Yes, if your lordships would please have straight away the audit report, my lords.
Where is the?
If your lordships would have page 26 of IA for additional documents.
Which IAS, sir?
I'm so sorry. If your lordships, if my learned friend could just assist us on that.
Yes,
My
where
apologies.
is
I
it?
should have had that number.
That they gave. Additional, it's here, it's here.
Yes, I'm very
Page
grateful.
20.
If your lordship, page 26, this is annexure N.
Minutes
for
of the
Nagpur.
second meeting of the COC.
That's right. That's right, my lords. Your lordships would see Committee of Creditors is the Indian Bank, Bank of Baroda, etc.,
Correct, correct.
which
Yes.
are also the complainants. Please have
Yes.
page 40.
Yes.
May I read resolution number 3, my lords?
Yes.
And my apologies, I said audit report is a forensic report, my lords. Appointment and approval of fee for forensic and transaction auditors voting, so and so. Chairman appraised the COC that Regulation 35A of the Insolvency Bankruptcy Board of India process, Regulation 16 requires the RP to form an opinion, that's a resolution professional, my lords, to form an opinion whether the corporate debtor has been
Yes, sir.
subjected to any
You
avoidance.
can
So
straight
and
away
so.
go to this, said forensic audit report covered period so and so. Forensic
Yes.
auditors did not come across any transaction which in their
I am
opinion
so
may be
grateful.
categorically and conclusively termed as fraud.
That's right, my lords.
That is what you wanted to read?
That's what I wanted to
Yes.
show, my lords.
Yes.
And then, my lords, they have directed a further, in view of the above, chairperson opined transaction audit need to be conducted for the period of 5 years. So effectively, very clearly, quote unquote, auditors did not come across any transaction which in their opinion may be categorically and conclusively termed as fraud is their own case.
Yes.
If that is the premise of the entire case, now please let's have a look at the complaint to see whether any of the allegations can at all stand with or without this as well.
Who is the complainant? Bank. Madam Mala. Yes. I mean, Indian Bank.
My lord, I'm
Wait,
very
wait,
sorry.
I'll come back to you.
No, before that, I'm very sorry to say I do not have this IA which he is talking about.
Your COC, madam.
Yeah, yes, my lord, but I don't have it with me.
Please take
He
it.
said he has sent a copy.
Take it and I have flagged it also. Yes. Yes, sir.
Yes, sir. If your lordships would have the FIR, my lords, the complaint is, I'm so sorry.
So new counsel has come on record.
Yes.
If your lordships would have the FIR, which your lordships would find at page 68.
Yes.
And relevant at page 69,
Yes.
first information contents at the bottom, para 12. A written complaint dated 23rd December 2020
Clause
of
12.
so.
Yes.
12.
Yes.
A written complaint dated so and so, dated 23/12/2020 of Shri so and so GM Zonal Manager Indian Bank, Bangalore, has been received in this office on 28/12/2020. The same has been made as a part of this FIR and is enclosed. The allegations in the complaint disclose commission of offences under 120B, read with 420, 68, 71, read with the PCA provisions, my lords. As we committed by Messrs Steel Hypermart India Private Limited, Shri Mahendra Kumar Singhi, A2, Director of the company, Suman Mahendra Kumar Singhi, A3, Director of the company, and Shri Mukesh Surana, Chartered Accountant and Partner of Messrs So-and-so, Statutory Auditors of Steel Hypermart, and unknown public servants and unknown others. Hence, a regular case under section so-and-so is registered against the above company, persons, and unknown public servants and unknown others on this basis. So no inquiry, nothing, complaint received. They say very well, let's register the FIR, and please have a look now at the complaint which your lordships would find at page 71. This is dated 23rd December 2020, my lords.
Yes, sir.
I'm sorry, I'll trouble your lordships. Only way for me to read it is to show the entire contents of this.
No, not necessary. Come to page 77, paragraph 10, sir.
77. I'm very grateful, my lords. Page 77, para 10. Form 1 was filed with RBI on 7/11/2019. Forensic audit, which your lordship saw, on behalf
Yes.
of the consortium banks was conducted by Satyaprakash Mangal and Companies, Chartered Accountants, New Delhi, covering the period from 17 to 19. Their report dated 27/9/19 listed several fraud pointers. Gist of forensic audit is presented below. My lords, read what the forensic report actually said over there. So
No,
the entire
the
premise.
forensic audit report is inter alia the basis of registration of the crime by the CBI. And
Yes.
the bank itself is of the opinion that there was no fraud. The forensic audit report indicates that there was no fraud played by the petitioner.
Absolutely, my lords.
So the submission is, how could it become a crime, particularly of 420 or 120B? What is 468 and 471 doing here? I want to know, that's all.
My lords, with greatest respect, I would ask myself the same question as well. But let me try and go through the complaint and try playing prosecution for a moment as to how they're trying to do this.
Yes, madam, you will have to answer.
Yes, my lord.
In a case where it is a loan between the bank and the borrower, and the loan is being serviced appropriately up to a particular point, it becomes a non-performing asset on account of a preliminary default and gets into chronic default, and you term the borrower as a chronic defaulter or a fraud or willful defaulter, whatever name you call. how does, where is forgery here under 468 and 471?
My lord,
420, yes, we will answer. 468, 471, how do you get it?
why? Because, my lord,
Why?
why? Because
Uh,
this loan is not like a simple housing loan you give at one point of time, then you.
No, I am
start
not
recovering.
referring
No,
to
no,
housing loan at all. Yes, yes.
not such as that of an housing loan where you give a loan and start recovering month-wise. This is based on the business transactions and it is a business loan. When a company starts to give out financial statements where the turnover is boosted up on transactions of sales and purchases, which are not in terms of machineries or whatever it is dealing with goods, but only in paper, fudging the documents, that becomes forgery.
Oh,
So they have-
documents are fudged here.
Yes, documents are fudged here. So what he has pointed out from the forensic audit report, your lordships has kindly pointed out here, it is a, what you call a small observation relating to the limitations which this audit report has seen, because there was no cooperation from the management
No,
in
no.
granting.
It may be a small observation, but has a far-reaching effect.
Let it be a
Yes.
greatest observation. Still,
Oh, file, no problem.
yes,
Yes.
still it is an observation which arises out of a limitation due to the non-cooperation of the management of the company. That is why they say that this is a great limitation for us. To understand the entire FIR, we have to go word by word in the transaction forensic audit report, not a transaction audit, it is a forensic audit report. Based on the forensic
So
audit
one more
report-
clarification.
Yes, my lord.
Wherever these loans have become default, willful default or whatever, everywhere it is handed over to the CBI?
No, my lord, it
Then-
is not CBI. When a
So
forensic audit is
25
done-
crores, 50 crores, that is the limit. Based
the
upon that
limitation.
RBI circular,
Yes, my lord.
you,
About 25 crores.
about 25 crores, it goes to the CBI automatic. It's
Yes.
axiomatic.
It's revised, my lords, above 6 crore it is.
Now it is 6 crores, huh? All right.
So when, based on a forensic transaction audit, my lords, it has been found in 2017 onwards, there has been a default, no doubt about that. But 2019, the GST authorities, they had raided two, I'm giving only few, just, I'll make a detailed argument later. They had found, yes, my lord, they
alright.
had actually raided two units, two factories of this company, my lords, one in Tamil Nadu, in Zuzuvadi, and one here in Jigani. These two places they had raided, and they found out that all the papers, that is the invoices, it was all only in paper. There was no movement of goods, meaning they had claimed a number of input tax credits, even without rotation of movables.
I wish to interject here, my lords. I've gotten a clean chit from the GST in Tamil Nadu. That is a false allegation.
Come back. Yeah. Why do you get so touchy? Wait. Yes.
So, my lord, after certain investigations, my lord, GST has not given them away. I'll come to that part now. There were two factories, as I said, my lord. One factory was in Karnataka and one was in Tamil Nadu. The Tamil Nadu factory is still under control of GST authorities, whereas the one in Karnataka was released. There were the size or volume of the machineries and iron over there were huge, and all those are hypothecated to the banks for the loans obtained by them. When the GST handed over that factory, the management had moved out all the movables, machineries, and I don't know, they had realized, monetized, or there was nothing, God knows. But there is no transaction relating to that value in any of the books. That should have been brought into the loan account to bring down their default, my lord, or the debt they should have brought. That is not done. And when the GST authorities still know it is under control in Hosur, and they have also filed relevant applications before CIRP. In CIRP, it is still pending, saying that they have a control and we have a control. All those things are still happening. And in meanwhile, landlord is also saying, I have a control over that factory. All that is going on. This is part one, my lord. And part two is that when you go through the FIR, my lords, when this company had taken a loan, it was for machineries, it's a steel company, and for rolling sheets, it was purchasing and selling. But the stock statement did not reflect where it was going, where it was coming. It was only in papers. When audit was done, nothing was matching. That is why the bank also stated, has brought in the stock auditor also and accused in this FIR, my lords. So there comes all these criminal offenses. Not every default amounts to a criminal offense. But when a forensic audit relates to certain acts which constitute criminal offense, then the bank is bound to file an FIR, my lords. When I present my arguments, my lord, I'll go one by one.
What did you do till now then?
Yes, that is preliminary.
Trailer.
Yes, my lords.
Picture abhi baki hai. Yes, we'll see. Nim bandilla in a way. Now the complainant is heard. What's the senior counsel? ನೀವು ಇದ್ದೀರಾ? Somebody else?
ಅಲ್ಲ ಮೊದಲು ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಮಿಸ್ಟರ್ ಧ್ಯಾನ್ ಇದ್ರು ಅವಾಗ ಅವ್ರು
ಅಲ್ಲ, what's his name?
Vaibhav Gagar.
Yes, sir. Now we have heard the complainant's preliminary submissions.
That's right, my lords.
Yes, sir.
So
We'll hear it further tomorrow.
Very well, my lords, as your lordship's team.
Tomorrow complete the submissions.
ನಾಳಿದ್ದಕ್ಕಾಗ್ಬೋದು.
Day after tomorrow. ನೀವು ಅದು quickly ಅವ್ರು ಇದಾರಲ್ಲ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಬಿಡಿ. ನಿಮ್ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಆಮೇಲೆ.
ಆಮೇಲೆ ಮಾಡ್ಬೋದು.
ನೀವು RCB ಮುಗಿದ ತಕ್ಷಣ ಇಲ್ಲಿ ಬನ್ನಿ.
With my even
Match
more
ಮುಗಿದ ತಕ್ಷಣ
learned
ಇಲ್ಲಿ ಬನ್ನಿ.
senior, with my learned
Sir.
senior friend over there, Miss Sushila ma'am, I
Yes.
would imagine, in fact, she was to start. I'm
No
sorry, I
problem,
didn't
sir.
see her,
No
therefore I
problem.
commenced.
No problem. So we'll take it again. ನಾಳೆ ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್?
Day after tomorrow, madam.
We'll take it again tomorrow. Day after tomorrow. Okay, day after tomorrow.
As is convenient to your lordships.
Heard the learned senior counsel or Garg.
Vaibhav
appearing to the
Gagar.
petition. Garg and the learned senior counsel Srimati Sushila and counsel for the complainant bank Srimati Chitra Nirmala. List the matter on Thursday. Thursday same 3:30 PM.
Very, very grateful, my lords.
Yes. Adralli, yes, make a compilation, a convenience compilation and refer, and so that the senior counsels would refer only to that convenience compilation, give it to them.
Indian matter.
It will be easy to finish off the case. Correct, whatever, make, if you are referring to documents after documents, make a convenience compilation, paginate it, we'll close it.
Indian.
That would be very helpful for disposal. Yes, serve a copy on the other,
Very
and serve
grateful.
all the copies on the other side. Yes. Adelli, nan court copy. Small observation. Yes. Day after tomorrow. Yes, next.
Obliged.
Decide, mining matter.
ಗೊತ್ತು. This is G. Janardhan Reddy connected.
ಇಲ್ಲ.
Huh?
FIR ಅಲ್ಲಿ ಅವ್ರು ಇದಾರೆ.
FIR emanated from there.
FIR ಅಲ್ಲಿ ಇದಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಬಿಟ್ಬಿಡ್ತಾರ ಅವ್ರನ್ನ.
ಅಲ್ಲ ಬಿಟ್ಬಿಡ್ತಾರಲ್ಲ, ಹೈಯರ್ ಕ್ವಾಂಟಿಟಿ ಗೋಸ್ ಟು CBI.
CBI ಹೋಗಿದೆ, ನಿಮ್ದು ಇಲ್ಲಿದೆ, SIT ಇದೆ ಅಷ್ಟೇ. More than 50,000 metric tons have gone to CBI.
Yes.
Less than 50,000 metric tons is with the SIT.
Yes.
ನಿಮ್ದು 39,000 metric tons. ಅನ್ಸುತ್ತೆ ಅಷ್ಟೇ ಅಲ್ಲ? So it is here.
And all that I am saying is that yes, there is an observation while granting interim order of this honorable court. But there is para 5, your lordship have also extracted in lordship's order. But the charge sheet material itself would be clear that all these
It is not my order. Coordinate bench
Your
order.
lordship also was pleased to extract coordinate bench order.
That's the foundation ಅಷ್ಟೇ.
Yes, that's all.
Yes. The para 5 considering
Para
the
5.
facts.
Yes, yes. But all that I am required to show is that there is some material in relation to but though we are not sure about the manner in which the license was surrendered and form, there's no document of acknowledgement, but it has come in the record. We have also, it is part of charge sheet also. It was submitted to us also. We have, it is part of charge sheet also. We are not on that. But 10/9/2009, not even taking that as the cutoff date, along with my statement of objections, I have filed several invoices in relation to the transporters, raised by the transporters, which are all before 10/9/2009. The extraction of the illegal extraction took place. I would say illegal because
According to them,
yes,
nothing has happened after 10/9/2009, the date on which the license stood cancelled, correct?
yes.
So after that, if you have imputed any
No,
misgivings, then it would not be an attribute of a crime at all. That is the submission.
It is not.
Now, if everything has happened prior to 10/9/2009, it can perhaps become a crime depending upon
Yes.
the ingredients of
That
whether
is
it
all.
would meet.
Page 45 to 49 of my learned friend's petition.
Yes.
Which is the summary of the charge sheet.
Yes.
That shows that your lordships are at there.
I am 40, I have seen that, yes.
Yes, 44 onwards.
Yes.
Then 44.
Your accused number?
1.
45 ಅಲ್ಲಿ ಸ್ವಾಮಿ.
ಇದು 379, 409,
Yes.
Lord, 379.
MMDR both.
120.
yes.
At page 45, my lord, your lordship could see. At page 45, after the 4 unnumbered paragraphs,
Yes, I have seen. Mark,
a date 1/5/2009 is the transport date.
Correct, that is before 10/9/2009.
1, 2, 3, 4, 5, 6, all of them, my lord.
Again 1/6/2009.
Yes, yes, all of them.
Again 1/7/2009.
Yes, all of them. Next page also, all of
Yes.
them,
Yes,
all 5 of them. The lordship had directed me to produce the supporting documents. I have produced along with my statement of objections. Then lord, at page 47 also, your lordship would see measures Srinivasa Mineral Trading Company.
yes,
ಅವರು
sir.
ದಿನಾಂಕ
That's a
6/8
submission. What are you to say?
Lord, I am not a transporter. I am not a trader. It is the mineral, my lord, which has been transported by the SSMTC, the accused number 2 and 3.
You are accused number 1.
I am the accused number 1. There is a categorical fight state in the charge sheet itself. They say, my lord, it is the accused number 2 and 3.
Then who are you?
I am the licensee. I am the lessee.
Lessee of the, lessee of
ML,
what?
ML number 2173. I am the lessee. It is their case, my lord, that the lessee has a oral understanding with accused number 2 and 3 for mining. There is no such oral understanding, my lord. It is on record that I am selling the mineral, my lord, which was extracted to the accused number 2 and 3. They were purchasing it from me. Subsequently, they were transporting.
Who was purchasing from you?
Accused number 2 and 3. Accused number.
How did it come to you?
It is from his land, the land where that license is. And the
No, how
enforcement.
did the ore mineral come to you?
I am the lessee, my lord.
Lessee of the mine.
Yes, yes.
Then yes.
I am the lessee of. I am the lessee.
Yes, sir.
There is no such allegation that I have transported, my lord. It is not my transport. Transport is exclusively done by the SSMTC, my lord, Srinivasa Mineral Trading Company, represented by Srinivas.
All right, yes.
Lord, my statement of objection, just for a moment.
You file a synopsis of
Please, I
submissions.
have filed, my lord, already.
ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ?
Just for a moment, may I draw my lord's attention?
Yes, yes, Arbatti ಅವರೇ, ಒಂದು ನಿಮಿಷ. It's here.
8th
ಅರ್ಬಟ್ಟಿ
July.
ಅವ್ರದ್ದಿದೆ ಸಿನಾಪ್ಸಿಸ್, ನಿಮ್ದಿಲ್ಲ.
ಅಲ್ಲ, ನಂದು 8th July.
Yes.
Lord, for a moment, annexure R3, my statement of objections, page 57. This is the transport agent's invoice for the transport. Annexure R3, my lord, these are about 5-6 invoices. Your lordship will see the date 1/7/2009.
That is there in the charge sheet also.
Howದು. And your lordship will see the recital in the invoice also from JMV mines. Andre, that is A1. A1's mine extracted from there. And kindly see, my lord, I would not trouble my lords with the rest of the documents. Kindly come to page 165. Lord, this order rejecting discharge application.
Yes.
All these contents which my learned friend has raised before my lords have all been considered.
And rejected.
And rejected, not from para 9 onwards. Para 9.
Accused number 4 ಯಾರು?
4 is another person. Not
One
who
of
was
the
there.
transporter, my lord, here in out of among
Against
this
him
five.
it is allowed.
Against him it is allowed, we have filed revision petition.
ಹಾಕಿದ್ದೀರಾ?
Hakid. Not para 9 to 13 relates to, my lord, the petitioner. And the same contentions are raised, same dates are raised. Para 10 onwards I'll read, not, whereas the land council submits that the illegal mining act carried out by the others made first accused to discontinue his mining operations. This clarification itself is questionable for the reason of his failure to resist or complain to the authorities concerned against the illegal mining. Form F at page so and so of the charge sheet do not refer anything about the illegal mining. Prima facie,
Yes.
it is forthcoming that the illegal mining activities were very much in the knowledge of the first accused.
Yes, sir.
My lords, one paragraph, my lord, page 45, my lord. It is the internal page of.
Of what?
SSMTC.
Petition.
Charge sheet.
ಮುಂದುವರೆದು.
Aye.
ನೀವು ಮುಂದುವರಿರಿ.
ಮುಂದುವರೆದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಡೆದುಕೊಂಡಿದ್ದ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅದರಲ್ಲಿ SSMTC ಅವರು ವೃಷಭೇಂದ್ರ ML ನಂಬರ್ 2173 ಗಣಿ ಪ್ರದೇಶದ ಸುತ್ತಮುತ್ತಲಿನಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಗಣಿಗಾರಿಕೆಯನ್ನು ನಡೆಸುತ್ತಿದ್ದು JM ವೃಷಭೇಂದ್ರ ಗಣಿಗುತ್ತಿಗೆ ಪ್ರದೇಶದ ಸಮೀಪ ಮಧ್ಯದಲ್ಲಿ SSMTC ಸಂಸ್ಥೆಯವರು ಮಾಡಿಕೊಂಡಿದ್ದ SSM ಪ್ಲಾಟ್ನವರೆಗೆ ಕಬ್ಬಿಣದ ಅದಿರನ್ನು ಸಾಗಾಣಿಕೆ ಮಾಡಲು ತಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ವ್ಯಕ್ತಿಗಳ ಹೆಸರಿನಲ್ಲಿ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಕಂಪನಿಗಳು ಸೃಷ್ಟಿಸಿ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಕಬ್ಬಿಣ ಅದಿರನ್ನು ಸಾಗಾಣಿಕೆ ಮಾಡುವ ಬಗ್ಗೆ ಮತ್ತು ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಹಣ ಸಂದಾಯ ಮಾಡುವ ದಾಖಲಾಗತ್ತೆ. Is the SSM plot, my lord, what my learned friend produced the document invoices, my lord, that is for the SSM plot. It is the charge sheet, my lord, says that he was doing illegal mining.
It says JMV mines to SSM plot.
All right, yes, heard reserved.
Great.
Next, yes.
39.
Senior counsel has become free. ಆ ಕೋರ್ಟಿಂದ ಆಚೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ? Yes.
10 ಅಲ್ಲಿತ್ತು. 10 ಅಲ್ಲಿತ್ತು.
ಅದೇ ಅದಕ್ಕೆ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಬಂದೆ.
This is that Gunashila's matter, chartered accountant. My lords may just have the synopsis. I can quickly take my lords through the synopsis. I think it covers most of the aspects. 7/8/2024, we submitted synopsis.
Respondent.
I'm for the respondent, my lords.
You are ready?
We are ready, my lords, senior in other courts.
I just point out the
Let them
synopsis
argue,
by
my
then,
lords.
my
We
lords.
will-
My lords may notice this company was incorporated on 10/10/2011. My lords, petitioner, he was a director for about 4 months. 29/2/2012, my lords would notice he resigned as director. Operations of this company itself started on 2013 and 2014, my lords. And my lords, 2016 is when first set of complaints that came against the company. My lords, it was felt the company was more into that pyramid scheme, my lords. So they initiated proceedings in Mumbai in 2016. And in that, my lords, I was asked to appear. I appeared. They had taken my information. They felt that I had nothing to do with it. I had resigned when the company was incorporated right in the beginning itself. So, my lords, the charge sheet of that first complaint is Annexure F, page 49, where I am not made an accused. Then the CID at Bangalore in 2018 initiated the next proceeding, my lords. The same thing followed up. They called me, my explanation was taken. They would find that I had nothing to do with it. The whole commercial part of the company only commenced from 13 to 14. So they dropped me in the charge sheet. Then, my lords, a lookout circular was issued in 2019. My lords would have it at page 14.
Yes.
Now, this lookout circular is what is there even in existence now, my lords. So the other writ petition which has been filed
is challenge.
out. So my connected matter only. Now, my lords, the respondents, they sent a show cause notice. Now, this will be important, my lords, because they proceeded on the footing that I was a director. My lords would have page 94 for a minute, my lords.
Yes.
My lords, in 94, the show cause notice, 27/10/2021, they would proceed on the footing, my lords, that I was one of the directors and the offense prima facie which they find is 447 and 448 of the Companies Act, which comes into force much later to my resigning as a director, my lords. So, my lords, one of the contentions which we wanted to point out is, my lords, Article 20, which my lords had covered under the Black Monies Act, my lords. So, my lords, when this notice had come,
that has become final?
No, my lords, it's pending consideration. A portion of my lord's order is stayed in the Supreme Court.
Portion of the order?
Yes, my lords. Paragraph 15, they've stayed it because they felt the constitutional validity of the act has not been challenged.
Not been challenged.
But the one portion, my lords, they would stay. We have.
Oh, it has to pass muster, constitutional muster.
Because paragraph 15 only, Article 20,
That's
which
all
my
right,
lords.
yes.
My lords, I think we have even produced that order.
It's here, page 48, 49. No, Supreme Court's order is not.
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ
All right, no
ಮೇಡಮ್.
problem.
You only that portion of paragraph 15 from one portion they say that
Otherwise,
says.
where the facts, nothing
No,
is stated.
nothing, my lords. So this show cause notice, when it came to us, my lords, we reply back point, my lords, paragraph 15, page 99 ali, they give reference to one other case that was registered in Hyderabad. My lords, may kindly notice paragraph 15. And even in that Hyderabad case, my lords, they drop us, my lords.
Yes.
We have filed that along with the memo, my lords, 7th June. So all the proceedings that have taken place, I am dropped, my lords, because I was only a director for 4 months. Now, this notice which they issued to me.
Both the petitions concern the same petitioner.
Same. On the LOC, my lords.
On the
And
LOC,
one
on
is-
the crime.
One is quashment of the entire proceedings. Now, my lords, if my lords would notice page 104 ali, notice ali, right in the end, it comes to me as a former director, not as a chartered accountant, nothing to do of that. One question the court wanted to know was, are you being prosecuted as a chartered accountant for the company? No, my lords, I'm not being prosecuted as a chartered accountant. I'm being prosecuted as a former director. So the show cause notice at page 104 itself, it comes to me as a former director. I reply back to that, my lords, a detailed reply pointing out all the events that have taken place. And then comes the complaint, my lords. Please notice the complaint. Even the complaint proceeds on the footing of making me a director, former director, not a chartered accountant. If my lords would have page 115, my lords, meanwhile, could I just say the Companies Act, it came into force on 12/9/2013.
Yes.
Much after my retirement as a director, my lords. Then I had resigned in 2012.
Yes.
The relevant portion in this complaint, page 117, my lords. I'm
Yes.
shown as accused number 10. It would be a private complaint, my lords, which is filed with the department. And then the
This
relevant
is
portion.
that Vihan direct selling.
Yeah.
Virana, Vihan.
Vihan.
Vihan,
Vihan.
correct.
My lords, idralli page 118, paragraph 3, they proceed against accused 4 to 10 as former directors. My lords may notice that point, because on the last occasion, the impression that was sought to be given was, no, we didn't proceed against him as a former director, but he was also handling it as a chartered accountant, and that's how we proceeded.
No, but the entire show cause notice is on the premise that you were a director earlier.
Even the
There is no mention about you being a chartered
chartered
accountant.
accountant, any role.
That you have made, I have
Yes, my
made a
lords.
note also. Here.
Oh, please, my lord. That was the only point my lords wanted to know. My lords, throughout this complaint, they proceed only on that basis that I was a former director. Now, the contentions, if my lords would have.
But you
this-
were a director, but only for 4 months.
4 months, right at the inception, my lords. And then the commercial activity also commenced only on 2013, 2014. The complaints came in 2016.
Correct. When were you a director?
My lords, 2012. My lords, in that synopsis, right at serial number.
So, before 2013.
Yes, my lords. My lords, page 2 only, 29/2/2012, I resigned as a director.
No, no, I'll see. I've not gone through a
Yes, my
synopsis.
lords. Now, the contentions, my lords, which we have taken, please now notice page 5 of the synopsis, my lords.
Yes.
3, very clearly the date that I was a director is disclosed, my lords. The petitioner was a director of the company for only 4 months between 10/10/2011 to 29/2/2012. Section 447 and 448 of the Companies Act, which is alleged, my lords, it has come into force only on 12/9/2013. And my lords, there is no saving clause in that, my lords, to say anything. Proceedings against the petitioner, therefore, are violative of Article 20 of
So
the
you say
Constitution.
it's covered by,
Yes, my lords, but because my lords, one portion of it is stayed, we are falling back on the 1953 judgment, which is quoted by my lords.
correct.
Constitution bench ruling. So that covers that issue on saying, my lords.
Yes.
And then, my lords, we also pointed out they have proceeded against us as a director. Absolutely no allegation as a director. What is it that I had done in the entire complaint? So, my lords, page 6 are the other contentions which have been taken. And then, my lords, reading of the entire complaint, absolute no iota of any ingredients of the offences which are alleged against me.
Yes.
And no specific averment itself, my lords, other than saying accused 4 to 10 were directors. And after having received a reply from me, my lords, indicating the whole sequence, it is not at all been considered. and a private complaint which has been done on the basis of which cognizance taken, my lords. So, my lords, these contentions I have put it here. And my lords, the judgment, my lord's judgment is at page 9.
No, that I've
Black,
seen. Yes.
Black Money Act.
9 to 49.
Oh, Adral, only paragraph 15, my lords, from the portion at page 48, 15th paragraph, about
That's a-
6 lines onwards.
Yes,
Therefore,
yes.
the criminal law, that portion of it is state.
Only that
One
portion of 15.
Portion of 15.
Therefore, the criminal law
Yes,
cannot be set
from there
into
till
motion
the-
against the petitioners
Yes,
in the aforesaid
How,
case.
till the end of that paragraph. That portion is stated. In fact, we have it in the system.
We'll take it, yes.
Please.
You can give a copy later. Yes, Kumar, sir.
Regarding LOC matter is concerned, my lords.
LOC ಅಲ್ಲ, ಇದು ಇನ್ನೊಂದು.
Writ petition, criminal petition.
Hmm.
The undisputed facts are, my lords, he is a chartered accountant. He was a director initially. He acted
4 months.
initially for incorporation. Even till date, his email ID continues with that company
As what?
for correspondence. He still-
Correspondence?
With the company and the any other agencies. Still, he has got some nexus. We don't know what is the nexus. But one fact of the matter is, my lords, the chartered accountants plays a quite a pivotal role in the entire system of.
Your notice itself is not that he's a chartered accountant.
My lords, it is there subsequently. We have stated so in the
ಎಲ್ಲಿದೆ?
criminal.
ನಿಮ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿ, ಎಲ್ಲಿ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಹೇಳಿ.
In what capacity he incorporated a company.
All your notice is on the score that he's a director.
Director
Correct.
initially.
And now all your submission is on the score that he's a chartered accountant. What is he?
There are two aspects which request to be made, my lords. Undisputed fact. It is not like it is an economic offense. It is not like IPC offense where we can say that you should have said A, B, C, D things. It is a bundle of facts which makes the entire system to work and cheat the public.
ಕನ್ನಡನೋ ಇಂಗ್ಲಿಷ್? ಇರ್ಲಿ ಬಿಡಿ, ಎಸ್.
So this is the bundle of facts which.
ಅದನ್ನೇ ಕೇಳಿದ್ದು. Yes.
So, so number of factors and facts request to be looked into when he has been arraigned as accused in the 447 complaint. Since he facilitated the whole process to happen, he is the one who has certified the accounts. Fraud being played. And the amount of money collected has been routed through to their own companies to QA Malaysian group. It's a conduit. QA Malaysia group, then Vian and the QNet placed in Hong Kong. Then it comes to India. Then again they create 2 more companies of subsidiary of QA group. The money is routed through those companies. Apart from that, my lords, what exactly his role was played in the company's entire, one is initially incorporation. It's for fraudulent purposes. Second, continued certifying their accounts as a tax consultant and also as well as chartered accountant to certify the accounts. These are the 3 roles which the petition has played. Now, as far as the notice is concerned, they have looked into the initial proceedings, what has been initiated.
ಸರಿ, ಆಮೇಲೆ ಎಲ್ಲಿ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿದ್ರೆ?
Only the complaint would have said that.
ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆ? ಕಂಪ್ಲೇಂಟ್ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಅಂತ ಎಲ್ಲಿ?
447 is acted as chartered accountant tax consultant. That's what has been narrated in the complaint, my lords.
No, you can't take it lightly.
It is there in the complaint.
ಕಂಪ್ಲೇಂಟ್ ಇದೆಯಾ? ತೋರ್ಸು.
Complaint.
ಕಂಪ್ಲೇಂಟ್ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಅಂತ ಇದೆಯಾ ಅಂತ ತೋರ್ಸು.
Acted as a tax consultant also.
ಮತ್ತೆ ಹೊಸ ರೋಲು ಟ್ಯಾಕ್ಸ್ ಕನ್ಸಲ್ಟೆಂಟ್.
ಅಲ್ಲ ತೋರಿಸ್ಲಿ my lords, ಎಲ್ಲೂ ಇಲ್ಲ ತೋರಿಸ್ಲಿ. I can show about 8 places former director.
No, formal director.
ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಅಂತ ಎಲ್ಲೂ ನೋಡಿಲ್ಲ.
ಎಲ್ಲೂ ಇಲ್ಲ. My lords, page 117 onwards, page 118, first place that we get is the second, paragraph 3, 4th line. Accused 4 to 10 are former directors.
Yes,
Then, my lords, please notice after that, the next place where they talk about him being only a director, my lords, paragraph 16, page 127, 5th line, as well as their directors.
No, everywhere I find
Paragraph 18, look
your
out.
name linked to director and LOC at page 18.
LOC as a director. And then, my lords, paragraph Roman number 6 at page 129 and its directors. Page 131, Roman number 11, board of directors. Then the company and the directors have violated. Page 132.
Director. Where is chartered accountant, tax consultant?
No, sir. Sorry, in the complaint it is not said, so it is said in the Shen objection filed in 27046,
On
the
that
criminal
you-
petition.
Complaint
It
to
is
charge sheet till there is objection.
ಇದು FIR ಕೂಡ ಅಲ್ಲ, ಇದು complaint, my lords.
Completely.
Yes, it's a complaint.
complaint.
There are many proceedings initiated as far as, it will have some ramification as far other petitions are concerned, my lords.
Dalla, see, that cannot be the ground. You're submitting a criminal case.
Yes.
It, allegation should be specific.
Yeah, only-
It's not that, it's not a, frolicsome act of, setting a criminal law into motion against.
Certainly,
someone.
I agree for that, man. Only two things are there.
Mm.
Last, when they argued, there are 2-3 issues they have raised, matters for which I had start the instruction of the department to give in one this thing. Can it be
At
taken
any
up tomorrow? I will give that.
Tomorrow agalla, day after tomorrow.
Definitely.
We'll continue day after.
At
And
any time.
also cognizance is at director, my lords. Cognizance.
Alla kade direct, I
that-
don't find the word chartered accountant at all.
And,
What-
and so far as QNet is concerned, in fact, the coordinate bench had quashed the proceedings against QNet.
No, no,
Lordship
that is,
Justice
I'll-
Anand Bhai Reddy's
Lordship, I'll make submissions.
And
This is a company playing around certain things. I place it on record, how they are fooling the public even today. They are escaping. Because if you go to your Lordship's, their website, you will find many options.
ಅಂದ್ರೆ
And options ಹೇಳ್ತಾರೆ, ಒಂದ್ ಕಡೆ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಗೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಅಂತ ಕ್ಲಿಕ್ ಮಾಡಿಸ್ಕೊಳ್ತಾರೆ, ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ.
ಟಿಕ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ ಅಂದ್ರೆ ಹೆಂಗೆ?
No, you will be forced to go or lured or you are, yes, or you are prompted. So they say you repeat, you earn so much. I have said it so in my statement of objections, even in the complaint also. See, that's how gullible members of the general public are lured to the invest and they lose the money. They don't know where they are investing, who are the persons who are in. You don't require any product. They simply send one item of some lakh. That's how it is being. That is an inspection report. And earlier they came in as a gold quest company in Tamil Nadu and Maharashtra also. It went up to Supreme Court. They closed the company activities. Then they came with new avatar as go beyond direct selling. This is how they are playing around. SEBI has initiated proceedings. They have put it in public notice how they are treating the members of general public. ED has initiated the proceedings. There are so many multiple proceedings. Even the Consumer Ministry has also.
Now the offense is 447 of the
And
Companies Act.
447. 447.
IPC offenses ಏನಿಲ್ವಾ?
ಇಲ್ಲ. And 447 only under the Companies Act. Collected the money from the general public. They have not repaid. It is a cheating. Neither they have given the service.
When did 447 spring as an offense under the Companies Act?
Under the Companies Act, they have collected the money.
No. When did it come as an offense?
2017, many complaints.
When did that 447 itself become an offense?
In 2013 itself.
Correct. What are these acts?
2013.
Long 2011.
No,
12.
no. 11, there are no transactions. Inspection report is for the year 15, 16, 17, not prior to that. It has been conducted. Inspection was conducted in the year 2000, for the respect of the year 2015, 16,
No,
17.
the submission is a post facto law cannot be used against them to prosecute
That's-
them criminally.
Yes, that's the one
Correct.
point which they have raised, my lords.
Ah.
As far as I am concerned,
Mm.
in this case is concerned, my lords, he says I was only a director for 4 months. Prior to 2013 Act came into force.
In the year 2012.
Well,
Now he has been hauled into these proceedings for his acts done as a director for those 4 months.
That's one submission, my lords.
That's a sheet anchor, sir.
Yes, sir. Second aspect is, my lords,
Mm.
as I mentioned, his relationship in the company has been continued. Even if you take it on prima facie case, my lords, if we look at this association with the company for subsequent years in any capacity, if we can place it on record and place it, he is completely involved in the transactions of the company where.
Nale you seek instructions and come.
Yes, these 3 facts I will place.
Day after tomorrow.
Definitely. Obliged.
Supreme Court order ಒಂದು ಕಾಪಿ ಇದೆ
ಕೊಡು.
ಮಾಡಿ.
ಈಗ ಏನ್ ಕೊಟ್ಟರು ನಡೆಯುತ್ತೆ ಕೊಡು.
That all 31 are FIRs which have been stayed, manners, when the directors were absconding.
No, is this got anything to do with that Sanjay Godawat?
No, it is different, man.
Different,
But,
my lords.
well,
My
actually,
lords,
here is a,
QNet earlier was as Gold Quest, my lords. They were into,
31 FIRs registered.
yes, here is the same
against
case.
him.
Same case.
here also same case ಅಂದ್ರೆ ಅದಲ್ಲ my lords. ಇದು Gold Quest, QNet is different. They were into direct marketing. the whole concept of direct marketing, my lord should get in his lordship justice unwearied disorder.
No, there, Sanjay Godavataya, he was the complainant in that case.
Yes,
Complainant against some other
Against
person
someone
where
else,
about
yes.
15, 20
No, no,
crimes
this
were
has
registered
nothing.
against others.
I think that's all Star, my lords, that I think the
The
company
Star,
is
yes,
Star.
yes. The Star was the complainant.
Company, okay.
That's what here is a case where what they are projecting, I will just place it on record, how they are trying to.
I thought day after tomorrow.
Obliged. There's an interim order.
That will continue.
Only in respect of criminal petition is concerned, not.
Wherever it is.
Allah, but criminal, that LOC is going to be dependent on this criminal proceeding. I don't say LOC.
Anyway.
I am suffering for the past 5 years, not even called one.
ಏನು?
LOC when they were issued, for 5 years, the ROC, Hyderabad issued LOC for investigation. 5 years, they've never called me for any investigation. 6 years.
ಅದು ಸುಮ್ನೆ sword hanging on the head.
So there are 13 directors against all of them, it was
Day
issued.
after tomorrow.
Sir, and objection was filed in 2009.
And why LOC?
That is a decision taken by the secretary, I mean, after looking at the report, inspection report, against all directors, including former directors, LOC.
LOC.
And object of LOC is participate in investigation or trial. ಇಲ್ಲಿ ಎರಡು ಇಲ್ಲ.
ಒಂದು ದಿವಸನೂ ಕರೆದಿಲ್ಲ.
ಒಂದ್ಸಲಿನೂ ಕರೆಕ್ಟ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಾಗಿದೆಯಲ್ಲ.
Complaint has been filed.
Investigation.
Permission granted by the ministry was only to go proceed against the relevant directors, not against all the directors of the company.
Relevant directors.
I was there for 4 months.
Day after tomorrow.
Who are mentioned in the investigation report by their own ROC.
Day after.
I was
Deeply obliged. Allah, chartered accountant, your case only in the complaint is not chartered accountant. My lords, this is not an information given under an FIR. Now ಹೇಳುದು, we said we are chartered accountant, reply ಅಲ್ಲಿ. Not.
So incidentally today the CA came a lot because we thought we would get some relief because chartered accountant stay.
Oh, ಹೌದಾ? You are not a chartered accountant, former director. Then why you won't get relief today. Yes. You early 5 o'clock. ಒಂದೇ ನಿಮಿಷ, one flight has just landed. Wait.
I will not take, my lord, more than 1 minute. It's a simple matter. My lord, there is a moratorium order. My lord, all that we said is, there is a, my lord, decree passed by the commercial court, which is appealed before this honorable
Shyam Sundar sir, in the lighter way, don't mind.
I know, my lord, it's a pleasure, my
Then
lord.
you should not,
In fact, my lord, in fact,
to break the monotony.
I understand that, my lord. In fact, we should be rather, my lord, doing that to keep your lordship's energies high. But it's always, my lord, the other way. We take energy from your lordships.
That's why getting depleted these days. Yes.
Lord, I will not take more than 1 minute.
Yes.
There is, my
30
lord,
seconds, Andre, ಈಗ.
There is a commercial court decree, my lord, which is challenged, my lord, before this honorable court in a commercial appeal. Execution proceedings started immediately. We, my lord, in the meanwhile, there is a moratorium order, which is, my lord, admitted by the court. We only said that since there is a moratorium order, no further legal proceedings can lie. Please look at the moratorium order. Kindly, my lord, only see, my lord, page number 29. This is how, my lord, the
Moratorium will operate against the company and not against the directors. As simple as that.
In fact, my lord, I would have been happy, my lord, if it was said. Kindly, this is a case against the company. What the learned judge
Arrest
would say,
warrant is against you.
no, Lord, what the learned judge would say, the moratorium is only with respect to that particular applicant in the NCLT, not, my lord, against anybody else, against others. There is no moratorium. It's a very myopic way of looking at, my lord.
No, idral myopic ಇರಬೇಕು.
Allah, kindly, my lord, see this. This is how, my lord, the learned judge would say. The said order would not affect the rights of the DHR to proceed against the JDR herein. The said moratorium order is only with respect to debts of IDBI trusteeship. My lord, this is moratorium, my lord, is an order in rem. Lord, it can't be, my lord, only against a particular debtor.
In rem, quay the company, not in personam, quay the directors.
In fact, my lord, against direct also there is a moratorium. There are multiple moratoriums. You only said that it cannot be proceeded. And my lord, the learned judge would simply, my lord, this is a myopic view of understanding. My lord,
ಮತ್ತೆ myopic, ಇದ್ರಲ್ಲಿ myopic ಇರಬೇಕು.
the view of
ಇದರಲ್ಲೆಲ್ಲ
understanding.
parochial, myopic
My
ಎಲ್ಲ
lords have
ಇರಬೇಕು.
dealt, my
You
lord,
can't
with
be
huge
broad-minded
matters on
here.
Moratorium. Moratorium, my lord, is of universal application. In fact, my lord, I
It's
said,
not, It's not universal.
It is, my lord. Once
No.
there is a moratorium, all
Once
the
there is a
debts-
moratorium, query companies, yes, it operates, not against the directors.
Yes, my lord.
So we will stay things against the company,
Yes, my lord.
not against the second petitioner.
In fact, against the second petition also there is a moratorium. Individually against a guarantor, my lord, there is a moratorium. There are two
Guarantor
moratoriums.
or a director or borrower, moratorium will not operate.
I am greatly obliged, my lord, if the proceedings
fine,
are
yes.
stayed against the company. In fact, my lord, I said, in spite of all these things, I am prepared to offer security before the appeal court by depositing 25 lakhs. My lord, even that is not accepted.
ಅಲ್ಲಿ ಎಷ್ಟಿದೆ?
1.5 crore rupees decree, my lord. I said I am in a commercial appeal before this honorable court.
What, no order passed in commercial
No,
appeal?
my lord, I was asked to say what is the amount which I can deposit because, my lord, these days money decrease, my lord, there is no automatic stay. We have to make some deposit.
Oh, okay, definitely.
Yes, that is the reason, my lord, we voluntarily said
Hmm.
that 25 lakh rupees which we have undertaken before the Honorable High Court, we will deposit. My lords, may I kindly say that, my lord, I will deposit before this Honorable Court 25 lakh rupees. My lord.
Too less an offer.
Allah, in fact, my lord, it would be far
ಒಂದೂವರೆ
lesser.
ಕೋಟಿಗೆ 25 ಲಕ್ಷ
My lord,
ತುಂಬಾ
if
ಕಮ್ಮಿ
it,
ಆಯ್ತು.
if it would rather be far lesser, my lord, if I go on the scale of that, my lord, the Honorable Supreme Court judgment, not the entire amount of decree need to be deposited.
No problem.
It is more to show, my lord, more to show, my lord, bona fides. And in fact, my lord,
Ozone urban, I told you, ozone ಉಳಿದೇ ಇಲ್ಲ, ಬರೀ CO2
we are
ಇರೋದಿಲ್ಲ.
just
ಕಾರ್ಬನ್ ಡೈಆಕ್ಸೈಡ್ ಮಾತ್ರ ಇದೆ.
but we are just
Yes.
trying to sneak out of the troubles, my lord. There are some helping hands.
Hmm.
But ಈ time ನಲ್ಲಿ ಈ ತರದ್ದೆಲ್ಲ ಮಾಡಿ directors arrest warrant against the director. What the director can do
Correct.
for
If
the acts of the company?
If O2 becomes CO2, ಅದೇ ಆಗದೆ.
ಅದೇ. My lords, may kindly protect us subject to the condition.
25 lakhs
25
deposit.
lakhs, my lord, I'll deposit before this honorable court.
The petitioner shall serve on the counsel who represents the plaintiff in execution 170 of 2024. The petitioners are before this court calling in question an order which directs the petitioners to be or issues an arrest warrant against the petitioners in view of the fact that interim moratorium, the court observes that.
ಹೌದು, kindly, my
The
lord,
learned arrest warrant. The learned senior counsel M.S. Shamsundar appearing for the petitioner submits that the proceedings are before the NCLT and a moratorium is operating on the company and its directors. In that light, the concerned court could not have issued warrant of arrest against the petitioners. Very doubtful. A warrant of arrest against the petitioners. There shall be an interim order of stay of the order impugned subject to the condition that the petitioner would deposit 25 lakhs before this court in the next 24 hours.
Lord, kindly allow me, my lord, 3 days.
72 hours.
Greatly
Yes.
obliged. Greatly obliged.
You serve on the council
Yes.
and file an acknowledgement, otherwise interim order.
We shall.
Yes. Next. I continue. 1 minute. I'll take that matter. I'll just run through and send the councils who are waiting. Why is the advocate general waiting? Which passed over?
The morning land acquisition matter.
Further hearing. ಯಾವುದು?
Council, Mr. Pradeep told that AG will come in the matter.
66 further hearing, correct. The tender matter. ಅದು ಕೊಡಿ. That I know, but where, this can't go on like this.
The matter was not listed, although it was.
Tomorrow it will be, day after tomorrow it will be clubbed and listed, all the matters. ಕೊಡಿ. Madam, ಅದು file is already come, cause list ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ, so there is a problem.
My lord, one more matter which was still at the filing stage.
No, that we won't.
No,
You
that
got
has been
third
scrutinized.
matter, whatever it is, special order ಆಗಿದೆ, so that will come.
Please.
That is, tomorrow it may not be possible, day after tomorrow, finally, it is tag this petition along with so and so, heard the learned counsel, advocate general appearing for the respondent. The counsel for the petitioners would seek time. As a last chance, list this matter on Thursday at 2:30 PM. In the event no submissions are made, the petitions would be answered, hearing the advocate, learned advocate general. Interim order ಇದೆಯಾ? ಏನಿಲ್ಲ ಅಲ್ಲ, ಪಾರ್ಟಿಸಿಪೇಷನ್ ಅಷ್ಟೇ ಇದೆ. So 1 minute, make it correct. ಅದು ಏನಿದೆ?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಯಾಕೆ?
KDB acquisition, in the morning Learned Council has requested for pass over. AG will come in the matter.
We'll file a short reply to it, my lord. Your lordship may have it on Tuesday, my lord.
My lord, only one point and a legal point and a strong point in the second.
Legal point ಅಂತ ಹೇಳಿ ಸ್ಟ್ರಾಂಗ್ ಇಲ್ಲೋ ನೋಡ್ತೀನಿ.
Second volume. 2 volumes I have put it. In the volume 2.
ನೀವು ಸೆಕೆಂಡ್ ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಸ್ಟ್ರಾಂಗ್ ಪಾಯಿಂಟ್ ಇದೆ ಅಂದ್ರೆ ಕೇಸೇ ಇಲ್ಲ ಅಂತಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ.
ಹೇಳಿ.
Page number is 449.
18/11/2003.
Yes, and I would like to take my lord to this page number is 453 again. That
Again, what is the impending urgency?
Impending urgency is, my lord, we have right from the day one, we have filed objections.
ಈಗ ನಾಳೆ ಇಂಟರ್ ಮಾಡಿರ್ಬೇಕಾ?
Final notification issued, and so far as our possession.
File your objections.
Our possession is concerned, let them not disturb.
Are you in possession?
Yes.
Well, one small fact, my lord, the whole petition, they don't say which property they own. And so which schedule is not mentioned.
Annexures I have placed as a RTC.
More in the nature of PIL.
That is precisely why he is telling is a very strong case.
More
Let him mention which 48 petitioners are there, which petitioners own which survey number, what is the extent in the notification.
I have a table and I place it. You are not saying, sir, please.
In the whole volume, 2 volumes, there is not disclosing.
I have in the table form I have given, my lord, the only one point is these are all the potential fertile agriculture lands in the catchment area of Tippagondanahalli. And the government has notified it, these lands cannot be acquired or cannot be used for any industrial purpose. There are catena of decisions by this Honorable Court where Justice
Where is the catena?
I will place it. My lord, now once when that notification of the year 2018 and my village, my Hobli is purely zone 1, they cannot notify it and they cannot take it for industrial purpose. That's the first point. Number second point is now, as it is, these are all potential agriculture lands. The policy of the government, both in the central government and in the state government, 2007, 2013, by their circular, they shall not acquire potential agriculture lands. Despite all these things, they want to notify it. And notification issued in 2024, from the day one when they conduct.
Let them file their objections.
Please, Mala. Day after tomorrow.
Government.
ಅಲ್ಲ
24 hours ಅಲ್ಲಿ
ಅವ್ರ ಪ್ಯಾರಾಫಿಲ್ ಇದೆಯಾ ಮಸ್ತ್ ಎಲ್ಲ
ಪ್ಯಾರಾಫರ್ನಲ್ಲಿ ಎಲ್ಲರ ಹತ್ರ ಇದೆ, ಅದು ಮಾಡಲ್ಲ.
And only thing is, let them not cause any disturbance. ಇಲ್ಲೇನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ
ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಅಂದ್ರೆ ಯಾವ ತರ?
1 minute. One first point is
ಯಾವ ತರ ಡಿಸ್ಟರ್ಬೆನ್ಸ್?
First point is in overnight they change the RTCs in the name of KDB. Number 2, the electric.
First ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದು ಅಂತ ನೋಡೋಣ, ಆಮೇಲೆ ಅವ್ರಿಗೆ
ಇದೆ ಎಲ್ಲಾನು ಇದೆ. ಅದು ಯಾಕಂದ್ರೆ 2 ವಾಲ್ಯೂಮ್ ಇಂದ ನೋಡಿಲ್ಲ, ಟೇಬಲ್ ಫಾರ್ಮಲ್ ಹಾಕಿದ್ದೀನಿ. Number 2 is let them not disturb the electricity connection and electric supply. We are all agriculturists. Number 3 is now, as it is, we have some bank transaction and loans.
ಬ್ಯಾಂಕ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರ್ದು.
ಅಲ್ಲ ಇವರು
ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ
ಇವ್ರನ್ನ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ನಮ್ದು, ಯಾಕಂದ್ರೆ ಇದು ಫ್ಲಾರಿಕಲ್ಚರ್, ಇದು ಇದೆಂತದ್ದು ಪಾಲಿ ಹೌಸಸ್ ಎಲ್ಲ ಇದೆ. ಈ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ರೆ the whole thing will be destroyed. Let there be set direction and let them maintain it. That's all my.
ಅದು ಮಾಡಿದ ತಕ್ಷಣ ಮೂವ್ ಮಾಡಿ.
ಅಲ್ಲ ಅದು ಮಾಡಿ
2:30 ತಗೊಂಡು ರೆಸ್ಟೋರ್ ಮಾಡಿಸ್ತೀನಿ.
KDB ಇದು RTCಗಳೆಲ್ಲ ಓವರ್ ನೈಟ್ ಚೇಂಜ್ ಮಾಡಕ್ತಾರೆ.
ಓವರ್ ಡೇ ಟೈಮ್ ಅಲ್ಲಿ we will restore it.
Please, ma'am. That's all my humble request.
File your objections. Heard the learned counsel appearing for the petitioner and learned advocate general as advocate general, advocate general appearing for the respondent. List the matter 15th. List the matter on 15th. Objections, if any, shall be filed by the respondents. In the event of need, the petitioner is at liberty to move the matter before the next date of hearing. Event of need ಅಷ್ಟೇ.
Please, ma'am.
ನಿಜವಾಗ್ಲೂ ಕರೆಂಟ್ ಹೋದ್ರೆ ಆಮೇಲೆ ಮೂವ್ ಮಾಡ್ಬಿಡ್ಬಿಡಿ.
ಇಲ್ಲ
ತೆಗೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಅಲ್ಲ ಪವರ್ ಕಟ್ ಆದ ತಕ್ಷಣ ಡೋಂಟ್ ಮೂವ್ ದಿ ಮ್ಯಾಟರ್.
ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ
ಪಕ್ಕದ ಮನೇಲಿ ಪವರ್ ಇದೆ, ನಮ್ಮ ಮನೇಲಿ ಇಲ್ಲ ಅಂದ್ಬಿಟ್ಟ. ಅಲ್ಲಿ ಕರೆದ್ಬಿಡಿ ಅಲ್ಲ. 70 I'll just please ಕಳಿಸ್ಬಿಟ್ಟು I will take it definitely. Yes. In camera ಒಂದಿದೆ. ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಇದಾರ?
I appear for respondent two in that proceeding. Senior is here. Other side counsel.
ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಇಸ್ ದೇರ್?
I am not in photo number 10.
ಆಯ್ತು, ಅವ್ರು ಬಂದಾಗ ಹೇಳಿ.
71.
Appear for the respondent.
All other matters will repeat. Huh? 73. 73. Kariri madam.
72.
My lord, 72 I appear for petitioner. This is my lord that Kukke Subramanya matter.
My lord, 73 may be.
Oh, dilapidated condition.
ಅಲ್ಲಲ್ಲ ಪ್ರಸಾದ ಹಂಚದ ಅದರಲ್ಲಿ.
Oh, yes.
ಘಾಟಿ ಸುಬ್ರಹ್ಮಣ್ಯ.
ಘಾಟಿ. ನೀವು ಕುಕ್ಕೆ ಘಾಟಿ ಒಂದೇ ಅನ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ. Yes. Because ಕುಕ್ಕೆಲಿ ಅದು dilapidated condition ನಡೀತಾ ಇದೆ. Yes.
My lord, in this matter.
ಪ್ರಸಾದ ಹಂಚ್ತಾ ಇದ್ದೀರಾ?
ಹಂಚ್ತಾ ಇದೀವಿ. ಇದರಲ್ಲಿ
ನೀವು ಯಾರಿಗೆ? ಟೆಂಪಲ್ ಗ? ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್.
Filed one application seeking amendment.
ಹಾ.
If there are no objections, it may be allowed, my lord, and for amendment, they may, my lord, file objections if required.
There is no application put up.
Given to understand, my
We'll
lord.
see. Repeat ಆಗುತ್ತೆ. Entry ಮಾಡಿದ್ರೆ continue ಆಗುತ್ತೆ.
Entry
Yes.
mod.
73.
Please.
This RERA appeal. Now RERA appellate authority is constituted.
Delay payment, my lord, delay payment statutory.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲ appellate authority constitute ಆಗಿದಾರಾ?
Constitute ಆಗಿದೆ.
It is functioning.
Functioning, my lord.
Yes madam, then we'll send it there.
Administrative order, circular.
Even that can be challenged before the appellate authority.
Any order.
For everything 226 is not the remedy, because appellate authority was not there, I entertained. That doesn't mean I will continue to entertain. Now if the appellate authority is there, I'll reserve liberty to challenge it. The entry mod, if anything, will continue.
Itself is issued without jurisdiction.
Yeah, ಅದು ಅಲ್ಲಿ ಕೇಳಿ sir. Circular is issued.
Yes.
Which circular?
Which is.
Circular is challenged.
Yes, my lord.
That we'll see then. Yes.
My lord, it may be heard, my lord, because one day.
Day after tomorrow.
Yes, my lord.
Yes. They'll repeat day after tomorrow. Oh, ಇದು appeal ಅಲ್ಲ madam. All these circulars challenge, all these cases are challenging
Sorry, yes,
circular.
my lord. Circular.
All right, yes. Day after tomorrow we'll hear it. So there are about 50, 74.
74.
We'll give one more, there are some.
ಕೊಡಿ
matters-
ಎಲ್ಲ.
Yes, my lord.
ಕೊಡಿ ಎಲ್ಲ.
90 matters are there. my lord.
90.
Yes, ma'am.
Give it. Yes. Give the list, Gautam. We'll do one thing. All these matters, we'll post it on 10th. Huh? Give all the list of all the matters, we'll post it on 10th. Now, what is 74?
My lord, interim order
GMCPC.
emanates from 1 of 97,
In
FPP
relation
1 of 97, my lord.
Huh?
The
This
interim
arises
order.
out of, my lord,
ಅಲ್ಲಿ ಇಬ್ರು ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ.
I'm the petitioner.
ಸರಿ ಹೇಳಿ sir. Wait, madam.
This matter arises out of, my lord, an order passed in a final decree proceeding,
GMCPC.
TMCPC.
Yes.
And the issue now involved in this case is that the respondent hearing, my lord, is claiming to be the purchaser of an undivided share of
I will hear it day after tomorrow.
All right. It takes some time because of, my lord, it takes at least about half an hour
That's
for
okay.
two reasons. That your lordships called for the record. Records are here. My lord, what has happened in this case is that at the time when the plaintiffs filed the suit, my lord, one advocate.
Day after tomorrow, I'll take it. If you want half an hour, come at 4:30. I'll take it at 4:30.
Whatever the time that.
4:30 to 5:30
Well,
we'll
I'm
finish.
seeing, my lord, your lordships are, whatever the time that
Can't
is
help
convenient.
it.
No, you
Yes.
can't help it. I understand that.
4:30
So
to-
we will wait. That is not a problem.
ಅಲ್ಲ
to
ನೀವು
wait.
wait ಮಾಡಬೇಡಿ, ಬರೋದೇ 4:30 ಬನ್ನಿ.
All right.
Yes. I'll
Today
take it.
your lordships had shown it as 3:30 list.
ಅಲ್ಲ, you come at 4:30 because 3:30 ಇಂದ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ರೀಚ್ ಆಗೋ ಅಷ್ಟೊತ್ತು 4:30 ಆಗುತ್ತೆ.
All right.
Yes.
Winner, whatever the.
Come at 4:30.
To your lordships.
Entry model ಇದೆಯಾ?
ಇದೆ.
That will
Continue
continue.
ಮಾಡೋಣ.
Yes.
Oblige.
Yes, sir. ಕರಿಬೇಡಿ. ನಾವು
Serial number 58, my lord.
58 ಏನು?
58, my lord. LR application has to be allowed, my lord.
ಆಗಿದೆ.
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಆಯ್ತಲ್ಲ 58. ಯಾಕೆ? ಕಾಲ್ಔಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
ಇಂಟರ್ಲೋಕೇಟರಿ ಕರೆದಿಲ್ಲ ಒಂದ್ ನಿಮಿಷ.
Bill number 50. Sir.
ಮೇಡಮ್ 50 ಎಲ್ಲ ಆಯ್ತಲ್ವಾ?
For the petitioner.
50 ಇಂದನಾ? ಬಿ ಗ್ರೂಪ್. 50 to 57 interim orders are there in any of the cases? They'll continue. They'll be listed on 17th. 50 to 57, 17th. Interim order subsisting would continue till the next date of hearing in any of the cases. 58,
58, my lord, the petitioner is dead, my lord. The LRs are to be brought on record. I've made my application. That will
Allowed.
kindly be allowed. Please.
LR application, madam. 58 allowed for the reasons so.
Please.
File an amended cost title.
Please.
Yes, next. 59.
My lord,
Ah.
I am the party in person, Dr. Mandal.
Hmm.
This matter is a termination simpliciter where I have been terminated.
In simpliciter,
Yeah.
you made out a case for yourself, yes. Hmm.
No, I'm just summarizing, my lord.
Yes, sir.
Because it's the end of the day. So it's a termination simpliciter in my case where I was without any cause in violation. If you can kindly, your lordship, go to the page 68 of annexer.
Day after tomorrow.
Kindly, if you can post it on Friday, my lord.
All right, Friday. Yeah, who is appearing on the other side?
And my lord, I have to submit a memo.
Aishwarya R. Who is it? Fortis Hospital.
Yes, my lord.
You're a doctor.
There are two respondents.
Why were you terminated?
There was no cause given, my lord. That's the reason. If you can kindly give a cause.
No, on what allegation or something?
No allegations, my lord.
Just like that terminated.
Just like that, one fine morning, I have even conducted 33 operations in 18 days. The list of the operations I have committed as annexure in annexure M.
What's your qualification?
I'm a cardiothoracic and vascular surgeon. I'm a fellow of the Royal College of Surgeons, Glasgow. I'm fellow of American College of Surgeons. I'm also a fellow of American College of Cardiology. If I go on, sir, I don't want to boast about my credentials. The main point is that the thing that has happened, it's a stigmatic termination without giving any, because
It's simpliciter.
because of the reason, there are two. It's like, it's
All right, we'll hear you. Let the respondents come.
and my lord, I need to give a memo. It's regarding, because the last day I had posted the case was on 19th of July 2024.
You want it on that day?
Yes, my lord.
You want it on that day?
No.
4.
24 years, my lord.
Yes.
The reasons for that I have given. You had asked me on Friday
Don't
that
worry about that. It will come on Friday.
if I can just post the memo, my lord.
Keep it. Yes. On Friday it will come.
Okay. Kindly, can you
want on
give me
Friday?
initially, like, so that I can present my mat?
Give you time at 4 o'clock on Friday. Come at 4 o'clock.
Okay, thanks, sir.
We'll hear you for
Oblate.
half an hour.
Thank you,
You
my
should
lord.
finish in that time.
Everything, my lord.
Yes.
My prayer is for reinstatement and like interim relief. I have not got my salary since September 23rd.
All that you summarize and come. We'll hear you like a physician, not a surgeon.
Okay.
Right? Yes.
Thank you, my lord.
Vacating interim order, 17th.
Interim order may be extended.
That will be vacating the 17th. Andre extend
Matter
again.
without that, they will now take away the other process that was stayed after hearing the matter.
Right. Yes, yes.
Interim order may be extended.
It will be extended. Yes.
My lord, in this matter, your lordship had directed police protection to be given. Now what they're saying is, my lord, ADLR has to give a report.
ADLR?
ADLR is a party.
ADLR.
They say, my lord, ADLR has to demarcate it. Then only we can put the compound wall.
We have issued a endorsement and we've also requested the ADLR and the Tahsildar to come and identify because.
My lord, let a date be fixed, my lord, let ADLR come.
Yavat ಮಾಡ್ತೀರಾ?
Your lordship may, within a week's.
Learned AGA Rahul Karyappa submits that the ADLR has been instructed to inspect the property and draw up a report.
Along with the Tahsildar.
Along with the Tahsildar,
Villages are clearly.
along with the Tahsildar of the jurisdiction in the light of the issue in the list. The ADLR thus, along with the Tahsildar, shall conduct a survey of the subject property on the 10th of July at 11 a.m. No separate notice need be issued to the petitioner. The petitioner shall be present at the said time on 10th of July.
My lord, as per the ADLR's report, my lord, we will, my lord, put the fencing compound.
Aden urgency 13th ಆಗ್ತೀನಿ ತಾಳೆ.
Our police protection kodala, they have burnt my
Wait,
house.
sir. The ADLR shall, the report of the ADLR shall be placed before this court on the 14th, list on 14th.
My lord, report of the ADLR is already there. They have done haddu bastu also.
But ಇನ್ಯಾಕ್ಬೇಕು ಸರ್ವೆ?
ಅವರು ಡಿಮಾರ್ಕೇಟ್ ಮಾಡ್ಬೇಕಂತ ತೋರ್ಸ್ಬೇಕಂತ.
Demarcate ಮಾಡಿ. The report of the ADLR shall, with regard to demarcation, shall be placed before the court on the 11th, list on 11th.
11th.
ಅಲ್ಲ ninth ಅದು ಮಾಡ್ಲಿ, 9th at 11 AM, 9th inspection, 11th matter.
ಅವ್ರು ಮಾಡೋದಕ್ಕೂ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಬೇಕಾಗತ್ತಲ್ಲ.
No, that
ಗವರ್ಮೆಂಟ್ ತಗೊಂತಾರೆ ಬಿಡಿ.
Government of the police, but
If necessary, along with the protection from the police, yes.
62.
ಏನು ಅಷ್ಟು contested property, ಎಲ್ಲಿದೆ?
Lord, Yelahanka, they say, my lord, it is a Gomal land. In the contempt court, my lord, the revenue department has earmarked and given us.
Yes, all right. Pasha sir, 5 minutes I'll take. Yes. Because I have to ask everybody to go out. Yes.
62.
Appear for the petitioner, my lord.
62.
On the basis of a letter written by the third respondent who is a perpetual litigant, and after he had told this court in earlier proceedings that he has no claim over any survey number excess 35, he writes a letter to the first and second respondents and they issue me notice saying that we are not releasing your layout plan.
That is why we have stayed it.
Yes, my lord, therefore, my lord, there's urgency, my lord, at least I can release the sites, they're all close to completion. I invested a lot of money.
Objection.
Or ಆಗಿದ್ದಾರೆ.
Oh, sorry. Day after tomorrow, Thursday.
Grateful. Interim order to be executed.
Interim order subsisting would continue to the disposal of the petition. Yes. Why is Renuka madam waiting?
Number 44, my lord, it's adjourned to 10th, my lord. I was
10th
not
alla.
here.
Adjourn day after
Sorry,
tomorrow.
day after tomorrow. I want it on 10th, my lord.
You want it on 10th? All right, 10th.
Sorry, my lord, I
No
was not
problem.
present.
Yes. 10th, fine.
Second
Yes.
list, the 9th matter.
Second. Sidramaya ನೋಡ್ದ?
Second list.
Passed over.
Pass over. Second list 9 pass over ಆಗಿದೆಯಾ? Consider representation.
Yes, my lord.
ನೀವಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ?
ಇದೆ. 230 we will dictate.
38D.
38.
ಆಯ್ತು, ನಾಡಿದ್ದು ಮಾಡೋಣ. List day after tomorrow. ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅದು.
75 dictating judgment, my lord, your lordship wanted the Lokayukta complaint.
ಕೊಡಿ.
Not in fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕಾನ್ಸೆಪ್ಟೇ ಇಲ್ಲ ಈಗ. ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. ಎಸ್. ಹಾ, ಅದು ಕಾರ್ಗಿಲ್ ಈಗ ಟೈಮ್ ಆಗೋಗಿದೆ. ನಾಳೆ ಅದು ಒಂದು ಇನ್ ಕ್ಯಾಮೆರಾ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ. ಟುಮಾರೋ ಆಗಲ್ಲ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Please. One submission.
Day after tomorrow at 2:30.
Please.
Why is Basaraj sir waiting? 70?
Impleading application ಏನು ಹಾಕಿದಂಗೆ ಅಂತಾರೆ.
My lord, in this matter serial
70.
70, my lord.
ನೀವು ಯಾರಿಗೆ?
While the application for impleading, we are also.
So who are you supporting?
I'm asserting myself.
No, my lord, may I make a submission in this, my lord? I had.
Are impleading applicant?
I don't know, I am just getting the knowledge now.
Yes.
I had filed an application on 18/12 before this court. I had only sought for 6 writ petitions to be connected between the
ಮತ್ತೆ
parties.
ಯಾವ್ಯಾವ ಕನೆಕ್ಟ್ ಆಗಿದೆ?
There are another 5 petitions which are being appended to
ಲಿಂಕ್
this.
ಮಾಡೋಣ ಕೊಡಿ.
Please, my
ನಮಗೂ
lord,
ಒಳ್ಳೇದೇ.
70.5.
ಒಂದ್ ನಿಮಿಷ.
Please, my lord.
ಬಸವರಾಜ್ ಸರ್, ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
70.2.
ನೀವು 70.2 ಹಾಕಿದ್ದೀರಾ?
I'm in 70.2.
ಒಂದ್ ನಿಮಿಷ. That has no connection with this?
My lord, 70.5 is to be D-link, my lord.
ಒಂದ್ ನಿಮಿಷ. ಈಗ 70 is ಓಕೆನಾ?
Okay.
70.1 ಓಕೆನಾ?
Yes, my lord.
70.2?
Okay, my lord.
70.3?
Yes, my lord.
70.4?
No, my lord.
ನೋನಾ? ಯಾಕೆ?
70.5, my lord.
70 ವಿಶ್ವನಾಥ್ ಸರ್, 70.5 ಏನಿಲ್ವಾ?
No, I'm there.
ಅಲ್ಲ, ಯು ಆರ್ ದೇರ್.
The
ಮ್ಯಾಟರ್
parties
ಲಿಂಕ್
are
ಇದೆಯಾ?
not the same.
Link with this survey number wise, my lord.
ಅಲ್ಲ, ಇಸ್ ದೇರ್, ಈ ಸರ್ವೆ ನಂಬರ್ ಇದೆ, ಬಟ್ ಇದ್ರಲ್ಲಿ ಏನು ನಾಟ್ ಕನೆಕ್ಟೆಡ್ ಟು ದಿ ಅದರ್ಸ್.
Not connected to the crime which we have argued for.
Crime ಅಲ್ಲ, crime not relates to survey number. ಅದಕ್ಕೋಸ್ಕರ.
No, ನೀವು ಕೊಟ್ಟಿದ್ದಲ್ವಾ ಲಿಸ್ಟ್ ಎಲ್ಲ?
ಹೌದು, ನಾವು ಇದ್ಯಾವ್ದು
Praveen only gave the list.
ನಾವು
Kill him, not let this.
ಆಯ್ತು, ಹೇಳಿ ಈಗ ನೆಕ್ಸ್ಟ್.
70.8, 9, 10, 11.
ಇದು ಯಾವ್ದು ಇಲ್ವಾ?
ಯಾವ್ದು ನಾವು ಮೆಮೊನಲ್ಲಿ ಯಾವ್ದು ಕೊಟ್ಟೇ ಇರಲಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ಯಾಕೆ ಬಂತಿದ್ದು?
This I only found it out the day before yesterday. One of the learned counsel said this matter is pending before Honorable Supreme Court, which none of our parties have been.
Then will dealing call this.
ಅಲ್ಲ, ಇವೆಲ್ಲ ಬೇಕು. ನಾನು ಹೇಳ್ತೀನಿ ಅಂತ. I will not take more than 10-15 minutes.
ಅಲ್ಲ, ಡೀಲಿಂಗ್ ಮಾಡೋದು ಬೇಡವಾ?
ಇಲ್ಲಿ.
ಅವರು ಬೇಡ ಅಂತಾರೆ, ಅವರು ಒಂದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇರ್ತಾರೆ.
ನಾಡಿದ್ ಮಾಡೋಣ.
Impleading application ತಪ್ಪೇ.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಬಸವರಾಜ್ ಸರ್ ಯಾರಿಗೆ? ಬಸವರಾಜ್ ಸರ್.
My lord, may kindly
ಇಂಪ್ಲೀಡಿಂಗ್
see the
ಅಪ್ಲಿಕೇಶನ್ ಯಾರಿಗೆ?
In
so far as the applicants are concerned, we have filed the application for regularization and this honorable directed the government to consider the application. And the report is submitted by the government that we are in possession of the property.
You are in possession of the property.
All the applicants. There is a report submitted by
All the impleading applicants.
Yes. Today we have filed, so we
Lord,
are.
after a period of 1 year, they are coming up before this court.
Nadit tagonti.
These writ petitions are pending from more than 2 years.
We'll see
Now,
whether
out
is
of the blue,
whether
they
is a
come and-
necessary party or not. Objection haki. ಅಯ್ಯೋ ಅದಕ್ಕೆ ಡೀಲಿಂಗ್ ಮಾಡೋಣ ಹಾಗಾದ್ರೆ. ಯಾವ್ದು ನಿಮ್ದೆಲ್ಲ ಯಾರು ಕೊಟ್ಟಿದ್ ಮತ್ತಿದೆಲ್ಲ?
Lord, my memo could be looked into on 18/12, which I filed. I have filed only for.
Yes, Prasanna Kumar sir. We'll delink all that unnecessary things. 70.5, 8, 9, 10, 11.
Please, my lord.
We'll delink and hear the other matters.
Please, my lord.
Yes. ಅದು KLR sir, ನನ್ನ jurisdiction ಇಲ್ಲ
An
ಅದಕ್ಕೆ.
allegation against us regarding crime.
Yes.
regarding that.
We'll take it day
They
after.
have argued the crime on that matter and they are trying to establish. that.
70.1 and then.
ಅದೆಲ್ಲ ಇದೆ. That is there. Only these matters. Yes.
Please.
Day after tomorrow.
Please, my lord.
The impleading application, the learned senior counsel Shreyas Basavaraj submits that the impleading application is preferred in 70.3 na Rahul Reddy.
70.2, 5559 of 2022.
5 point?
5559, 5559 of 2022.
70.2, my lord.
70.2.
70.2.
5559 ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
70.4. 70.4. Sorry, sir.
70.4, yes.
Nam-
All right, yes. The registry is directed to put up the application so filed on the next date of hearing, day after tomorrow.
My lord, the delink matters, which date would your lordship do?
D-Link will post it before the bench having roster and interim order iದ್ರೆ it will continue. Yes. ಅದು ಬರ್ಕೊಂಡ್ರ ಮೇಡಮ್? D-Link sounds, yes.
Grateful, my lord.
ನಾಡಿದ್ದು 2:30ಗೆ ತಗೊಳ್ಳಿ. Now, one request to all the councils, ನೀವಲ್ಲ, who are all sitting, will have to move out of the court hall. Some in-camera proceedings. Yes. Interim orders wherever there will exist. Don't worry about it. Yes. All. ಅವ್ರದ್ದು ಯಾಕೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ? ಬಂದಿಲ್ವ ಇವತ್ತು? ಬಂದಿದ್ಯಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು? R2. ಇನ್ನೊಂದು ಡೇಟ್ ಹೋಗಿದೆ, ಅವತ್ತು ಬನ್ನಿ. ಅದು ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು ಎಲ್ಲಾರ್ಸ್ಗೆ, ಅದು ನಿಮ್ಗೆ ಲೀಗಲಿ ಅರ್ಥ ಆಗಲ್ಲ. ಯಾರು ಎಂಗೇಜ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ ಹೋಗಿ ಅವ್ರೆ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡ್ತಾರೆ. ನೀವೇನು ಅವ್ರಿಗೆ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರ? ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ, ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಇದ್ರೆ ಅವ್ರು ಕರ್ಕೊಂಬನ್ನಿ. ಅಡ್ವೊಕೇಟ್ ಇದ್ರೆ ಕರ್ಕೊಂಬನ್ನಿ. ನೋ ದಟ್ ಐ ಕಾಂಟ್ ಸಿ. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ. ಅಡ್ವೊಕೇಟ್ ಇದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಕರ್ಕೊಂಬರ್ ಫೋನ್ ತೆಗಿತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡಿ. ಎಸ್, ಐ ಥಾಟ್ ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅಂತ. ನೋ ಅಷ್ಟೇ ಆಯ್ತು. ಗೋ ಗೆಟ್ ಯುವರ್ ಅಡ್ವೊಕೇಟ್, ಗೆಟ್ ಯುವರ್ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ಕಮ್. ಎಸ್, ಅಡ್ವೊಕೇಟ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. Why? Who are they sitting? Oh, you are, Ashok is here. Avru yaru? Live stream off ಮಾಡಿ.
ಒಂದು ನಿಮಿಷ